Good morning, good morning, good morning. It is Monday. It's April 28th. Can you believe it? Neither can I. It's day 5 of the Karen Reed case. Replay crew, you guys are the best. Remember, all the timestamps are down below. If you're just joining this case on the replay crew, don't forget to get the Law Nerd app so I can keep you in the loop when the witnesses you want to see are on the stand. That is what we built the app for. So don't forget to get the Law Nerd app. But as we get into day 5, just a quick programming note. I had band mom stuff this weekend, which entailed driving through multiple states and lots of it. So we will pick up day 4 later. Day 4, I'm going to give you the summary of day 4. There were 2 witnesses who laid foundation. One from the lab, one that was a paramedic that was on the same rig with the paramedic we saw last week that transported Karen Reed on that hold. They still haven't talked a ton about the hold that her dad called in, but it was the other person on the rig with Dan Whitley. So, we'll get to it. And then they went on a jury view. They had little opening statements of pay attention to this and pay attention to that. So we'll cover that. It's less than 2 hours of court because Friday was a half day. Today is a half day for the jury as well, but not for us. So sustenance is needed. I have caffeine. I'm going to need to grab lunch because it has been a long weekend. But sustenance will be needed because the ARCCA experts are on this afternoon doing their voir dire. So here's what I expect today. We're going to do a half day of testimony. We'll see what the Commonwealth brings. And then the jury will be excused for the day at lunchtime. And then we will do the ARCCA voir dire. What does that mean? It means that because the court found a discovery violation on the part of the defense, instead of keeping these witnesses out, the Commonwealth gets to ask them the discovery questions that they might not have had. So the Commonwealth gets to go, hey, when did you start talking to the defense? Hey, are your text messages really gone? Hey, what about this? What about that? They think they're going to do this in a half a day. I think that's adorable. We'll see what happens. So this afternoon, we will get that voir dire outside the presence of the jury. Emily, you didn't stream this weekend. No, I was offline this weekend, y'all. I was driving the car. I was listening to music with my kid. I was doing band mom stuff, and I got to go hang out with Peter Mon because I was in his neck of the woods. And I was like, Peter, are you around? And he's like, we can go to brunch. I'm like, we can go to brunch. So we did that. I did IRL things. So I know we'll pick it up later. Was it a consequential day? No. Did you miss anything? Not really. But taking a day offline or a couple days offline was needed. And letting my kid pick the playlist was fun. And then I got to pick the playlist. Thankfully, we like the same music. And then we're getting ready for Metallica. We're getting ready for Metallica this weekend. Y'all, we got real life stuff to happen. So today I'm all in. Why? Well, I have a croissant. Emily, will sugar fix it? No, but yes. I have a croissant and a cappuccino. It's going to be fine. Are you tired? Yes. All of you, what music do you listen to? Lauren, I listen to just about everything. My kid's rotation is right now really heavily 90s, early 2000s. So Linkin Park, OG Linkin Park. Let's not get into new Linkin Park. We don't have time for that discussion. So OG Linkin Park, a lot of like Sum 41, The Offspring, like just some more obscure punk that my husband really enjoys because he loves punk. So it was mostly that kind of a weekend. We did not listen to Dave Matthews once in the car. We listened to Metallica. A lot of Korn. Like Travis has just been like Korn, and then Limp Bizkit for the memes. And he's like, okay, but low key, like kind of good. Caitlin asked about the LP Jay-Z Encore. Yeah, we listened to the entire thing because I love it. So yes, that's what we were doing this weekend. We were just kind of rocking. So it was a rocking kind of a weekend. It wasn't a low key. It wasn't like a Dave kind of a weekend. It was not. There was no chill. We're getting ready for Metallica. For all of you that asked, is my son a millennial? Basically. Basically. You know what? There was one thing there was one goal as a parent. A, keep everyone alive to the best of my ability. Look, it's stressful when they start driving. Second, make sure that their taste in music doesn't suck. Like that, look, you're going to go far, kid. It's going to be fine. But if you have a great taste in music, it's going to be all good. It's going to be all good. So yeah, we had to get ready we had to do some Pantera too, because he doesn't know Pantera as much, and they're also opening for Metallica. So we had to get ready. We had to get ready. There were some there, and then we'll talk about it later. So it was a good weekend. My child is exhausted. Amanda says, former band DCI kid, those road trips were always the best. My child is so tired. He's so tired. He's like, Mom, we moved for like 10 hours. I'm like, welcome to DCI, buddy. He's like, we did ab workouts. I'm like, yeah, you're going to need it. You're going to need it. It's a good thing you're 17. Good luck, bud. You're going to be tired. He's like exhausted and excited. You know that feeling, the exhaust-sighted. So he's off to school. I'm here. Are we exhausted? We're exhausted. It's fine. We're good. It's Monday. We're going to go to court. It's all going to be good. Emily, just roll the intro. Everybody wants to go to court. Law nerds, we do. We do. Why is my soundboard not soundboarding at me? That was strange. Did you guys hear it? I didn't hear it. Huh. We're going to have to, if the soundboard's not working, I'm going to collapse. Because that's not, okay, I'm gonna figure that. I'm gonna figure that out. I'm gonna figure out what's going on, because I don't know. You guys are like, no, we didn't hear it. I didn't either. Uh-oh. If I have to reset the soundboard, I'll do it once court starts, and then I just won't be able to talk for a few minutes. It'll be fine. Let's roll the new intro. Let's pull up court and let's just go. It's a Monday. It's all gonna be fine. It's all gonna be fine. Good Lord, Emily. It's all good. Let's go. Let's go to court, law nerds. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I have no idea. We're going to go to court. Hopefully we hear court, and then I'm going to figure out what's going on with my soundboard, because I need my soundboard. I do. I love it so much. It's like the external part of my brain. All right, let's go to court for the hear ye's. Shall we? I think we should. All right. For those of you saying, oh my God, new intro, don't worry. We just rolled it out for this trial. It's all good. Let me know where you're coming in from, what you're drinking. Let's hope for some hear ye's. Do we got a face to the hear ye's? Anonymous in the chat. Anonymous. Same.
Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Sir, the closed captioning thinks you were saying draw near and give your tennis. A, pickleball these days, and B, we need to do that again. Like one more time with feeling, because I need to get the sound gained up a little bit.
All persons have any business before the Honorable Beverly Canody, Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
There we go. All right. I got to figure out why my soundboard's not soundboarding. Oh, there we go.
Right. Good morning, counsel. Good morning, Ms. Reed.
Spontaneously fixed itself.
I do have to ask you those same three questions. Were you up for, actually?
Your Honor, I stayed off the internet this weekend, too. It was
follow the instructions
great.
and refrain from discussing this case?
I went to
with
Barnes &
anyone?
Noble. I went to Sephora.
Everyone said yes and nodded affirmatively. Were you also able to follow the instructions?
I listened to an audiobook.
Independent research or investigation.
I should have done research, Your Honor. I didn't even open my laptop. And I told Team Baker I was going to do stuff. It's going to have to get done today.
On Friday?
I didn't.
Everyone said no or shook their heads.
I was in the car all day.
Social media this weekend.
I went to Buc-ee's twice.
Thank you very much.
It was great both times, because
All right.
Buc-ee's,
Mr.
it's a
Brennan?
newer Buc-ee's, too.
Good morning, Your Honor.
Good morning.
Awful call Ian Whiffin.
Okay.
Oh, right into technology. Okay. Ian,
All right, just come on up.
Mr. Alessi is like, Your Honor, we have a few betters. Look, y'all, Alessi is the tech guy. So Alessi is the one that's going to be doing this cross-examination. For those of you that did watch court on Friday, it's okay if you raise your hand. I mean, no spoilers. But for those of you that did watch court on Friday, yes, Lally did do the direct exam of a witness. We'll cover it. I will share what I got at Sephora. I got a new brow gel, and I got another one of the lip glosses I've been wearing for trial because this one's almost out. And I was like, well, it's like a lip stain oil. I was like, that if this runs out during trial, I'm gonna die. And then my eyebrow pencil was almost out, so it was refills. It was refills and wandering around, and same with Peter and I wandering through Barnes and Noble's talking about books that we loved. We had so much fun, so it was really good. We're gonna keep going. Okay, what are this? Immediately, the jurors have to be like, girls, can we do this before we come in? Can we do this before we come in? Because they're sitting there and we get to zoom. They're sitting there.
Commonwealth calls Ian Whiffin.
The Commonwealth calls Ian Whiffin. It's so dramatic. You've already called Ian Whiffin. Miss Little, the hair's herring. We love the wave. It can't be humid in Massachusetts yet. Mass folks, are you humid yet? We've got days of humid and days not. But we're getting right into tech. They're going in such a different order than they did previously. It's really interesting to see how the Commonwealth's putting this case in evidence this time.
May I, Your Honor?
Yes, please.
We'll talk
Good morning,
about that at the
sir.
break.
Good morning.
Would you kindly introduce yourself to the jury?
Good God!
Yes, my name is Ian Whiffin. I'm a digital forensics examiner and decoding product manager for Cellebrite.
We'll just do
You
those.
just mentioned Cellebrite. Is that where you work?
It is, yes.
And you're a forensic
Why does it sound like he is screaming across the Grand Canyon to talk to this witness? Y'all. Is the AC on in court again? Because last trial, the judge yelled at everybody to speak up a million times. Maybe Brennan's just trying to make sure the court's not yelling, speak up at them. I don't know. Is a fan on? Is it loud?
examiner.
I am.
Can you tell us a little bit about Cellebrite, where you work?
Yes,
Accents. New England versus England. I might take a poll on that later. No offense, New Englanders.
Cellebrite provides digital forensic solutions to
It's like
customers
OG
globally
versus new school.
for access and decoding of digital artifacts from devices.
Where would you find a digital system? Is that designed to a phone, or is it all systems?
Typically, Cellebrite
My coffee maker is a digital system at this
or
point.
iPads, but we do have some additional devices that we can also
Yes.
integrate computers, vehicles,
He-
things like that.
So
Testified last
simply,
trial.
what is Cellebrite?
Cellebrite is a digital intelligence company.
Oh, thank you, Judy. Everybody's
Do they
like, Emily,
use
no, it's a
certain type of
Scottish accent.
software?
What's
Do they
wrong with
brand
you?
A certain
Fair.
type of software?
Yeah, we create our own software to access devices
That's
and to
fair.
decode the data that we pull from devices.
So essentially, does that software help you look into the data on the phone and analyze it?
It does, yes.
I know.
What is
All of
the
you in
role of the
Massachusetts,
digital
there's lots of different
forensic
accents around
analyst?
Mass.
Typically, the analyst would take the data that's been extracted from a device, such as a cell phone, process that in software such as a physical
Some of you are
analyzer
saying not
that
Scottish,
Cellebrite create,
Northern England.
and use that information to filter, to search, and to create a report for the
Fair
investigator
enough.
that would allow them to see what happened on
I
the
read
device
one thing out of the
at
chat.
the time being investigated.
How long
And
have you
I'm-
been involved
I'm
in
just dying.
analyzing data, sir?
I started my career in digital forensics in 2013.
Can you take us back to the beginning of your career?
Ian
and tell
Whiffin,
us a little
nobody
bit
wants to
about how
dox you.
became
They just want to know where your
involved in
address is
learning
from. We're
about
really not
analyzing
trying to figure
data?
out where you live.
Certainly. I spent 5 years as a frontline police officer in the UK during the 2000s. In 2009, emigrated to Canada and continued policing frontline officer in Calgary.
Well, sir, this doesn't help us at all. He's like, well, I'm kind of Canadian. He's like, we're a part of the Commonwealth, different Commonwealth, but we're a part of the Commonwealth.
Before joining the digital forensics team in 2013, pursued several qualifications related to digital forensics.
Sir, how
and
do you
just
feel about
continued in that
all-dressed
role
chips?
until 2019, 2020, when I left the police agency
this coffee is
and began
good.
working for Cellebrite.
Thank God.
While you were working
The
at
coffee
the
is
police
good this
agency and
morning.
began your career analyzing data, were there special classes that you took?
There were. In order to be a forensics examiner in Canada, you have to take
All of you
a
are like
3-week
North
foundational
England.
course.
Fair enough. Northern
in
England.
Ottawa, basically covering the basics of digital forensics. And then from there, other courses are available that would focus on things like cell phones, would focus on how to get data from different types of
the coffee's
devices.
coffee.
And then there's industry qualifications that can be sought as well, where you can focus on particular types of device or particular types of data.
Does software in this field continually change?
It does.
No.
Every time an update is released to an application or to an operating system, there's the opportunity for the foundation
What
of that
happens-
software to change. And from
what
a
are we
forensics
doing?
point of view, you have to re-understand what has
screen is
changed,
just
make sure
resizing
you understand
itself
what is
sua
now
sponte.
happening on that device, and provide that information to the users.
As you've progressed through the field, do you continue to take classes?
I've not taken a class now since I actually joined Cellebrite and did the basic foundational courses that Cellebrite offer. But prior to that, I was doing courses across the
It's like
industry.
I teach the
Do
courses
you
now.
teach courses?
I do teach webinars. I don't teach any actual courses, although some of my research and some of my tools are taught to examiners in many of the industry standard qualifications which users seek.
Do you ever write papers about the subject that are published?
I do. So I have a blog where I publish my research. Sometimes some of those become papers which get peer-reviewed and distributed in more academic channels.
So when one of your papers is
I'm
peer
interested,
reviewed,
we're
can you
getting
tell us
into
what that
this.
means?
Yeah, essentially,
Early.
other forensics examiners would read over the
Odd to
paper
me.
that I've written, do their own testing, compare their testing and research to what I've conducted, and make sure that what I've said is consistent with their findings. And presuming that what they find is the same as what I found, then they would agree that it's a valid document and it gets shared.
Take us now to Cellebrite. When you began working at Cellebrite, what did you do?
When I started there, I was considered the senior digital intelligence analyst. My role was to help the developers of the software understand the role of a digital forensics examiner, what an examiner needs from the tool, what an
He was
examiner
like,
wants
I
to do with the
talk
tool,
to the
and how they want to use it.
people so
And then
that the
since then, I've
engineers don't
progressed to
have
the
to.
decoding product manager, where
Engineers
I
don't
can,
talk to people.
manage the backlog of software applications that we support, decide how we should
I'm
support those
waiting
applications,
for that movie
and
reference
how that information should look to
wander its way
users.
into the chat.
Do you do research?
I do still do research, yes. It's not my primary function within Cellebrite, but it's something that I've continued to do throughout my career.
Have you ever done any
Thank you,
programming?
Lawnards. I feel so.
Yes, again, I'm not an official programmer with Cellebrite, but I do program as well, and I have several tools which I've written myself for the last few years.
Ian, it's
since
giving
around
programming is
2015.
my passion.
Tools that I wrote to do the things that the vendor tools didn't do, and to offer examiners things that the vendor tools didn't offer. And I continue to maintain those tools as a learning opportunity for myself, and also because other examiners can make use of these same features.
Mr. Whiffin, have you ever testified in courts regarding forensic examination of
Yeah,
data?
in this
I
one.
have, yes.
And can you
last
share a
year.
little bit about that?
I've been qualified as an expert in Canada, Australia, the UK, in total around 20 times.
I want you to take us now to the Cellebrite software. We talked a little bit about it. I don't want to go into too much detail.
That went
but can you
much
help us
faster than it did
explain
last time.
How software
works-
works like Cellebrite software.
He works
Yes.
for
So
Cellebrite,
fundamentally, when
the
we've
company
got
that makes
data from a device,
the program.
it's a series of files, a series of databases, property lists, all manner of different structured data. The software that we create knows where these files exist.
Sir, you created
knows
an
how to read these
international
files
incident in the
and
chat
what the
because I
data inside
errantly
them
read a
means,
comment.
and provides a clear view for the user to view that data.
We're gonna
As an
go
example,
back to my England
if you were
versus
to
New
look
England
at the
joke.
SMS
Leave it.
database on a device, all you would see is a long list of messages that don't really have an easy way to interpret or to read them. Our software takes that information, converts it into a conversational view so that as a user you can read the data, you can see who sent what message, what time it was sent. We can do decoding and decryption of various different types of security to give the user as much information as possible.
Is there other software available in addition to Cellebrite?
There is. There's multiple vendor-supplied tools and multiple tools available that are maintained by users in the community, like myself.
Does a forensic examiner, should they rely simply on the software program, or is there more to do other than the program itself?
The software program is great at finding the data and displaying the data, but I always maintain it's the role of the examiner to actually understand what that data means and provide context and validation for what that data means, making sure that the end user of the report, whether that's the investigator, a judge or a jury, can understand what that data actually means rather than just taking it at face value from the software.
Can you say tell
Does the
Longshanks
software
Colin is
create a
free?
report that you can
Emily, stop it. It's going to be a long day. Yes, we're just trying to compare. I appreciate that you can tell the direction. His testimony so far is very explainer based of we try to help people so they don't interpret our data wrong. Because that's what the Commonwealth is going to be arguing, is that the other examiners are interpreting the data from Cellebrite incorrectly. And he's there to explain, look, our job is to make sure that our information is interpreted correctly. I imagine they'll get into the fact that Cellebrite has changed the way they display some of their information to prevent that from happening.
look at that manages or arranges some of the data that you can see?
It does. It just creates a list of all of the results that the examiner wants to include in the report.
So the software can produce a report, but the examiner goes beyond the report and looks into the data itself?
The examiner can and should go beyond what the program provides.
Let's turn now to your involvement in this case.
Even though Brennan is yelling,
Can you share
or it
with us
sounds
when
like
you
it to
first
us,
became aware of
I appreciate how linear it
the
is.
data in this case and how that came about?
Yes, it was actually one of the public relations managers at Cellebrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp.
What?
And requested if we could.
One of the Cellebrite public relations managers was doing what? Reading Reddit and was like, hey, yo, we got a problem. What? For those of you asking in the chat, like Judy F and others, I thought today was ARCCA Day, half day. ARCCA Day is at the afternoon. ARCCA Day is at the afternoon. Wait a second.
Look into it and find out.
Cellebrite itself, like, just parachuted into this case. This is new information. Their PR manager was like, hey, can we get the tea? What?
Itself?
I backed up.
We had to go beyond what the program provides.
We backed up in time. I needed to hear that again.
Let's turn now to your involvement in this case. Can you share with us when you first became aware of the data in this case and how that came about?
Yes, it was actually one of the public relations managers at Cellebrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp and requested if we could look into it and find out what the confusion was and how we could respond to it. At that point, I contacted the investigators to get more details.
What?
Did you learn that a consumer had called about a question relative to a report produced by the software?
Yes, there was both the troopers who had requested information about this particular artifact and also a private forensics examiner, Richard Green.
Wait,
Richard
when
Green
did
reached
they...
out to your company?
So did you hear about it first from the PR person and then you called law enforcement, or did law enforcement call you at the same time? What is happening?
What specifically was the question or issue?
He reached out to the tech support team asking basically there's a timestamp that doesn't make sense. I need to understand what this timestamp means.
What is a timestamp?
Essentially, it is the time which is attributed to an artifact. So it should intentionally be when something happened on that device, we would show a timestamp associated to it.
Oh,
Can you tell us what an artifact is?
An artifact would be any piece of data that we pull from that device. So it could be a text message, it could be a location point, it could be a photograph.
So if I had photographs on my phone, would
You must say, look at this photograph. That's all.
each photograph be considered an
it.
artifact?
It would, yes.
Would the
That's what
date
you
and
have to
time I
say.
took the photograph be considered an artifact?
I'd consider that a property of the artifact.
And if I had a phone call or a text message, those would be considered artifacts?
It's
Yes.
too early for
When I
this.
look at my phone and I see a call log or a name, does that tell me all the information about that call?
When you look on the phone itself?
Yes.
No, there's usually a lot more information in the background of the phone that's available to the forensics examiner, which the user wouldn't necessarily see on the device.
And so when you're looking
Yeah,
at
I'm not caffeinated
an
enough for
artifact,
this.
a phone call, a text message, whatever it may be, and you see it on a report, if you want to know more detail, where it came from, when it was developed, when it started, is that what a forensic examiner would do, to look into the data to try to identify that other information?
Yes, you can see what other information is available. You can see if there's any information that's been deleted that can be recovered. And you can validate the information that's there and make sure that the timestamps are being interpreted correctly and that they mean what you think they mean.
You told us you got a call from a consumer or a forensic examiner.
No.
Richard Green,
Can we go back to
about a
PR
timestamp.
calling him, please? Alessi, save
What
us.
type of timestamp? For what type of artifact was this timestamp?
I need to know more.
It was related to an internet query.
And so there was an internet query on a phone that had a timestamp, and this gentleman, Mr. Green,
That's
had a question
leading
about it.
and
He did. He
compound.
wanted to know how accurate the timestamp was in relation to when the internet query was made.
Did you look into the question, the query that was made?
In response to Richard Green, at that time, I didn't. I wasn't aware that Richard Green had made this request until several months later. But it was an almost identical question that had been asked by the troopers here. And that's the question that I was able to look into and to answer.
And can you share with us what was the
So they didn't
issue?
even
What
tell
was
you.
the question that you were actually looking into?
The question was related to a timestamp of 2:27:40 a.m. And an internet query that appeared to have occurred at that time. There was no other information on the device that suggested that that internet query had occurred at that time. So we wanted to know how relevant is that timestamp to when the query happened. So I was able to take test devices, recreate test data to find out exactly what this timestamp meant, and discovered that it was actually the timestamp that the tab within the browser was brought into focus and had no relevance to when the actual web query had been made.
And so after you looked into the issue and came to a determination or opinion, did you reach back out to Mr. Green?
Eventually, yes, I did. After I provided information to the troopers, I wrote a blog that covered this information because there was another examiner in Europe.
What did you just say to me? What did you just say to me? What did you just say to me? Not a report? Not, sir. Was there also a report? Was there also a report? Or just a blog? Fucking Monday.
Who had a very similar question.
I wrote a blog about it because this was a problem that was probleming.
Or opinion?
I backed up a little bit.
Did you reach back out to Mr. Green?
Doodly-doot. I feel like I need to tell
Eventually,
you I
yes,
backed
did.
up.
After I provided
After I
information
plugged
to
it.
the troopers, I wrote a blog that covered this information because there was another examiner in Europe who had a very similar question, and I realized that this is a relatively common point of confusion. And then eventually I reached out to Richard Green, offering to speak to him about this issue and clear up any confusion, but never received a response.
Well, you had
So to
written the blog
summarize, there was
already.
an inquiry about a phone that made a Google or a internet search, and the question is, what time was that search made?
Correct.
And relative to that inquiry,
Was there a report?
there was a timestamp on some of the data that said 2:27 a.m.
Correct.
Sustained.
So at some point, did you have an opportunity to forensically examine a telephone that was attributed to a person by the name of Jennifer McCabe?
I did have the opportunity to look at the data that was extracted from that device. I never saw the device itself.
And putting that aside for a second, secondly, were you asked to look at any other phone?
Chad, I see lots of questions, so I'm going to pause real quick to answer them. Who is Richard Green? The defense or one of the defense tech experts. So the defense tech expert will testify later. That's who was going through this. I can fill that in because I know that now because we watched the last trial. So I am trying to not give spoilers, but clarification when we need it. The jury is sitting there being like, okay, but who's Richard Green? I don't even know if the defense mentioned Richard Green in their opening. I don't know if they mentioned him by name or if the jury would even remember at this point. You know who the jury remembers by name at this point? Jen McCabe. So the fact that they got back to, so a search by Jen McCabe, the jury's like, what now? What now? That's the name that the jury is going to remember. All the rest of this, the jury's not going to remember. The jury's not going to remember. And it's hard because they don't have context for this yet. So the jury's like, okay, so you talked to somebody, but somebody else. And all right. So the jury, if y'all are sitting there confused, yes. But why does it matter? Here's why I suspect the Commonwealth is doing this now. Because before they see anything else, the Commonwealth is putting in the information before the jury that this was all just a big confusion because they didn't understand the way the software printed it out. And in fact, the software changed the way they worked to forestall this confusion. So before that information even comes in, before this even gets any further into Jen McCabe, the jury has the information that the people that run the company are saying, yeah, this is all a point of confusion. People don't understand it, and we're explaining it. We'll see how cross-examination goes, but that's why I think they're doing it in this order, because then the jury is checking everything against this expert before Jen McCabe gets up on the stand. So they're answering the question before it's even asked. It's a solid strategic order for the Commonwealth. We'll see how cross-examination with Alessi goes.
To examine data in this case, aside from the phone attributed to Jennifer McCabe?
Yes, I was also sent the extraction of data from John O'Keefe's phone.
Did you look through the data and analyze some of the data in John O'Keefe's phone?
I did, yes.
So I want to walk through both your analysis of Jennifer McCabe's phone, but also of John O'Keefe's phone. So if we can first start with Ms. McCabe's phone.
Yes.
Yeah, that's the name the jury remembers.
Did you actually receive her phone?
He just said that.
No, it was just a download of the.
He said he only got the extraction, but never
So how
saw the
does that
physical
work?
phone.
The examiners here had done the extraction of the device, resulted in a large zip file, which is a container containing all of the files extracted from the phone. They uploaded it to Cellebrite's secure portal, where I was able to download it and verify what the data was in the extraction.
When you received the download of the extraction for Jennifer McCabe's phone, was it a similar process for John O'Keefe's phone?
With John O'Keefe's phone, I actually received the data on a USB thumb drive through the mail.
So no, not the same process.
And before we begin, can you summarize briefly the issue, what you were looking for, and what the scope was as far as Jennifer McCabe's
Which
phone?
issue?
For Jennifer McCabe's phone, it was related to the internet search that occurred, or that allegedly occurred at 2:27:40.
And as part of your effort and analysis, did you put together a PowerPoint that would help educate us on how a timestamp works and what happened in this case?
He did a
search?
live
I did, yes.
demonstration last time,
Have you
didn't he?
seen that PowerPoint recently?
I did, yes.
Oh boy, a
Madam Approach, Your
PowerPoint.
Honor?
Yes.
I can eat breakfast. It's interesting bringing in this information before this issue is like scandalous to the jury.
That should take a look in, do you know, or do you recognize within that binder?
Yes, this is the PowerPoint presentation I created related to Jen's phone.
And with that presentation, do you have it downloaded on your computer?
I do, yes.
I'd like to introduce this as the next exhibit, please.
No objection, Your Honor.
All right, thank you.
You know, with the court's permission, I'd ask Mr. Whiffin to be able to use his computer to walk us through the PowerPoint and explain it to the jury.
No objection, Your Honor.
Yes, thank you, Mr. Whiffin.
Okay.
All right. We're going to walk through this PowerPoint. I'm going to croissant instead of snark because I'm hungry.
May we begin, Your Honor?
Yes.
Neither of my cats are barking.
Walk us through and explain
not
the
here.
PowerPoint and explain this issue to the jury, what the
If they start chirping at the birds,
question
though,
was
I'll let them know.
and how you resolved it.
Of course. Okay. The query revolved around a database called browserstate.db. Browserstate stores information about
to the wall
Safari,
files.
Internet browser, and about the tabs that the user has either had open or has open.
I'm going to try to move
Fundamentally,
me
in
out
this
of the way.
presentation, I wanted to include information from iOS 14.
I'm just trying to move the closed captioning so all of you watching on TV, you don't get them covered by chat. I'm trying to move me out of the way because the PowerPoint information tends to be at the bottom.
And earlier.
So there we go.
iOS 14 is not the version of iOS that was on Jen McCabe's phone, but iOS 14 has an easier way to understand how this database works. And then I can move on to iOS 15, which was the device or was the version installed on Jen McCabe's phone. And hopefully by that point, it will be clearer how this information is being populated on the
Emily,
device.
rude.
Could you tell us what iOS means?
iOS is Apple's proprietary operating system available on iPhones.
Thank you.
I appreciate that Brennan does break it down better than Lolly and the questions are smoother.
The browserstate.db
It is easier.
Tabs table is shown, hopefully I can show this on here, in the top here. The real database has many more fields, but these are the fields which are important for the demonstration to just see the row ID, the timestamp that's recorded, the URL or the web address, and the title
Everyone
of
making
the page.
PowerPoints, can you stop
And the example at the side there, you can
from
see.
your girl? Look, I know most people, the bright white background does not hurt their brains. But if there are two people in the jury who the bright white background hurts their brains, they're going to be pissed. Can we just start making PowerPoints on backgrounds that are not bright white? Can we just? That's it. That's my, like, I'm already just like, oh my God, it's so bright. Can we just?
See, there's the browser is open, but there is no tab actually in focus at this time.
Make myself small.
Can I take us just a little bit back so we can put this in context?
Yes.
When you are doing internet searches on your phone and you hit Safari or Google or
All
whatever
of the
search
dark-
engine you're going to
all
use,
of the dark
does
mode.
it create a tab?
It doesn't create a tab just by opening the application, but there may be tabs already open in the background when you start the application, and then you can
how many
tell it
tabs
to
do y'all
create
have
further
open?
tabs.
Because
So if I have a phone, can I have a number
Tell
of
you
different
what.
tabs on my phone at the same time if I've searched for different things?
yeah, this would
throughout
hurt
the
my
day?
eyes in
Correct. You can have
person.
hundreds of tabs open.
Do tabs stay open forever or can you close them?
They stay open until you close them.
So if you look at your phone and you have a number of different tabs, and say, for example, I start with one tab, I'm looking for the local football score. Can I reuse that same tab for some other search, or do I have to use a new tab to start a new search?
You could
questions.
use that tab for as long as you wanted, or create a new tab to do additional searches while maintaining the original tab in its current state.
And so what you're trying to demonstrate to the jury is identifying a time on one of these tabs where a particular search was made.
Objection, Your Honor.
Sustained as to full.
Could you explain this demonstration as it relates to tabs on these internet searches? What are we actually trying to learn?
I appreciate that
As I
Alessi
showed,
uses
there's
his
a
objections
field in this table called timestamp.
surgically.
It's actually called last viewed timestamp. I wanted to prove or to demonstrate what that timestamp means, how that timestamp gets populated, and how it's relevant or irrelevant to a case.
So if I have one or many tabs open on my phone, each tab will have its own timestamp?
Correct.
And the URL, that's whatever I look up, what I search on the search engine?
Objection, Your Honor.
I'll allow that. Is that what's looked at?
That's correct. The URL is the address of the page that's being viewed.
So if I have a tab open and I use it
Like
continuously,
www.lawnerdalert.com.
3, 4, 5, 10 times,
www.lawnerd.app.com. Those would be like URLs.
will the time
Just saying.
stamp change?
No, it will not.
And is that what you're explaining to us now?
Correct. That's part of the demonstration and presentation.
I'm sorry to interrupt.
Okay. So in this instance, at 10 a.m., which is shown in the top of the device there, we can see I visit firstpage.com as an example website. At that time, a row is created in the database that shows row ID 1 with the timestamp 10 a.m. when the page was opened. The URL and the title are relevant to the page that was visited, so firstpage.com. A minute later, excuse me, I now use the same tab to visit secondpage.com. What actually happens in the database at this point in time is the first record is updated with new information. So we continue to see row ID 1. We continue to see the timestamp that the tab was opened at 10 a.m. And we now see the URL and the title that are related to the secondpage.com website. So I've shown it here. The first one is red to show that's no longer a live record. It's been replaced by the new record that's underneath it in black. A minute later again, I can visit thirdpage.com. And at that point, the record's updated a further time. So we still see that it's row ID 1, because no new rows are being created. We're just simply updating the existing rows. So we still have row ID 1, we still have 10 a.m. as the timestamp, and we have the URL and the title that show thirdpage.com instead.
Mr. Whiffin, so in the URL column, there are 3 different searches?
Yes, this is 3 different pages that have been visited within the same tab.
And in the data, it has 3 timestamps, but they're all the same.
Correct.
Okay, thank you.
This database is not monitoring web navigation events. It's purely monitoring the tab events. So when the tab's brought into focus or when the tab's created is the only timestamp that's relevant here.
Thank you.
From a non-forensic point of view, if I was looking at this database in a regular database viewing tool, all I would see is the black record at the bottom. I wouldn't see the other 2 records because they've been essentially overwritten by the third record. If I was to use a forensic tool, though, then I would see all of these records because the forensic tool is designed to find the older versions of these records that have been replaced. So again, from a forensic point of view, I would see all of these records, I would see all the different URLs, and I would see the same timestamp and the same row ID for all of them. This fundamentally changed in iOS 15, and I've tested this on multiple versions of iOS 15, 16, 17, and 18, including iOS 15.2.1, which is the same version of iOS installed on Jen McCabe's phone. In this case, the data is not written to the database immediately. So I've tried to show here that we have some in-memory variables, so essentially a short-term memory that
I know the jury doesn't have any context for all of this. If y'all are like,
aren't written to the database yet, so they're not written long-term. So in this case, if at 10 a.m.
the prosecution wants to be able to argue this in closing.
We see that
That's why they're giving the
variable,
example now.
timestamp, URL, and title are updated to show a 10 a.m. timestamp and the first page .com information. But you can see at the bottom, I still have the browser state tabs table, and nothing has been written to that database at this time.
Notice they haven't
So
talked
can I
about the
ask you a
language of the
question
search
about
not once.
this
They talked about the
browser
time
state
only. They have not said what the search
What does
is.
that mean? What does that tell us?
The browser state.db is just the name of the database that Apple are using to monitor the tab activity on the device.
Will a cell phone have a number of different databases it will send information to, or is it all one database?
There are hundreds or thousands of databases, depending on what applications are installed on the device. Each database typically targets a different application or a different feature.
Can information from a URL or a Google search or a Safari search, can it leave data on different databases, or does it always go to one database?
It can leave on different databases, for sure.
Thank you.
So again, to continue this example, if I now go to secondpage.com a minute later, we can see that now the in-memory variable is updated. So the timestamp still remains 10 a.m., the same as it did previously on iOS 14, but the URL and the title are updated to reflect the current web page that's being viewed.
And now that Brennan has
nothing
stopped
has been
yelling,
written
it's
to
easier to listen to.
The browser state database.
But it's hard to have
I can go
context
to
for it.
thirdpage.com. Again, we see the in-memory variables for the URL and the title are updated, but the timestamp still remains the time that this tab was brought into focus or created, not the time that the navigational event occurred. Still, nothing's been written to the browser state database, and it's not until you actually close the tab that the information gets removed from the in-memory variables and written into the database. And at that point, the information written to the database is whatever was in the in-memory variable. So right now, all we have is a single record in the database that shows
tabs.
the 10 a.m. timestamp. That's when the tab was opened. And we have the thirdpage.com URL and title
Wonderful.
information, which is
Good
the
job,
most
Em.
recent web page visited in that tab.
On the computer, there's only like 4,
It wouldn't matter whether I
though.
was looking at this data using a regular database tool or a forensic database tool. The only record that I will see is this particular record. There may be multiple versions of this record, but still would
Thank you,
only
Tab, for
show
letting
me
me
this timestamp
letting
and
me
this
know
URL
what tabs you have
information,
open.
because this is the only information that was ever committed to the database.
Yes, Chad, 169 tabs on my phone. Look, at the bottom it says
Moving on from that,
169
there was,
tabs.
multiple databases
That's just
or
what it
multiple data
is. I'm not
sources
closing
on
one
Jen
now.
McCabe's phone that could be used to see what actually happened on the device at this time of day that was of interest. So the analysis I did looked at the browser state database that we've just described,
will
the
show you.
history database, which is what is tracking the navigational events.
Says
So
at the
every time
bottom,
you visit a website
169.
and the website fully loads, it gets written to the history database to say this URL was visited at this time.
Also, no, I'm not showing you the page with all my tabs open. You will see that I open tabs to check the spelling of words, to see what my kid's summer schedule is. That's why we showed you the other way. 160. There's too many tabs related to Pokemon Sleep.
And that's
Pokemon
the information
Go.
that, as a user, you can see. When you look at the internet history in your device, it will list all of the web pages that have been visited.
And this weekend's project, which was reorganizing my focus
com.apple
modes on my
mobile
iPhone.
safari.plist
It's fun.
is a property list file, so essentially a list of values and information, keys and values that would describe various settings on the device typically. But it also stores information such as the last searches that were conducted using the Safari search feature. And then finally here we've got knowledgec.db, which is a massive database at the heart of iOS that stores lots of types of information. It can tell you what web page was actually on the screen at any given time. It can tell you when the backlight came on, when the backlight went off, when the device was locked or unlocked, the battery level.
We learned that in the Murdoch
lots of
case
different
about
types of
when the light
information.
goes on and off.
But useful here for the web pages that were being viewed.
Like if you throw it, will it?
So using the combination of all those sources, I could see that at 2:27:29 a.m.,
I do need the
Safari was
tabs.
opened
They're my external
from
memory.
the application library on the device. At 2:27:29 a.m., when Safari opened, there was already
This I wanted to
numerous
see.
tabs open in the background.
Error code. Why is it?
The browser would show in the foreground whatever browser tab was opened when Safari was previously minimized. In this case, we can see, looking at knowledgec.db,
the Hockamock Sports of
the
it all.
web page that was being viewed was related to Hockamock Sports, Friday's schedule scoreboard. At around 2:27:30, that tab would have been closed. Now, we don't actually have a time that the tab was closed, but based on other activity, this timestamp can be inferred. But essentially, when this tab was closed, a record is created in
I
the
don't want to talk over this because this part is going to get important. But like 4 of you all asked around the same time, and Deborah, I saw it from you as well, in a good way. Isn't it more important what the search was for? Not to the Commonwealth. To the Commonwealth, it's more important to say, at this time, this is what was going on. So I'm going to try to move the closed captioning so they're not covering the example. So for the Commonwealth, it's more important to say, look, at this time, this is what's happening. And then later this search happened. And that's why it showed up that way on the report. And we're the company, trust us, and the other experts don't know, et cetera. So it's more important to them to not reaffirm to the jury what the search was for. So they're going to call it like the 227 search or the 22740 search so that the jury's not hearing house long hypothermia over and over. We'll get to that more, I'm sure, in cross-examination. What the prosecution, I think, wants to do is have the jury sitting there going, okay, so that search wasn't done at 227, and then move on. And then later when the defense makes a bigger deal out of it, the hope is that the jury is already like, okay, but we understand that search wasn't made at that time. So continue on. We'll see how effective that is. We'll see how cross-examination goes. But for the Commonwealth, the time is more important than what the search is. And they're not going to keep reiterating the search. Alessi is going to bring it up. We'll keep count of how many times, by we, I mean y'all, we'll keep track of how many times Alessi talks about what the search is versus the time. The Commonwealth is going to refer to it as the time. So hopefully that helps. Let's continue through his presentation.
The browser state database that shows the timestamp 1:59:44 a.m. That would have been the tab at the time that the tab took focus. And then the Hockomock Sports Friday schedule scoreboard URL. At 2:27:31, there was a browser switch occurred, and the last visited timestamp that's held in memory would have taken the time that this occurred, so 2:27:31. This URL was PayPal. There was no navigational event listed in history, so this wasn't a page that was visited from a bookmark or from typing in a URL. It was whatever was currently shown in that tab when the tab was brought into focus. And we know that this exact URL was last visited at 7:40 a.m. on the 28th of January. This is evidenced in browser state and in knowledge C. Around a second later, that tab gets closed.
The jury's not with you any longer,
and that record
sir.
gets written to the database with a time of 2:27:31, because that's the time the tab was brought back into focus. It gets written with the URL and the title information related to PayPal. At 2:27:33, another tab is brought into focus from the background. This one related to Eastern Bank. Again, the last visited timestamp would be updated because this tab has now been brought into focus, causing the timestamp to change. We know that this particular website was visited at 8:02 on the 27th of January, and there's no new navigational events at this time. So we know it's just brought into focus and visible on screen according to Knowledge C and browser state databases. That tab gets closed and it gets written to the database. This again is going to show, and I've just noticed there's a typo.
So my takeaway is leave all your tabs open forever
correctly.
and nothing gets written to the database. That's my
But essentially,
takeaway.
it's closed around this time.
Probably wrong, but
And the Eastern Bank URL is written to the browser state database with the 2:27:33 timestamp. At 2:27:35, we see that there's a YouTube video shown on screen related to It's Raining Men. This shows in Knowledge C. There's no new navigational event for it, but there's also no timestamp in the browser state database at this point. This is because this page is actually, or this tab is brought back into focus a second time, and that when it gets brought into focus the second time, the timestamp that's attributed to it overwrites the timestamp that would have been written at this point. Sounds convoluted, but essentially, if you imagine that the in-memory timestamp here would have said 2:27:35, but then there's another tab that's
for all of you, like, what the fuck is with It's Raining Men? I'm not going to spoil it. It'll come up. We're going to have to wait.
Mr. Whiffin, can I ask you a couple questions?
Yes.
No, it'll come up. It'll come up. The jury's sitting there going, what the fuck, It's Raining Men? It'll come up.
Does that indicate the time when this tab was actually opened?
Yes. The time that the tab was brought into focus or opened.
What does it mean brought into focus?
If you imagine you could have 5 or 6 or however many tabs in the background, you select one of those tabs to view, it makes it full screen, that would be considered in focus, and that would cause the timestamp to be updated.
So if someone had an open tab that had a timestamp,
Just one?
and then they put it in the background to look at a different tab, but then went back to an earlier tab and opened it, would it create a new timestamp?
It would update the timestamp.
If somebody had an open tab and they didn't put it in the background, but they used other functions or shut off the phone, and when they came back, that tab was still open, would that create a new timestamp?
As long as Safari doesn't close, then the timestamp will remain the same. So if I just minimize Safari, put it into the background and start to do other things on my phone.
But what happens when Safari closes? Because I close Safari
If
all
I
the time.
completely close Safari or turn the
Yeah,
phone
I
off,
swipe out of Safari
when
all the
Safari
time.
reloads, then that tab does get a new timestamp when it opens up again.
All of them? Like,
Thank you.
What if there's like 169 of them? Do they all get a new timestamp? Because I close
At
Safari all the time.
227.36, we've got Hockomock Sports, Gallery
I don't
Shoots,
close the
Canton
tabs.
Girls, basketball to important win at Mansfield, is the page that is visible on screen. Again, we know that there's no navigational event at this time, so the page is not being loaded as a result of a bookmark or typing the URL in. It's just showing what was on screen previously, and we know that this page was previously viewed at 22:55 on the 27th of January.
But then why did it record at
This tab gets
227?
closed and gets written to the database as well, and we see it's written with the
was
timestamp
Safari closed
227.36
in the
when
morning?
the tab was brought into focus. And then we go back to the YouTube video tab. So at this point, the timestamp that had been written there gets overwritten again with 227.38, and it shows the YouTube video is the active page that's on the screen. At around 227.
Also,
39.
not the YouTube app?
That
I
tab
have
gets
questions.
closed and the record is written to the database showing a timestamp of 227.38 when the tab took focus and the YouTube video URL. Then we move to 227.40, which was the time of interest. And we see that a browser switch occurs, causing the last visited timestamp to take on the time of 227.40. This is the tab that was ultimately used to search.
That's not you. That's court.
At this point in time, there is
I don't know
no
what happened.
navigational
That
events
wasn't you.
recorded anywhere. All we see is that the web page that was brought into view is ozonebasketball.com/teams. This web page was last visited at 14 minutes after midnight on the 26th of January. We know that this is on screen because it tells us that in Knowledge C, and we know that the time is 227.40 based on Knowledge C timestamps and based on the browser state database timestamp. At 227.42, there is a web navigation event. Whether this is loaded from a bookmark or whether it's typed in, I can't say, but a web navigation event occurs using the same tab that's just been loaded. And now the user is loading the web page hockomocksports.com/standings. This is logged in the history database that shows what web page is visited when, and it also shows in the Knowledge C database to show what web page is on screen at this time.
Mr. Whiffin, in the slide before 227.40, you mentioned that was the tab in question.
Yes.
Do the following pages that you show us in the PowerPoint follow that one specific tab?
Yes.
Thank you.
So at 227.47, there's another web navigation event as the web page hockomocksports.com/schedules is loaded. Again, this is evidenced in the history database to show that a navigation event occurred and completed, and in Knowledge C to show that this is the web page that was viewable on screen. At 227.53, there's a further web navigation event where we're now now loading the page hockomocksports.com/schedules/girls hockey. Again, this is evidenced in the history database and the Knowledge C database to show what page loaded and what page was visible on screen. At 227.58, there's a further navigational event for girls hockey Franklin 21-22. Again, this is logged as a navigational event in the history database and shown on screen according to the Knowledge C database.
So I understand these are all subsequent searches on the same open tab.
Correct.
Are these
Sustained is to full.
Are these?
all subsequent searches on the same single open tab?
There is no tab switch event listed. We see the tab switch event occur at 2:27:40, and then we see lots of navigational events occur.
Is that a yes?
At 2:28:06, Safari is minimized, so it's removed from focus so that something else could be viewed, or the phone is locked.
Is removed from focus.
Wouldn't you know if the
different than
phone's
closing?
locked if you have the
Correct.
whole
If you remove it from
extraction?
focus, it's essentially going into the background,
Like,
but it's still
you-
open.
You have the whole extraction. I just don't understand, if you have the whole extraction, why you don't look at the web history, and then if you're building a PowerPoint about it, instead of saying could have been lunch meat, could have been peaches, like could have been whatever, can't you just say, and then I looked at the rest of the phone extraction and saw that the phone was powered off, that the light went on. Like, you have all of the data. So instead of saying could be this, could be that, can't you just bring all the data together and say the web was doing this and then the phone did this at the same time? You have that data. I'm just confused why you don't intersperse the phone activity with the web searching. It seems like it would make more sense. So, I don't know. He said, for all of you saying, but does he have all the data? He said he received the zip file of the phone extraction. So I'm assuming zip file of the phone extraction means you have everything that was extracted from the phone. And he hasn't said that he didn't. So that's my question. Like, why not just do that? All right, we'll continue on. Yeah, the jury doesn't, we have more context for this than the jury does right now. And we're still like, what? And for some of us, we've heard this testimony multiple times. So the jury is like, huh? We'll talk about it later. I gave earlier why I thought they're doing this now. We'll talk about it again. Don't worry. It's okay,
Current
guys.
state just in the background versus if you close it completely and have to reload
If you're
it later
confused,
on.
the jury's confused.
So in this particular state, the timestamp doesn't get changed. The timestamp remains 2:27:40 as it was earlier.
And I have to decide where we're going for this week.
Safari is then
For
not used
Pokemon
again
Sleep.
until 6:23:37 when it's opened from the background using the icon in the app library.
Tara
At
said
this
the phone
point, when it
extraction
loads
can be
up,
limited, though. It can, but nobody's given us that
The
information.
same page that was open when Safari was minimized is shown.
We don't know.
So we still see hockenmocksports.com/schedules/girls hockey/Franklin/2021-2022. There's no navigational event at this point, so we know that it wasn't completely reloaded. It's just showing what was on screen previously, and it's evidenced in the Knowledge C database. At 6:23:49, there's a cache file created. The cache file is related to
not
how
cache.
long to digest food.
Not Kesha.
Now, these particular cache files show up as suggestions in Safari. So as you're typing in a query or a word or a URL, for example, Safari tries to take that information and make suggestions based on what it thinks you might be searching for. So if, for example, you were to type in how long to die with the word spelled just DI, Safari can mistake that for how long to digest food, and it could present this information. And up until about 12 months ago, this is the information that was provided by Safari. If you were to do this search, if you were to type in how long to DI, you would get the result that's shown at the top of the screen with an image of somebody eating a plate of food.
So a fill-in
And this
search.
is the image that was cached
Not the
onto
official
Jen
word.
McCabe's phone at 6:23:49.
Kate in the chat said,
does
who
cache
actually
mean?
uses Safari? A lot of iPhone
Essentially
users do.
Downloaded now for use later. Like it will download it, it will save it in case it's required again. If it is, it doesn't need to download it. It's
No,
already
y'all, she wasn't looking up food. I know, we've gotten very far afield. He is talking about the predictive text in search. So he's talking about predictive text. So a lot, for those of you asking who uses Safari, a lot of iPhone users use Safari default on their phones, even if they don't use it elsewhere. Anyway, he's talking about predictive search and how if you start typing in how long, that the phone might predictively respond. He didn't say she was searching for how long does it take to digest food. He's explaining that this is predictive search and why predictive search happens. So let's, where did you go? The entire, it just disappeared. Cool. How long before the stream has tech issues? An hour and 5 minutes today, apparently. Let's continue.
if it's not required again, eventually it will be deleted.
So is it stored information from prior events that's available in case the device thinks you're looking for it?
Yes, so at this point in time, at 6:23:49, when it downloaded it, that's the first time that it's downloaded this image, and it stores it. If an hour later, for example, I did the same search a second time, it wouldn't need to re-download the image because it's already got it in cache. So this, the creation
It's
time
trying
of
to
this
help.
Image shows that this is the first time that this cache file was downloaded. A few seconds later, at 6:23:51, the blue button at the bottom of the keyboard is used to submit a search for the term "How long tidai in Kikdi," CIKD. This creates a specific URL in Safari, which is shown on screen here. So google.com/search "How long tidai in Kikdi," IE
Just
UTF-8,
spell it.
OE UTF-8.
Just spell that.
Client Safari is the important part of this string that tells us that it's a query that's made using Safari. This is different to if I visited Google, for example, and just typed in the search text box in Google. It wouldn't necessarily have this same structure of the URL. So we know that this is the query created by submitting a search using the search bar here and pressing the blue button at the bottom. We know that that search was conducted at 6:23:51 according to the information in mobile safari.plist. And Knowledge C also shows that this page was visible. Importantly, there is no history record made that shows that a navigation actually occurred to this website. Several reasons why that might happen. One could be if the device was in private browsing mode. However, it can't have been in private browsing mode because if it was, we wouldn't have the search recorded in the mobile Safari plist either. So we know it wasn't in private browsing.
Then why
it could have
bring
been
it up?
deleted at some point after the fact. That would leave a gap in the numbering. Every time a record is written, it would be consistent numbers 1, 2, 3, 4,
Could have
5,
been
6. And to delete a number would leave a gap there, so you would see 1, 2, 4, 5, and that number will pretty much never be reused. So if you don't see a gap, then you can be confident that nothing was deleted, and there are no gaps on this device. The third reason, and the one that I believe is the reason why it wasn't recorded in the database, is that the page never completely loaded. If I go to a web page and cancel the navigation prior to it completing the load, it will never get written to the history database. At 6:24:18, there's a second search submitted using the same method, so still using the Safari search bar, this time searching for host long to die in cold. This is evidenced in the mobile safari.plist. Again, there is no record made in the history database that to me suggests that the page never successfully loaded. At 6:24:24, Safari is minimized again. It gets reopened at 10:33:33 a.m., again loaded from the app library and brought into focus. And at that point, the previous page is shown to the user. That previous page is related to the search Hoss Long to Die in Cold. This
There's
is evidence
the
in knowledge
text
C
of the
to
search.
show that this is the page that's visible on screen, but there is still no history event that shows that the page completely loaded. And at around that time, so around 10:33:34, that tab would have been closed, resulting in the record being written to the browser state database with the timestamp 2:27:40, when that tab was originally brought into focus several hours earlier, but it shows the most recent URL information, which is the Google search for Hoss Long to Die in the Cold.
So it wasn't
doesn't
closed
have
until
any of the other
10:33.
URL information that was visited during that time period. It doesn't have the previous Google search for How Long to Die in the Kikti, because all it records is the most recent URL that's visited alongside the original time that the tab took focus. Importantly here, there is no title information.
And it seems like that's a Google
The title information is included
in
within
Safari.
the page itself. So if you do a Google search, the title of the page that showed up would show Google search, and then it would show the query that you typed in to search for. The fact that this doesn't have a title also suggests that the page never loaded. So again, it kind of ties back to the fact that it's not written in the history database. We have no title. It's both indicative that the page never
And
successfully
yes,
loaded.
chat, it's odd to me
Mr.
that
Whiffin.
this whole PowerPoint is listed as Jen's usage, not McCabe phone. Weird to me too. I'm with you. I'm with you. It's weird to me too.
When a
I
tab
don't know
is
why.
ultimately closed,
It's an odd choice to me.
does the URL always have the last search, or could it show an earlier search?
It will always be whatever URL is visible in the tab at the time.
Thank you.
To overview again the data sources used here, com.applemobilesafari.plist is known to be a reliable location to get search timestamps from. We know that it's good to show the time that a search was conducted and what search was conducted. It doesn't record if the device is in private browsing mode. The only time it shows How Long to Die in the Kikti is at 6:23:51, and the only time it shows Hoss Long to Die in the Cold is at 6:24:18. There's no other mentions of either of these searches anywhere else in this file. The history database, again, is known to be a good source of data for visited web pages and timestamps for the pages that completely loaded. Again, in this case, neither of these searches or neither of these URLs was in the history database, but there are no missing records, which indicates that nothing was deleted. And again, the only reason that I can come up with for why that is the case is that the page didn't load. There must be an entry within this database to allow the user to delete it. Obviously, if the page doesn't load, it doesn't get written to the history. As a user, you can't see that item in your internet history list, so you can't delete it. And then knowledge C, which shows the page that's on the
I
screen.
don't love that the
when
expert
your browser is in
who
use.
knows Cellebrite the
Again, we
most
know
is
that
like,
this
I
is
have to
a
just
good
guess at this
timestamp.
one.
And we
'Cause,
see the only times
like, your company
that
makes the
web pages
reports,
related
though.
to these web searches were open is at 6:23 and at 10:33.
For those of you asking why he's allowed to testify for
There were
long
multiple deleted records in the browser
spots,
state database. It wasn't
without a question,
just
he's an expert.
the record for Hoss Long to Die in the Cold.
Please explain.
When you say there's multiple deleted records, can you go into a database and see what URL searches have been deleted from the actual item?
Yeah, so from a forensic examiner point of view and using forensic software, I can look at the database and see the records that have been deleted and recovered. There does become a time when you're unable to recover any more records and they're now just purely deleted and unable to get back. But at this point, I was able to recover a good number of records. And these were the 5 that I thought it was important to focus on for here. You can see that 3 of them occur at 2:27. So at 2:27:36, 2:27:38, 2:27:40. And these are the web pages that we've just seen in the presentation. So Hockamock Sports, the YouTube video, Hoss Long to Die in the Cold. and then 2 additional pages for cantonma.org and Ozone Basketball. The way that we're able to recover these records forensically is because of
I know,
how
Chad, I know all of you
work.
feel tortured because you know that
What
ARCCA
I've tried to
voir dire this
display here
afternoon.
is that
And
when
it's
you
like,
first create
Really?
a record, in
I
this
know.
case, creating record 4025,
It's
a new
important
page
testimony.
is created in the database. A page is simply a block of binary data that's organized in a way that can be understood by the database as
I'm glad the
data,
database
much like it
understands.
would be a ledger with a list of records. So it creates frame 181 with page 2752 and the record
What?
4025. What is a little bit different from if you were doing this manually is when you want to add a new record, or when you want to delete a record, or when you want to update a record, it has to create an entirely new page or an entirely new version of that page. So in this case, we see that frame 194 is
Well, that's
also
a helpful
page
highlight.
2752. It duplicates the record 4025 and adds the record 4026. From the database's point of view at this time, frame 181 is now dead. Like, it won't be used for anything. And a regular database tool would only refer to the most recent version of that page, so frame 194. Forensically, I can look back at all of these different versions of the page and I can start to see differences. Not so important in this case when all that's happening is that you're adding information, but when you start to delete or edit records, being able to go backwards and see these previous pages, you can see the records that have been changed or deleted.
Okay.
So as we're
And
moving along all of these pages, each of these refer to a time when a new record was added. Every time a new record is added, a new frame is created, it duplicates the page from before, and it adds the new record.
okay.
I've highlighted record 4028 in green across these 3 frames because this is the host long to dying cold record that is of interest. Moving forward again, we continue to see records being added,
Why is stuff
but-
blurred?
particularly here at frame 430. Record 4029 is deleted. 4029, if I go back a few slides,
Oh my God.
we can see 4029 is the cantonma.org Families Index webpage. As far as I know, no relevance to anything related to this case. It just so happens this is the first record deleted from the browser state database. We don't have information that tells us at what time the record's deleted, but we're able to infer what time that record was deleted
How?
based on other records in this frame.
Like what?
So, for example, we know that at the time that record 4029 was deleted, record 4031 already existed. Record 4031 has a timestamp of 6:29 on the 31st of January. Therefore, we can summarize that record 4029 had to be deleted at some point after 6:29 on the 31st of January.
Okay.
We see again record 4030 is deleted.
I mentioned my coffee already ran out,
on
right?
frame 468. Again, we can look at what record was the most recently created on that frame at the point that that record was deleted. And that gives us information that suggests record 4030 had to have been deleted at some point after 8:35 on the 31st of January. We can continue to go along and continue to see that records being added, edited, and deleted, but the record of interest, 4028, still exists, even on frame 650.
So 4028
And in fact, it doesn't get deleted until frame 732.
correlates to
time
the search.
the record related to host long dying the cold is deleted, record 4037 already exists. Record 4037 was created after 2207 on the 31st of January. Therefore, we know that the host long to die in the cold record was deleted at some point after 10 p.m. on the 31st of January. Taking all of those deleted records, those 5 deleted records, and the earliest time that they could have possibly been deleted, we see a spread throughout the 31st of January. Like a few quite early on at 6:29 and 8:35, a couple
When
at
did law enforcement
9:20,
ask Jen
9:40,
McCabe for her
and then
phone?
finally the one that we're interested in at 22:07. For the user
I have questions.
to cause these to be deleted, if you wanted to do it selectively,
He's saying these weren't user deleted. He's saying they were database deleted, not user deleted. But he didn't say that 100%. He said that he inferred that they were deleted because the new records still built on them and that they didn't load properly, and that's why they were deleted.
and delete one at a time, the record has to be available in the history database. As I said earlier, it wasn't ever in the history database because there'd be a gap. So this record could not have been deleted by the user selectively. That leaves options of deleting everything from the history, but if everything was deleted, we would have none of this information, and we do. And it also leaves the option of deleting everything from what's considered today and everything that's considered today and yesterday. And again, if either of those options were the case, we'd have much less information than what we have, and we wouldn't see this staggering of timestamps that we see here where the information was deleted. Ultimately, I wasn't able to say what caused these deletions at these particular times, but I'm confident that it wasn't as the result of user interaction. That's something that was brought on purpose.
That was a really long answer.
So, Whiffin, I have a couple questions about your analysis and your opinions.
Yes.
Okay.
You showed us a tab that was opened at 2:27:40, and it had something to do with Hawkmock Sports.
Yes.
In your opinion, to a reasonable degree of scientific certainty, was that the same tab, that 2:27:40 tab open for Hawkmock Sports, was that the same tab that later was used for searches or attempted searches at 6:23:51 and at 6:24 relative to how long or how's long to die in cold?
I believe it was, yes.
Does your opinion, is it based on your analysis of reports generated by software like Cellebrite?
Objection, Your Honor.
Sustained as to form.
Was your opinion limited to analysis of reports generated by companies like Cellebrite or Axiom?
It wasn't, no. I went into the data, looked at the various different databases, different files that were in use, tested it across many different devices to make sure that my understanding and analysis of it was correct.
In addition to your opinion that the two searches at 6:23 and 6:24 occurred at that time as opposed to 2:27:40, did you also, when analyzing the data, come to an opinion whether or not either of those searches actually connected and produced results?
If either of those searches had connected, the information would have been written into the history
So is that
database.
a no?
The fact that it wasn't in the history database it strongly suggests it never completely loaded. And the fact that there is no title information on the browser state tab as well also suggests it never loaded.
And finally, those attempted searches at 6:23, 6:24, you mentioned that information at some point was deleted from the phone?
The only records that were deleted were the browser state database records. Yeah, they were deleted from the device.
Do you have an opinion to a reasonable degree of scientific certainty whether or not that information was removed as a natural application of the phone, or was it because somebody took the phone and actually deleted it by hand?
So again, I don't believe it's possible, given the situation and the information that's available, that it would have been possible for the user to delete it. I believe it was more than likely a system event that caused that, but I've not been able to replicate that system event.
I want
That's
to take you
interesting.
back to your first opinion, where you opine that the how's long to die in the search occurred at 6:23 and 6:24, not at 2:27:40.
Yes.
And so, in looking at the data coming to that.
So everything
opinion,
you could replicate
what
except the
caused
deletion.
Confusion with the software where it could be misunderstood the time those searches were actually made.
Objection, Your Honor.
I'm going to allow it.
The way that forensic software typically works, certainly the way that Physical Analyzer works, is we design models for the data. So we know that an SMS application, for example, will always have a message body. It will always have a sender, a receiver, a time, that kind of thing. We always know that a web visit will have a URL, a title, and a visited timestamp. In this particular case, in the database, the timestamp is called last visited timestamp, which is indicative, you would think, of the time that the web page was visited.
I detect a
So
little
when that
snark.
information was being modeled within the software, the timestamp that was within the database was used, and it was called last visited timestamp. Since the investigation that I did into this case, I requested that the forensic research team at Cellebrite revisit this data and confirm if there's confusion around it. Were my findings correct ultimately? There are times that that information can be correct. If, for example, you create a brand new tab, visit a website, and then close the tab immediately, then that timestamp would be indicative of the time that the URL was visited. But if you were to create a tab, use it for 3 hours, and then close it, the timestamp would not be indicative. Also, if you were to bring an old tab into focus that you'd used several days earlier and then close that tab, again, you're going to get bad timestamp information. So ultimately, from Cellebrite's point of view, we removed the timestamp from that data to avoid confusion in the future.
You shared with us that the URL for the 623 and 624 attempted searches ultimately was removed from the device.
Yes.
Would it be fair or accurate to say there were over 4,000 deleted files from the phone?
That's-
Or there was 4,000?
Why don't you just
deletions
ask him a
from the
question
phone?
instead of
There were
giving him
many-
information?
Sustained
It's totally leading.
as to form.
Yep, because it's leading.
Would it be accurate to say that the only deletion from that phone was that 623, 624 search?
No, there were thousands of records deleted ultimately for various reasons. That I can
Like?
follow.
That would be an inaccurate assertion?
What?
To say that that's the only record that was deleted is inaccurate, yes.
Well, tell me more about the thousands of records that are deleted.
Thank you. I'm
then.
now going to turn to a second phone that you looked at.
It-
You told us that you looked at two phones. The second one was a phone that was, or is attributed to John O'Keefe.
Correct.
When you looked at the phone for John O'Keefe, were you looking at things different than we looked at on the phone attributed to Jen McCabe?
I wasn't as interested in internet data. I was more interested in location and health and
Why?
anything else that could be useful.
Is that what you were asked? And by whom?
Before we show any presentation, I want to get a little understanding of what you looked for and what you found. Were you looking for what's called location data?
I was, yes.
Was there a period of time that was important that you were looking for relative to location data?
Typically after midnight and before 6 a.m.
That on January
Don't start
29,
singing after midnight.
2022?
It is, yes, sorry.
How does a phone, like an iPhone, store location data?
Multiple ways that it can be stored. Primarily, there's a database called cache.sqlite. And every time an application requests location data from the device, a feature called Location Services on iOS tries to calculate the device's location using a combination
They're
of
gonna take the
technologies,
morning break before we get to
GPS,
cross.
Wi-Fi, cell tower, and Bluetooth. Calculates the device's location and stores that into the database as a latitude, longitude, altitude, timestamp, accuracy radius, information like that.
Are there different types of location data that are captured and stored on a device like an iPhone?
Can you define different types, please?
I'm sorry?
If you could define
What do you
by
mean,
different types.
counsel? Hey, counsel, just
Different
say.
sources of
Can you explain to us the type of location data stored on an iPhone? Just that. That's it. That's all.
data
Just that.
are generated that then
That.
captured on an iPhone.
Yes, so
Ask a simpler
the application
question.
can specify how accurate it wants the data to be. So, for example, if you're using a navigational application, you'd want high accuracy data. So the application would request high accuracy data from location services. Location services would then try to use GPS primarily
All right, your phone will tell
to
on
get
you.
location information. Versus if you were using a weather app, for example, where you don't really need to know precise information, you just need to know the approximate town maybe that the user's
No
at.
way. I want my
So
weather
a
app
weather
accurate
application would ask
AF.
for low accuracy information, and the device may be able to calculate the location based on cell tower information, for example.
And you know how I make my weather accurate AF? I watch Ryan Hall, y'all. I know some of you are probably doing that today. That's what I watch. I'm just like, why am I driving through rain that I can't see through in Kentucky? This is not what I anticipated. My weather app did not warn me. I need my weather app to be accurate.
Both can be stored in the database with the accuracy information that's available.
Would a application that is devoted to navigation in your programming experience typically have stronger
It's a really
data,
broad
location data
question.
information than a more general application
What's
like
stronger
a
mean?
weather app?
Yes, for sure. And Apple actually specify in their documentation, when they specify the various different accuracy levels, they have one for navigational purposes for map applications.
How do you define accuracy level from the different data that's being stored in a phone?
How do you mean? Sorry.
Is there high level, middle, low?
Yes, the information is typically provided with a range of meters. So you'll have a latitude, longitude coordinate and a number of meters that you have to draw around that locational point.
My phone doesn't speak meters.
And the device is somewhere within that circle.
Or maybe it
could be
does.
as accurate as 2 or 5 meters.
I don't.
It could be as inaccurate as
Sir?
several miles, depending on the technology that was used to get the data.
Are you familiar with an application called Waze?
I am, yes.
I
Tell
am.
us what Waze is.
Waze is a navigational tool, so you can plot a route and it will try to direct you the best.
I was way too excited about
the
that.
best way, avoiding toll roads, avoiding accidents, that kind of thing.
What is the level of accuracy in location information that is generated by using Waze?
That would be the highest level of accuracy. So it would aim to get GPS quality information of around 5 meter accurate.
So why doesn't a programmer in every application just use the highest level location data for every application?
Getting GPS data is not always possible. If you're in a building, in a basement, for example, you may not get that. But also, it can be expensive to the device in terms of processing power, in terms of battery requirements. So if it can find location information cheaper by using Wi-Fi networks, for example, then it would prefer to do that. So just a lot less resource intensive than using GPS all the time.
In order to capture the highest level of location data, the most accurate in an application
Sir, are we
such
going to
as
see you
Waze,
talking about location data in any other cases we're
somebody's
watching
using
this
Waze
year?
and
Because
then
I feel
turns
like
it
location
off,
data is
does
going
it
to come up a
still
lot
continue
in
to capture
Idaho.
that highest level of accuracy?
Typically not. It may do for a short time, as it's
Sorry, I
still
forgot
kind
to
of
mute
working
before
through
I
a
crunched.
backlog. But fundamentally, if there's no application open that's trying to use location services, then the location information that's being requested and recorded is far more sporadic. It's typically background applications that may be requiring location data.
When you analyze John O'Keefe's phone, in addition to the location data, did you also look into data known as health
I
care
did,
data?
yes.
And could you tell the jury how that works?
Yeah, so pretty much all iPhones for the last 10 years or so have Apple Health included. It monitors activity on the device, such as steps taken using various sensors inside the device, looking for motion which appears to be walking. It monitors altitude, so it knows whether you've gone up a flight of stairs, for example.
I mean, kind of.
It uses that information in concert with the steps taken. So it knows the difference between going in an elevator versus walking a flight of stairs. And all that kind of information is available to you as a user to essentially see how far you walked each day and to monitor your own health.
When you look at
It's the
healthcare
hatch
data,
eggs.
you said it interprets it in different terms. One you used was steps. If I have an iPhone and I'm walking and it registers steps, can it tell what direction I went in?
No, it's purely just looking for motion of the gyroscopes, which appears to match the pattern that it expects of somebody who's walking. It doesn't know whether you're in a straight line, walking in zigzag circles, just number of steps.
What if I had my iPhone and I was moving the iPhone, but my feet weren't moving? Would it register?
It could register some.
So if I
but
sat here and
typically,
started throwing my
it's
phone around.
relatively good at picking the difference between actually walking or throwing the phone around or shaking it.
The healthcare data, does it
Emily,
store
stop. You're
with
going to knock
date
your
and
monitor off
time?
the desk.
So there's two locations that health data is stored. Primarily a database called HealthDB_secure, and that aggregates the information into periods of time. So you may have a 10-minute period where it says 100 steps were taken. Now, it could be that the 100 steps were taken in the first 2 minutes, and then virtually nothing was done for 8 minutes there. But there's another database called Cache Encrypted C, which is
Okay.
more granular. It's where the information is written originally prior to it being aggregated and moved into the bigger health database.
You also mentioned that the healthcare data has a term known as steps.
Yeah.
If the movement registers as steps, would that necessarily mean that a person was walking up or down steps?
Sorry, are we talking about steps taken or flights climbed?
I'm sorry, flights climbed.
A flight climbed, according to Apple, is essentially an incline of 3 meters over 16 steps taken. So it wouldn't really matter whether it was walking up a flight of stairs, walking up a steep inclined hill, on an escalator, something like that. If there is movement that appears to be walking and an incline of 3 meters, then that would be considered a flight climb event.
Is there any other ways that the phone could register flights climbed, but the person's not actually walking up or down stairs?
So I did test this a few months ago, driving in my vehicle. I was able to, if I just put a
there a new
phone
report?
on my dock as I'm driving around, nothing was recorded. But I found that if I was actually holding the phone while driving at the same time, then the natural suspension of the vehicle plus the movement of my arm would be considered enough to be steps. And if that motion happened while I was driving up a hill, it would also result in a flight climb event. And the testing that I did consistently resulted in, I think it was 9 flights of stairs climbed while I was driving up the same hill multiple times.
In your studies, what elevation change would have to be present if you were in a car with a phone and it would register healthcare data as steps? Is there a certain level of elevation that would trigger that?
Again, it's just a 3 meter incline is required.
Did you say 3 meter?
3 meter.
The healthcare data, in addition to being able to give a range of time of movement and defining generally terms, whether it's steps or stairs, is there any other information about healthcare data that is important in your analysis of this case?
Is that a catch-all question?
Sorry, can you just repeat that, please? I'm sorry, I'm trying to think.
The healthcare data
Brennan, I've zoned out.
shared
This
tells
witness
us
probably.
there's movement,
Yes.
and it may come in the term steps. You also shared that the healthcare data can show elevation. That can come in the term flights.
Yes.
Is there any other information about the healthcare
Anything
data
else?
you looked at? Did you look at it across a wide range in this case?
No, it was just the steps and the flight climb that I was interested in.
What is the time period you looked at the healthcare data for in this case?
Between midnight and 6 a.m. or 6:30 a.m.
That's midnight on January
On January
29,
29th.
2022 till about 6 a.m.?
Yes.
and before we get to any presentations, did you see movement on that phone relative to healthcare data at different points through the night?
I did, yes.
Did you identify those different times in your report?
I did.
You created a PowerPoint for Mr. O'Keefe's phone. Are those time points and movements, are they indicated in the PowerPoint as well?
They are, yes.
So you had, with Mr. O'Keefe's phone, you looked at location data, you looked at healthcare data. Is there any other data you found important in your analysis to try to track the movements or non-movements of the phone of John O'Keefe on January 29, 2022?
Yes, I've also looked at battery temperature information and at a feature called Doppler, which is monitoring
I'm
for
interested
Face ID.
in the battery temperature.
Tell us a little bit about the battery temperature. Is it the battery temperature of the phone or part of the phone?
There's a battery temperature sensor built inside the phone.
Yeah, people who play Pokemon Go in the summer where it's hot know. We know. I'm very interested to hear about the battery temperature, though.
Within the battery. And it's essentially always checking for battery overheats or battery cool downs to the point where performance will be affected and the device needs to power off to save itself being damaged. So that temperature information isn't recording ambient temperature. It's not interested in the temperature in the room, for example. It's purely interested in the battery temperature. But it is affected by ambient temperature. And I, again, did lots of testing by putting the phone into controlled temperature environments, so inside a freezer for a set amount of time, to monitor how the battery temperature would decrease over time, given the environment it was in. Bringing it back into a warm environment and testing how long it takes to increase. Putting the device outside. I live in Calgary, where it's pretty cold in winter. So putting it outside, it was like 40 Fahrenheit, I think it calculates to. The temperature of the environment had a big impact on the battery temperature that was recorded by the device.
Were you able to track the changes in battery temperature for Mr. O'Keefe's cell phone over the course of the evening?
I think the jury will be
after
interested in this.
12,
If you guys are interested in it, they're going to be interested
on January
in it.
29, 2022.
It's easier to wrap your head around.
After 7, 8 in the morning?
And they have context for it.
There wasn't a massive number of records, but there were records that I've included in my report.
In addition to those three areas,
And having
when
context
a person uses an iPhone
is
and
important.
presses the buttons, or they hold it and they try to open it by recognizing their face, what is that process called?
The Face ID would be the process for the unlocking, and then the locking, pressing the button on the side would lock the device.
When an iPhone is being used, does it act or operate differently when it's out in the open or if it's in your pocket or under something?
Yes, so this is the Doppler function that I found within a feature called Unified Logs. Essentially, whenever the device receives a phone call or when you pick up the device, an iPhone X or above is trying to find a face to use to unlock the device. If the camera is blocked, a record is made to say that it's within a pocket state. So if my phone's in my pocket, when somebody calls me, it tries to...
Can you explain how it butt dials then? Can you explain how it butt dials then? Can you explain then how it butt dials? I got questions.
Look for a face, it immediately recognizes that the camera's blocked and it records pocket state. As soon as I take the phone out of my pocket or unblock the camera, it records a pocket state cleared event. So we know when the camera was covered up versus when it was uncovered, if at the time it was receiving a phone call or was being picked up.
Does an iPhone always record?
You guys, I know it's relevant to this case. It is completely relevant to this case. But also, I was on the phone with Judge Abby, I don't know, like a week ago. And Dr. B butt dialed me from his pocket while he was doing yard work like 9 times. And I have voicemails like 2 minutes long of just him walking in the yard. I don't know. How does it happen? Do you not? I legitimately have questions at this point about how it happens. Because it does happen. My dad does it too. Like, Does it depend on how loose your shorts are so that I have questions. Oh, I answered twice and then I was like, okay, this is just going to keep happening.
Whether or not the camera was blocked.
I mean, it can happen, but like how?
At the time a call comes in?
No. For example, if the device is already unlocked, then it won't make a recording to say that it was within a pocket state or a pocket state cleared.
Literally, Emily, keep listening. If the device is unlocked, that's how it is. Unlock your phone and put it in your pocket, and then we're here. It would be great if, in this case, they had the phones so they could see if they were in an unlocked state or not, because you would be able to tell if the phones were in an unlocked state or not if you had the phones. But if you don't have the phones, then you can't tell if the phone's in a locked or unlocked state. All right, there we go.
It was blocked or hidden or
I rewound a
covered
little.
at the time a call comes in?
No. For example, if the device is already unlocked, then it won't make a recording to say that it was within a pocket state or a pocket state cleared. And if the device isn't blocked at all, so if I have the device on a desk in front of me, for example, and a call comes in, there'll be no record that says that it's in a pocket state or a pocket state cleared. It will only record a pocket state event if the camera's blocked, and it will only record a pocket state cleared event if the camera was blocked and now isn't.
Does
So
it
if
have
I
to be
have my
unlocked?
iPhone and I put it inside my jacket in the darkness and I get 30 calls, would all of those calls result in a reading of pocket state?
They'd all result in multiple readings of pocket state. The pocket state check is conducted more than once a second.
But
I can't
only if
remember
you
the
put
exact
it
number,
in your pocket.
but it's very frequent.
Unlocked.
And
No,
an average
locked.
phone call from the start of the ring to when the device essentially hangs up, somewhere in the region of 500 checks. So if you had 10 phone calls, then you'll have 5,000 checks made that would all report pocket state.
Did you analyze John O'Keefe's phone on the evening, early morning hours through the next morning on January 29, 2022, in an attempt to identify where he was, what he was doing, and whether his phone was inside or outside?
That was my goal, yes.
And did you engage in that analysis, sir?
I did.
And in your efforts, did you write a report?
I did.
Did you write multiple reports on these separate issues?
I did.
And those reports are provided to everybody?
Yes.
In addition to the reports that you generated from your study, did you present or did you prepare a PowerPoint?
I did.
Does
Another
the
PowerPoint.
outline some of those points?
It does.
At the end of the PowerPoint, do you go through a timeline accumulating?
Can we just
many of
go
these
to the
pieces of evidence
PowerPoint?
together that show them in a chronological sequence?
I do.
And does that help capture the movement or non-movement of John O'Keefe's phone through that night?
I believe it does.
Nora, may I approach?
Yes.
Okay.
Showing no binder, sir. Could you look at it? Let me know if you recognize it.
Okay.
Yes, this is the presentation that I created regarding John's phone.
For those of you that don't have the Law Nerd app, now's a good time for me to remind you that yes, we will send out a Law Nerd app notification when we get to cross-examination. If we get to cross-examination today before court breaks for the day, because court's going to break at lunch. And we got a long way to go. So
Thank you.
I'll let you know. And then when we take the lunch break, I'll let you know when we're back for the ARCCA of voir dire, because that's going to be this afternoon. The jury is
Court's
here now,
permission,
but they
Mr.
won't be this
Whiffin,
afternoon.
Referring to Exhibit 39, I'd like you to walk us through
The jury just doesn't have a lot
John
of
O'Keefe's phone on the
a
evening
lot of,
January 29th.
Okay.
context for this.
2022.
They do with the phone battery temp. They've talked about that a
So
lot so far.
I start the presentation with location data. As I mentioned earlier, this comes from the cache.sqlite database, which is considered the most reliable location or the most reliable file for location data on an iOS device. Stores information whenever
When
location
y'all can stay, I'm not
information is
telling you who has to go.
requested.
I'm just
That
letting
could
you
be
know it's
through
fine.
user interaction with the device using something like Waze. It could be background activity, just depending on what applications the user has open, what settings the user has chosen. It's constantly trying to find its location and recording it in this database, partly for the purposes of identifying frequent locations.
Okay.
At 12 minutes and 5 seconds after midnight, the device shows multiple location points at Washington Street around Forge Pond. What I've tried to show here, there's a kind of a gold dot in the middle, which would show the actual latitude, longitude information. And then the circle around it is what's considered the accuracy radius. The smaller the accuracy radius, obviously the more accurate the information is believed to be according to the device. But ultimately, if the device is anywhere within that circle, then iOS would consider it correct. It considers it an accurate record.
Mr. Whiffin, why are there multiple circles of location data for one point where Mr. O'Keefe's cell phone was?
So this wasn't a single point in time. This was multiple records at around 12 minutes and 5 seconds. No application was actually in use at this time requesting location information, but the device, for whatever reason, recorded multiple records with various degrees of accuracy. Typically, you would see...
I hate the device for whatever reason. You have the entire forensic download. You can see what the phone is doing. It's like the phone just is doing shit. You can see what else the phone is doing.
Accuracy start quite low and get better.
I don't think he
time,
looked.
Which you may have seen on your own device when you open up the map application, and it may show your device close to where you are, but not perfectly where you are, and then wait a few seconds, and that information gets refined. Essentially, this is the same thing.
So low accuracy would be a wider circle, and higher accuracy would be a smaller circle?
Correct.
At this point, Mr. O'Keefe is not utilizing Waze on his phone?
Correct.
What time are we talking about?
Location data is still being stored randomly on the phone from multiple different sources?
It is, yeah. Depends on the device itself.
In the top left-hand corner, it says 12:05. That's the time at this snapshot?
Yes.
Okay. And
in
then
this
below
case, approximate.
And below it's obviously the date?
Yes.
Okay, could you take us ahead, please?
Okay. There were multiple records between...
It looks like things get way more accurate.
And what's shown on screen now at 19 minutes and 33 seconds. But all of the records were sporadic and low accuracy with values of 1,000 meters or more. But around this time, around 19 minutes and 33 seconds after midnight, is when Waze was actually brought on screen. Waze starts to ask for high accuracy data, so we see the accuracy immediately start to improve. So again, we see relatively low accuracy data to begin, and then over the next few seconds, it begins to refine itself until it gets down to a 5-meter accuracy records as the device continues up here. We'll highlight that there's a cluster of records here as the device came to either a slow or a stop. Momentarily, multiple records were created, and then the device continued driving up Denham Street.
Mr. Whiffin, below the time, 12/19/33, in the date, talks about the average accuracy.
Yes.
And that's in meters?
That's in meters. So again, the records that are shown at the bottom here are around 55 meters. The records shown at the top are around 5 meters.
Is it typical in Waze that once it locks in, the range is around 5 meters?
Typically, yes. That would be the goal.
You also mentioned the average speed. Where do you learn the speed from? Where does that data come from?
The database, the cache SQLite database also calculates the average speed between two data points, and also the bearing or the direction of travel between those 2 points. So the average speed that's shown here on the left is approximately the average of all of the records that are shown on this map at the time. And each of these map points has a directional arrow that points in the direction that the database recorded the device was traveling in.
When you look at this information generated because of the usage of Waze, and you can see both the accuracy and the speed, with the Waze information at its most accurate, can you actually tell whether the vehicle is moving or whether it stops?
Yeah, based on the speed and the
based on things
location
bunching up.
and the timestamps, you can determine whether the device is moving or stopped.
Thank you.
Also important to, I think, point out here, in terms of knowing how reliable this location information is, I typically look at something along the lines of, does the location think it's accurate? In this case, 5 meters, so yes. Does it make sense? Like, it's on the road, it's on the correct side of the road. So again, it kind of makes sense. It fits the pattern of the road. The cadence and the speed are, what you would expect for this road, like traveling at 20 to 30 miles an hour up here seems quite reasonable. So all of these factors taken together increase my confidence that this would be reliable location data.
Yeah, it makes sense. Given that there's also multiple other points of data that where
between
a car was
20
going,
minutes and 19 seconds
helps.
and 21 minutes and 58 seconds after midnight. The device starts on the left side, on the right side at Dedham Street, drives up and turns left onto Maplecroft Road. Again, we see that all of these location points match the pattern of the road layout. They all have a consistent cadence, a consistent speed, traveling at between 10 and 20 miles an hour. And we see a cluster of records here, which is around a stop sign. So again, it indicates how reliable the data is.
I think
because
the map
location,
is helpful.
The location data that's recorded recognize the vehicle slow, come to a stop, and then continue after.
There's going to be a lot of
stop
other
sign.
evidence
Is
toward this, but the jury
Maplecroft
hasn't seen it yet.
Road in Canton?
Yes. At the end of Maplecroft Road, the device turned left onto Oakdale Road and continued heading down there. Between the hours of 21 minutes and 59 seconds and 22 minutes and 53 seconds, the device continues down Oakdale Road. Again, all of these location points show with 5 meter accuracy. They show a consistent cadence, consistent pattern to the road. And again, we see a cluster where we see the device come to a slow or a stop for a stop sign. The device ultimately turns right onto Cedar Crest Avenue, I believe, and continue down there between 22 minutes and 54 seconds and 23 minutes and 57 seconds. Again, as I've said before, all of these points, 5 meter accurate, they all conform to the road. The cadence is good, and again, we see a cluster on
the speed
approach to a stop
changed.
sign. The device shows that it overshot Fairview Road and continued turning up Cedar Crest, but came to a stop somewhere between 50 and 51. And at 23 minutes and 58 seconds, the device appears to have turned around, so potentially a 3-point turn, in order to head back down Cedar Crest Road and turn right onto Fairview Road. Again, accuracy 5 meters, good cadence, good conformity to the road. All appears to be reliable and make sense, traveling at an average of 20 miles an hour.
And that road coming down at the bottom of the screen where John O'Keefe's phone travels, that's Fairview Road?
This is Fairview Road here, yes.
And then you see where it stops.
The next few slides replay that same data, but instead of showing multiple points on one graph or on one map, it's going to show one location point per slide. So at 24 minutes and 20 seconds, we see the device is already on Fairview Road. Accuracy of 5 meters, traveling at 14.8 meters and heading south.
That's not meters, that's at miles per hour.
Is now at 16.2 meters, but
That's at
it's still highly accurate
14.8
information.
miles per hour.
24 minutes and 22 seconds, traveling at 18.3 miles an hour.
Is it? He went between distance and speed. I think he means speed, not distance, but he was swapping between the two.
24 minutes and 23 seconds, traveling at 16.9. 24 minutes and 24 seconds after midnight, traveling at 16.9. 24 minutes and 25 seconds, traveling at 16.6. 24 minutes and 26 seconds, traveling at 17. 24 minutes, 27 seconds, traveling at 15.9 miles an hour. And at 24 minutes and 28 seconds, traveling at 14.5 miles an hour, at which point it's approximately outside number 34 around the driveway area. 24 minutes and 29 seconds, traveling at 12.1 miles an hour. 24 minutes and 30 seconds, traveling at 11.5. 24 minutes and 31 seconds, traveling at 10.4.
So slowing down.
24 minutes and 32 seconds, traveling at 8.9. 24 minutes and 33 seconds, traveling at 7. 24 minutes, 34 seconds, traveling at 5.2. 24 minutes and 35 seconds, traveling at 3.5. 24 minutes and 36 seconds, traveling at 3.2 miles an hour. And at 24 minutes and 37 seconds, traveling at 1.4 miles an hour. Finally, the device comes to a complete stop at 24 minutes and 38 seconds. I'll say from the testing that I've done related to the speed, it may not be 100% accurate, but it's a very good indicator of the speed in general.
Did it ever back up?
So if it says it was traveling at 10 miles an hour, it would have been traveling at somewhere between 9.5 and 10.5 on average.
Mr. Whiffin, you just showed us the travel of Mr. O'Keefe's cell phone around 12:24 to 12:24:38
Did it
on
ever
January
back up?
29, 2022, and you said at 12:24:38 it came to a complete stop.
Yes.
Before that complete stop, was the car continuously moving at some speed?
Yes, this is the first record that shows 0 miles per hour or 0 meters per second. Prior to this, there was always a record that showed some level of speed.
If you look at number 34 on that chalk, if you can highlight it, please. If the driveway were at the right side, the top side of the house,
Yes.
And the jury's already seen this because they went on the
Does
jury
your
view, so they've actually
studies
seen 34
indicate
Fair
that
View.
the vehicle, or at least the phone, traveled past the driveway before it stopped.
Objection, Your Honor.
Ask it non-leading.
Did this car or
The
the,
court's
phone
just
that was in
like,
the car ever
right.
stop at the driveway of that address?
No, according to the location and the speed data from the device, by the time it was approximately the driveway, the phone reports it was still traveling at around 15.9 miles an hour.
Have you ever seen a photograph of that address?
I have.
You have or have not?
I have.
You have. And in that
Have.
address, do you see on the far left corner of that address, the yard, there's a flagpole?
Yes.
Where this car stops, or this phone
Ooh,
stops
objection immediately.
at 12:24:33, how close is the phone to that flagpole?
I believe very close.
Huh.
And do you ever see the car or the phone stop anywhere near that driveway?
No.
Please
I
continue.
think Alessi's just busy taking notes for cross instead of objecting.
Between 24 minutes and 39 seconds and 25 minutes and 8 seconds, there were a cluster of more records, all showing 5-meter accuracy, but no movement. Although the center point does move around a little bit, you could interpret this as movement, but because all of the radiuses or radii overlap, there's also a good chance that there's no movement that actually occurred here. This is just the device as it's trying to refine its location. At 25 minutes and 30 seconds, we see a relatively significant change where the accuracy drops to 34 meters.
What time?
We do see a course or a bearing that shows that the device reported it was heading west. But again, this accuracy radius includes the previous locations anyway. So it's difficult to differentiate between actual movement based on this location data or just on the fact that the accuracy reduced, the center point shifted because of that accuracy change, and therefore a bearing was attributed to it when it shouldn't have
Was
been.
Waze
I
closed?
could ask you some questions about the chalk on that indicates
But was Waze
25
closed?
minutes, 30 seconds, so 12:25:30. The
Excuse
circles
me?
become larger.
Questions?
Correct.
Is Waze still being used, or has Waze been stopped?
No, Waze has been
Thank you.
closed at this point for about 40 or 50 seconds.
For how long, sir?
About 40 or 50 seconds.
this location data, or this circle, the perimeter, that's not coming from the Waze application anymore?
No, the location data never came from the Waze application. Waze was requesting location data. iOS is responding to that request, and as part of that response, would write the information to its database. Waze itself records very little location data.
So when you look at that circle, based on
So once
location
Waze is
data
closed,
alone,
the location's less accurate, is what he's
could
saying.
the phone be anywhere within that circle?
Correct.
There is a bullet pinpoint center of that circle?
Yes.
That center of the circle doesn't necessarily mean that the phone is at that exact location, does it?
It doesn't know. The center point is purely an indication of where you need to draw the center in order to draw the radius. If we didn't have a center point,
Somewhere within there.
how would you know where to draw this circle?
And so the phone could be anywhere in that circle, close to 34, inside 34, 32.
Objection, Your Honor.
Ask it non-leading, please.
Could the phone be anywhere in that circle?
It could.
Could it be at the center point?
It could.
Could it be still in the car?
It could.
We know what anywhere
Please.
within the circle means, Brennan.
Between 25 minutes and 31 seconds and 25 minutes and 36 seconds, there's an additional cluster of location data, ranging between 61-meter accuracy and 17-meter accuracy. All of them roughly centered on the same point, approximately, and all of the accuracy radius covers the same area. Like, there's so much overlap in these records that the device is essentially anywhere within the smaller circle.
What?
Between 27 minutes and 35 seconds and 38 minutes and 15 seconds, there was approximately 50 low accuracy records. Again, the device wasn't being used to ask for location data. This is completely passive and resulting in some pretty poor location data. I've highlighted with the red arrow where the 34
long period of time.
Fairview Road is. And we can see, although a lot of these location data do overlap with that point, there are location information here that doesn't.
So why can't John's phone find an accurate signal?
At 38 minutes and 16 seconds, the accuracy improves again. Is now 18 meters accurate, but continues to show approximately the same location that we saw 10 or 15 minutes
Okay,
earlier,
what else does the phone do
around
between
the-
12:27 and
kind of
12:38
around the
then?
flagpole area. 38 minutes and 17 seconds, same general area, slightly higher accuracy information down to 14 meters. 38 minutes and 18 seconds, accuracy increased to 12 meters, shifted slightly. Now the flagpole area is essentially at the lower side of this circle. Obviously the top side of the circle now includes a part of 34 Fairview.
If the location information is indicated by the circle and the circle has shifted, does that mean necessarily the phone has moved?
Not necessarily. Typically, you could assume it has, but when we're already talking about accuracies of 12, 13, 14 meters, it starts to become a little bit harder to determine how accurate this data is. So at this point in time, it
Chat,
could be
I know
anywhere
you're all
within the
asking
circle.
for more
And
information than we have yet. There's information we do not have yet in this trial, which is why I'm not answering your questions. I'm not ignoring you. I see you. We have a lot of folks watching with us that did not watch the first trial. So the jury doesn't have much more timing than this at this point. So I am trying to keep in mind that the jury doesn't have more information than this. So we're going to have to wait and see what information comes in this trial. I know it's hard, but we're taking notes of the times so we can call back to it. Don't worry.
The movement of the center
We'll get
point
there. We'll get
could
there.
just be the result of refinement of the device or environmental conditions that suddenly change.
We'll
If the
get
weather
there, Chad. We'll
changes,
get there.
It could cause the device to slightly miscalculate or to calculate differently.
Would a snowstorm or a blizzard potentially impact the precision of location information that's not
I know we're trying
precise like Waze?
It definitely has the potential to, yes.
we don't
How
have
about a phone being
a lot of
covered?
information.
Could that affect it?
That could also affect it, yes.
If somebody was lying on a phone, could that affect it?
That could affect it.
Could being in a building affect it?
It could.
Thank you.
Done that one at 38 minutes and 20 seconds. Again, refining information more. We've got an 8-meter accurate radius, still focusing primarily on the front yard towards the left side. And then accuracy of 7 meters at 38 minutes and 21 seconds, again showing that same general area.
What's the battery temp doing at this time?
Between 40 minutes and 22 seconds.
Can we just have the battery temp at these times running alongside the location accuracy to get some information? Be really helpful.
And 59 minutes and 29 seconds. Accuracy fairly drops off again, and we see some fairly wild records that don't cover the area at all. But we also see some more accurate records showing, again, where the red arrow points at Fairview Road. Those records are highlighted here, just between 40 minutes and 22 seconds and 59 minutes 29 seconds, only showing records of 25-meter accuracy or better. And again, it's kind of focusing on that flagpole area. Between 1 a.m. and 2 a.m., only looking at location information, which is 25 meters accurate or better. Again, it kind of focuses around the front yard area, although some of these accuracies are still rather large and could put the device inside 34 on the opposite side of the street, towards 32. Between 2 a.m. and 3 a.m., fairly similar story. Again, most of these points are centered around that same location at the front yard. Similarly, between 3 and 4 a.m., between 4 and 5, between 5 and 6. And in fact, if I take all of the location data between 25 minutes after midnight until 6 a.m., only looking at the records that report 10-meter accuracy or better, then typically they all focus around that same location at the front of the yard, nearish to where the flagpole can be found.
I'd like to ask you some questions about this photograph. There's a red circle with a bunch of red dots in the middle.
Yes.
Would those red dots
Could we have
indicate
used
the center of some
purple
location that
or
was captured
something?
at a particular point over that night?
Yes. So each of those center dots is the center of a 10-meter accurate or better location record. I chose to not show the accuracy radius circle on this image, just purely because it makes it hard to see when you've got all these intersecting lines. But ultimately, if you were to draw a 10-meter radius around all of these points, they would all fall within the large red circle that's shown.
Okay.
So this photograph was meant to take readings from the most accurate of the data throughout
demonstrative.
the night?
Correct.
Sustained. Ask it again. Different.
It's leading.
Was this circle
So what does
did it
this show?
include low frequency data?
No, this circle only includes 10-meter accuracy or better.
The fact that the center dots are in different spots, is that inconsistent with a phone being in the same place, not moving that entire night?
It could indicate movement. It could indicate refinement.
Is it impossible to tell?
It's impossible to tell at this level of detail anyway.
Are all of these dots given the
But you would also have
range
other
and
movement
meters
data.
are under? Are all these dots and all these readings of the
But if you have the
high-frequency
health
that are
data
compiled for
and
that
the
night, are they
temp
all
data,
consistent
can we
with
just take it all
Ms.
together?
Yoki's phone being near the flagpole and not moving that night?
That's leading.
I think that's a reasonable assumption.
All right, this might be a good spot. Are you ready to move on to the next area? Or
He said it's a reasonable assumption that this shows that John O'Keefe was near the flagpole throughout the night. It would be helpful if they had taken the location accuracy circles, the temp, and the health data all together That would be real nice.
Or you have any more questions about
Now would
this?
be a fine time, Your Honor.
All right.
We're
Folks,
taking
why
the
don't
morning
we
break.
Take our morning break.
Yep.
15, 20 minutes. We'll see you back there for 15.
Thank you.
Law Nerds, I'm going to be real honest with you. I generally zoom past the morning break because I'm like, let's ride. The way I want more coffee at the moment, yeah, I'm going to take a 5-minute break. I'm going to take a 5-minute break. I'm going to run to the restroom. I'm going to run to the restroom. I'm going to get another coffee. You guys are going to hydrate. We're going to hydrate. I'm going to take like 5. I'll put on our hold music. We'll notify the app. Do I have like, I keep putting my hands in my hair because I'm like, oh my God. Let's try to do a summary before we run to the bathroom. And then I just want to see all the data overlaid together. And I'm sorry for those of you that have not watched this trial before. I realize I am being impatient. I know I'm being impatient. I'm like, foundation is needed. Look, whatever you do, foundation is super important. This is the foundation. But I'm like, can you just tell us the answer and then give us the foundation? And I appreciate it when attorneys do that. Like, get to the conclusion and then tell me how you got there so I know what we're talking about. When we go all of the background before we get to the conclusion, I'm like, where are we going? I know where we're going, but can we bring in more information? And it's hard for the jury too, because they don't have as much context as a lot of us do. And we're sitting here going, I know some of the evidence that's coming. And we're still sitting here going, oh my God, oh my God, oh my God, oh my God. So let's summarize real quick. We are at the morning recess on day 5 of the Karen Read retrial. And we still have Ian Whiffin on the stand on direct examination. He works for Cellebrite, the company that provides the software that does the cell phone extractions. He has been talking about Jen McCabe's phone and is now talking about John O'Keefe's phone. As to Jen McCabe's phone, he did a PowerPoint presentation explaining to the jury why it is his opinion that a Google search did not take place at 2:27 a.m. for anything related to how long or how long to die in the cold, but that the time that shows on the Cellebrite report, which they did not show, is from when the tab was populated into the forefront, and that was at 2:27 a.m., with searches relating to Hockamock Sports, and that those other Google searches were using the same tab that those searches did not complete, and that when that program was closed, or at least that's my takeaway, when the program was closed, that after 10 o'clock in the morning is when that all wrote from when the tab activity happened. He had a little bit of a snarky side comment when he said, this says tab activity time, and that's me paraphrasing. He goes, you think it would be kind of obvious that that's what it meant, but we've had confusion around this, so we've had to change the way the reports report this because there's been confusion around this. I wrote a blog about it. That I'm not paraphrasing. That is exactly what he said. There was confusion, so I wrote a blog about it. While we're still talking about the Google search, the thing that stopped me in my tracks was when this witness said, oh, our public relations officer told me about this case and that there was confusion regarding this Google search. And then he said, and then I reached out to law enforcement. Brennan asked nothing more about it. We're not in cross yet. And then Brennan said, well, did law enforcement reach out to you? And did someone else reach out to you? And then he answered and talked about the fact that the defense expert, Mr. Green, though the jury, I don't think knows that's the defense expert yet, but Mr. Green reached out and asked about these Google searches. And then he finally got back to Mr. Green. It seemed like months later. And then Mr. Green never returned his call because it's been months. But he also spoke to law enforcement about that confusing search. But I'm like, wait. You called them? I'm going to need more information about that. I have a lot of questions. I'm sure they'll come up with Alessi on cross. And then we started getting into John O'Keefe's phone. his Waze location data. We have heard testimony generally about battery temperature, how ambient temperature can impact battery temperature. Anyone that plays Pokemon Go and weather understands how this works. Anyone that's tried to take pictures on vacation when it's hot outside knows how this works. We understand how battery temps work, but we have not heard what the data is from John O'Keefe's phone. We have seen the Waze data from John O'Keefe's phone, and then we have seen the location. Yes, the location data with the different location accuracy circles and at what time periods those location accuracy circles were quite accurate and at what time those location accuracy circles were not as accurate. I'm interested to see if this expert will take the other data, the movement data from the phone, the battery data, and the location data and say, look, at this time period when the location circles got, completely inaccurate, the phone battery temperature was this and the movement showed this. I'm hoping to see all of that data together, and we're not there yet. Will we see it? I don't know. But those are the questions in my mind as we take a break now. Knowing that I have more information than the jury does, the jury doesn't know who Mr. Green is yet, hasn't even heard the name. The jury has heard Jen McCabe's name. So I'm sure when they started talking about Jen McCabe's phone, the jury was like, why are we're always hearing one name in this trial. And you know what it is? Jen McCabe. Have we heard Jen McCabe's more than Karen Reed's at this point? We might have. We might have on day 5. I should have kept a counter. Damn it. Oh well, opportunities missed. At some point, we'll take a look. But the jury has heard this name come up a lot. I think it's very interesting that the prosecution has chosen to put this data in before you get to Jen McCabe. Explain the Google searches before Jen McCabe even comes in. Because if the jury's listening, they're like, okay, that's an explanation for the Google searches. And that seems to track with what we've heard. However, all they've heard about the Google search really at this point is in opening statements and then from Carrie. When Carrie Roberts testified about the Google search, it was very much on cross-examination where she was being asked about telling the grand jury, oh, so you heard Jen McCabe other way. You heard Karen Reed ask Jen McCabe to make these Google searches. That's what she told the grand jury. And then it comes to bear that that's not accurate. She didn't hear Karen Reed ask Jen McCabe to Google anything. She saw Jen on her phone, and later Jen told her that that is what happened. But she saw Jen on her phone. And we went through that quite a lot with the cross-examination of Carrie about what she told the grand jury when asked what she heard Karen say. And she said she heard Karen ask Jen to make those Google searches. No, she didn't. She heard Jen tell her that that's what Karen said. So that's where we're at the morning break. Remember, today is a half day for the jury, and then the ARCCA voir dire is this afternoon, which I think will be very interesting. But the jury won't be there for that. So let's take a morning break. I will get to questions as we can. Let me see how long this morning break is. Oh, they're still on break. Oh, a long break. Because they're still on break. Okay, I'm going to take like 5 minutes, run to the bathroom, make some more coffee. I suggest you do the same, get some water. It's going to be a very long day. But they are still on break, so I'll come back and answer questions. We'll send out an app notification. Sometimes those can take a few minutes to travel through the wires to get to you. But they are still on break, so I'll answer questions as much as I can when we go to break. So let me get it started. Let me put on my hold music, and we are doing a very quick break while court is on break. Let me see. So I'll be right back. About what time is it now? It's 10:56. So I'll be back right after 11. I will see you guys in just a minute. And I don't have my other, hold on. I've got the fun one because we made a court break. We've got a court break vibe for you guys. So give me 1 second to pull that up because A, Team Baker made it, and B, I very much enjoy the vibey music, and C, E, G, A, and B. All right, let's get to break. I will see you guys in just a second. All right, Law Nerds. Don't forget to get the Lawnerd app because we will also notify you when I'm back. But I will see you at, like 11-ish, right after thereabouts. Hopefully that makes sense. All right. BRB. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. All right, Law Nerds, it is time. Emily, you gotta turn the music down. I know, it's a vibe though. It's a vibe though. We're just leaving it on in the background. It's a vibe. Did y'all get the Law Nerd app? I know we're sending out an app notification to let you guys know we're going to resume testimony, but we also had to find some new feeds because there was like feed nonsense going on at the morning break, and all the feeds like cut out and then had to come back. And I'm like, what are we doing? Why do we have to go hunting for other feeds? So there are other feeds. So we're going to grab the one that starts on time. It's not going to have closed captioning. And then when we get caught up, we're going to switch feeds back to the one that has closed captioning. We're going to do our best, but I didn't want to miss testimony. So that's the issue. So let us get going. You guys ready to go back to court? I'm ready to go back to court. Let's do that. Okay, wait. I'm going to switch feeds from the one. I'm going to go to the one Miguelina's telling me to go to instead of the one I was going to go to. All right, let me switch to that one then. We got to get it queued back. I was not queued back up. Now we got to get it queued back up. Hold on. All right. Let's queue that one back up and let's switch feeds again. All right. Let's go back to court. Today is more complicated than it needed to be, but I made an iced coffee. So, today has been very Monday. It's been very Monday today. Let's bring the jury. Let's go back to court. Jury is still in. So we are going back. Why are we not full screen anymore? Let's try that again. Let's do that one more time, because that's not what we had all agreed to this morning when we pulled up the feeds. We had not. No, that's not what we were. That's not. What is this doing? Ew. No. That feed, no. Immediately no. Let's see if this works better. Y'all don't ask. I don't know. Emily, what's happening? I don't know. Why does that feed not want to show up full size? I don't know. Why does this one not want to show full size? I don't know. I don't know at all. It all worked fine. It all worked just fine. And now today is just like, no, our court break video worked just fine. Let's try this one more time. I'm so annoyed. You can see the rage starting to rise. You can see it. This worked full screen just fine. So why is this not full screen? Let's try it. There we go. Why, Emily? User error. It seems because it didn't feel like it. It didn't want to. Great. That's great. The most Monday ever. And then the feeds did all cut at the break, which is why I was like, oh, they're still on break. No, the feeds all cut. Streaming is dynamic. All right, friends, are we ready? Let's try one more time with feeling. Replay crew. Remember, we timestamp everything so that even though we can't fix it in post, you can. So you can just skip to the timestamps when like shit is sorted out. Thank you, Lawnards, for being like, well, you know, what is what is happening? What is happening? Last time. There we go. Woo! Fucking Mondays, y'all. Mondays. Let's go back to court after the morning break. Why did all the feeds change? I have no fucking clue. I have no clue. So we will do our best to get closed captioning back on the feed when we can. Switch feeds because it's one of the things that we focus on. It's real hard though because I don't want to miss witness testimony. So put on closed captioning on your end for a minute.
Doing any independent research on
Great, that's great.
investigation into this?
That's delightful.
Everyone said yes or
Great,
no
okay.
affirmatively.
There's the morning
Did
break.
anyone happen to see, hear, or read anything about this case since we left on Friday?
How is this so quiet?
And were you all careful? Everyone said no or shook their head.
Oh, that's all the way back at the beginning. Oh, that's why. We've gone too far. I thought this feed also jumped back in time. Nope, it didn't. That was on me. That was 100% on me. Yeah, all the feeds cut over lunch. I don't know why. And then they come back like midway through. So we're going to listen the best we can. There we go.
Scores in session. Please be seated.
Oh, thank goodness.
All right, Mr. Brennan, whenever you're ready.
Mr. Whiffin, before we go into the next subject area, I'd like to ask you about the location data. Based on your review of the location data, do you have an opinion whether the location data throughout the evening is consistent with John
Okay.
O'Keefe's cell phone being near the flagpole the entire
That's what
night?
he said before the break.
I believe it is, yes.
I asked you whether you had an opinion whether it was consistent with. I didn't ask you if you had an opinion to a reasonable degree of scientific certainty. Are there other things that you looked at that you will
That's what I want to
consider in
know.
addition to the location data to have a more certain opinion?
There is.
And is the next thing that you considered Apple healthcare data?
It's the Apple Health data, yes.
We asked about it, or I asked you about it earlier on, but I just want to talk about it a little bit before you show us and present to us the data that you've compiled for us. Is Apple Health data different than when you have like an Apple Watch?
No, it's the same
That's a
Apple
more
Health data
complex
recording on
question.
the phone or the watch. The only difference is the sensors.
For those of you asking in the chat, and I saw this a couple times, the reasonable degree of scientific certainty, he is a forensic examiner. He is going to be asked that question as opposed to a reasonable degree of medical certainty because he is a cell phone ceramic. Good Lord, today. A cell phone forensic examiner. He's ceramic. So that's why they're asking to a reasonable degree of scientific certainty. With the doctors, you'll hear a reasonable degree of medical certainty. He is an expert. That's what he's going to be asked. Continuing on.
Being used to do that monitoring. So if you're
Yep,
just using
words
the
are hard
phone,
today.
obviously you're only using the sensors in the phone. It's limited to steps walked and to altitude climbed. If you're wearing a watch, it can also do those things, but it can also add things like blood pressure monitoring and things like that.
Does Apple Health data require an internet connection?
It doesn't, no.
So it's all self-survives on the phone itself?
It is.
So without having an internet connection, it will still store the data?
Correct.
If I have an iPhone, is it storing health data even if I didn't ask for it to do so?
Yes. Unless you actively turn the feature off, it will by default try to track movement.
Is it something that is hidden that I wouldn't see unless I look for it?
No, there's an application for Apple Health, and then the settings are quite obvious in the settings screen.
Enough.
Apple Health data tracks movement of the phone?
Correct.
When you were considering the Apple Health data in this case, did you begin looking for the Apple Health data before Mr. O'Keefe's phone began approaching Fairview Road?
Yeah, I started again at around midnight and looked at the health data up until 6:30 a.m. on the 29th.
The different points when you tracked Apple Health data.
We're talking about John
is that
O'Keefe's
helpful,
phone now.
even if you're only trying to isolate a certain point in time?
It can be, yes.
Does it
Why?
help
Just ask why did you do that?
determine whether or not it was working properly? If it was,
It can determine whether it's working properly. It can determine an average kind of walking speed, for example, of a person, the average gait that the person may walk with, if that was important.
if a person has an iPhone and they're moving and it registers Apple Health data, and then they stop moving, and the healthcare data doesn't register because there's no movement, would the Apple Health data
We might not
resume
get to cross
movement
today.
even if somebody else
We
picks
may
up
not.
the phone?
It would. The phone itself doesn't care who's carrying it. It just looks for movement.
So it doesn't identify the owner in order to register movement?
Correct.
Your Honor.
Does it identify the owner in order to register
Better
movement?
question.
It doesn't, no.
We might not get to cross today
Could
because
you
it's a
turn to
half
the
day
next,
and then ARCCA.
part of the data analysis that you did,
So,
Yes.
please.
So the two sources that I got the Apple Health data from were a database called healthdb_secure.sqlite. This, as I said earlier, is the typical database that's used to store long-term information about the health activity that's been recorded. So this database can have years worth of steps taken, flights climbed, and any other kind of health data that's been recorded. The downside to that is that the information's aggregated, so you see chunks of time and multiple activities can happen within those chunks of time. The cache encrypted C .SQLite database is much more temporary, but is much more granular, so we can see exact times that flights were climbed, for example, or at least you can see the exact time that the flight climb was recorded to the device. And then that information is aggregated into the larger chunk of time. So again, we might see within the cache encrypted C individual flight climb events that occurred, for example, 30 seconds apart. But by the time that information is written to the Health DB Secure, you're now looking at a 10-minute time period with 3 flight climb events, as opposed to 3 individual flight climb events with individual timestamps. Typically, that source is not used because the data is not stored there for very long. The information that I found on John's phone
there's no
was
question
essentially
pending. What are we?
these 5 records.
Okay,
So
we're
between
just-
11 minutes and 9 seconds and
We're
21
rolling.
minutes and 5 seconds, there were 170
rolling.
steps recorded by the device.
Mr. Whiffin, I'm going to stop at each one.
I'm going to stop too because we're going to switch feeds because this is where the other feed picks up. So the things that we missed were his opinion. So I'm glad we actually found a feed to back up and get his opinion, even though it does not have closed captioning. So we're going to switch to the other feed that does have closed captioning. So if there's a little bit of overlap in that question, that's why. So because I wanted to switch to the feed that had closed captioning. So let us switch real quick. So if there's a little overlap, this is why, because I couldn't quite tell what they were talking about. I just saw this slide. So hopefully it's pretty early on in this part. Now we are going to the health data. Let me move me out of the way. and grab, there we go. So we have, it would help to have this all on one chart, right? It would be incredibly helpful to have this all together. But we'll see if that happens in closing. Maybe
19 minutes and 30 seconds-ish.
Wait, no, I wanted a screenshot of that. Damn it. Are we going back to that slide? All right, hold on. We're going to be switching feeds back and forth until we get a full answer. So give me 1 second, because we didn't even get half of an answer on that one.
I'm going to ask you some questions. At the time period,
I'm going to let the questions roll.
12/21/05, you don't have any independent information where John O'Keefe or his cell phone were, do you?
The location data that I showed to begin with on Washington Street was around 12 minutes after midnight. So the presumption is that's where the location was at that time. And then 21 minutes and 5 seconds, the device had already started using Waze. It was already driving along Denham Street or had turned onto Maplecroft.
What time did you say that Waze was initiated?
It was approximately 19 minutes and 30 seconds-ish.
Thank you.
Okay.
Again, we see at 21 minutes.
Now we can get back to our closed captioning. I hope that was helpful. That was helpful for me. But again, I would love to see it laid out more clearly. The way that they did with the text messages and missing calls and made it a summary exhibit where they overlap those things together. So
again, we see at 21 minutes and 10 seconds.
The jury's going to be flipping back and forth in their notes.
There are 80 steps recorded. And again, if you compare this to the location data, we know that the device was in a vehicle at this time. Between 22 minutes and 14 seconds and 24 minutes and 37 seconds, we have 3 flight climb events that are aggregated into that time period. And again, the location data shows that the device was traveling in a vehicle at that time.
Mr. Whiffin, you had showed us a slide of 2437 on January 29, 2022 in your PowerPoint presentation, noting at that time, 12/24/37, the phone in the car was still traveling at 1.4 miles per hour.
Correct. This is about a second before it came to a stop.
Can you conclude to a reasonable degree of scientific certainty that that period of 12/22/14 to 12/24/37, Mr. O'Keefe, or at least Mr. O'Keefe's cell phone, was still in that car?
Yes, the location data shows it was in the car at the time. And my next few slides will demonstrate why that was still recording a flight climb event while it was in a vehicle.
Thank you.
At 31 minutes and 56 seconds until 32 minutes and 16 seconds, there were 36 steps recorded. And then there was no further health activity recorded on the device for several hours until 4 minutes after 6 a.m. When 432 steps were recorded between the time of 6:04 and 6:11.
Let me ask you about that 12/31/56 to 12/32/16 time period. We can see larger ranges in the time period range. That is a smaller range comparatively.
what?
Yes.
At 12/31/56, is that the beginning of the 36 steps?
I hope the jury still has this up
Essentially, yeah, it
on the
takes
slide.
the timestamps from the cache encrypted C, looks at when the first step occurred, looks at when the last step occurred, and aggregates the times based on that.
So 12/32/16 would be the last steps taken for that cell phone.
Correct.
And in between that time period, there's 36 steps. You shared earlier that it doesn't indicate the direction of the steps.
Correct.
Other than the movement that equates the steps, can it tell anything about what direction, the positioning, how the phone was moving?
It can't, no. It's just purely registered what it thinks are 36 steps.
Could it have been a straight line?
It could have been a straight
Could it
line.
have been somebody
Oh my God.
pacing?
It could have
Okay.
been.
Could it have been somebody moving and jumping?
Okay.
Yes. Jumping, if they were jumping forward, essentially.
After 12.
When did Apple Health implement fall detection? I have questions.
32/16, when this phone took its last steps, it never moved again?
Objection, Your Honor.
Form of the question, sustained.
After 12:32:16, when this phone took its last steps,
Well, the phone didn't
did
take
it move
steps.
again until 6:04:01
The data
a.m.?
speaks for itself.
There were no more steps or flight climb or any other health activity recorded during that time.
Do you know what triggered movement at 6:04:01 a.m. of Mr. O'Keefe's cell
I
phone?
probably did ask this last
I
time.
presume that the device was moving at that time, but I don't know the details of who.
Objection, Your Honor. Move to strike on.
I'll strike it.
Please continue.
Okay.
I probably did ask
Regarding
last time
the
about the fall
flight climb
detection.
events, looking at the cache encrypted C database, I was able to find more granular, accurate timestamps for these records. And I showed those timestamps on this map at the position that the device was, according to the location data at the time.
I
You're
think that's
going
helpful.
back to earlier in the evening now, 12:22:14
Correct.
to 12:24:37 when the phone stopped near the flagpole.
Correct.
Okay, thank you.
So we have the first record at 22:17.
I think
flight
that's
climb
helpful.
event was recorded. I've highlighted that was a red line, and that equates to the red line that shows underneath the timestamp where the location was.
And this is what Waze is active.
Where the device was
Okay.
at that time. The second record is 22 minutes and 32 seconds, showed with a green line, which shows over here. And then finally, 24 minutes and 37 seconds after midnight, shows with an orange line down here outside 34 Fairview.
Okay.
I'd like to point out that health activity events are
That's
recorded
helpful.
upon the event completion. The device doesn't know that you're about to walk up some stairs. It doesn't know that you're halfway up some stairs. It has to wait until you've reached the top in order to detect that an altitude change has occurred. So that change only gets written to the database once the flight climb has ended. I tested approximately 8 different phones, different models, different versions of iOS, and found that on average, there was a time difference between 15 and 50 seconds between when I physically stopped walking up a flight of stairs and when the record was made. So it's just based on the time that the device takes to pull the altitude, detect that an altitude difference has occurred, and then write the data to the database.
So that's delayed.
So then I took
then.
that average data between 15 and 50 seconds and plotted it onto this graph, which also plots the
I
altitude
mean, it's
of the
better than
device
just throwing a
over
phone
time.
around and seeing what happens.
So the red line here shows the time according to the cache encrypted C database where the first flight climb event was recorded at 22 minutes and 17 seconds. Working back 15 seconds from that to say that with the gap that I know exists between the flight climb ending and when the record's recorded, the flight climb event is presumed to have occurred within this red gradient area. The altitude information on the device shows that between those times, the altitude increased from around 41 meters to around 45 meters. You may recall earlier I said that it's a 3-meter incline that Apple considers a flight climb event. Therefore, the incline that occurred within this red gradient is sufficient to trip a flight climb event. When we look at the second record at 22 minutes and 32 seconds, this is shown on this chart as a green line, and again, working back 15 seconds and beyond to allow for the tolerance, we see the green gradient area.
It's a good question.
This shows
I don't know.
an altitude change of around 45 meters to 48 meters. Again, that would be sufficient for a flight climb event to be recorded because we have 3-meter incline change. We then don't see an incline change for a while. All we see is the device going downhill until we get the record right at the end there at 24 minutes and 37 seconds. And again, working back around 15 seconds to the orange gradient, we see an increase from around 25 to 28, 29 meters. Again, that would be sufficient to cause a flight climb event to be recorded.
I'd like to ask you
Sorry, I'll go
to
back.
continue, and then I'll ask you, please.
Okay.
Okay.
I then compared that information to
What?
a topology website from the area, according to a topology website data, and plotted that out here.
What
We
topology
see,
website data?
The red circle now is related to the first flight climb, the green circle to the second flight climb, and the orange circle to the third flight climb. The gradients that we see here are the same gradients that were shown on the previous graph. So the presumption is that within this red gradient is where the flight climb event occurred. Within the green gradient here is where the second flight climb
you
event
can't see
occurred.
it 'cause there's
and within
numbers
the
on it.
orange gradient here is where the third flight climb event occurred. The white circles show the altitude of that particular location according to the topology website. So again, we see that for the red gradient, there's an increase from 43 to 47 meters.
I appreciate that the data is now
Between the
coming together
green gradient and the
in a chart to show how all the data
the green number 2
work together.
Again, we're going from around 47 to 50 meters. And then with the orange gradient at the bottom, we've gone from around 26 to 28 meters. So fairly consistent with the data that was recorded on the device in terms of altitude information. And I would suggest is the reason that these flight climb events occurred.
Sir, you're the expert.
Mr. Whiffin, there's 3 different times.
I don't
The
want
first is
suggestions. I just want to know what you know.
12/22/17. At that time, was the Waze data app initiated?
It was.
I think that's
Did
helpful.
that indicate whether or not Mr. O'Keefe or his phone were traveling in a car at that time?
Appeared to still be traveling in a car.
At 12/22/32,
I think the Waze
was the
data is
Waze
helpful.
data initiated and active?
It was, yes.
And at that time, does the data indicate that Mr. O'Keefe's phone was in a vehicle and moving?
It does.
And you showed us a slide finally from 12/24/37 that the vehicle was still moving 1.4 miles per hour.
Correct.
And was the Waze data initiated and active at that time, 12/24/37?
If I remember correctly, Waze had closed about 5 or 10 seconds earlier.
Now, based on your study of the Waze information, the location information, the topography, and the healthcare data, do you have an opinion to a reasonable degree of scientific certainty
That's leading.
whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was
There's gonna be a
registered as
whole
result
objection
of
to
a
that.
person holding a phone, walking upstairs, or for some other reason?
Based on the location data, the health data, and the research that I did and the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus the location data being incorrect and the person being walking up physical stairs.
Thank you.
I don't understand why we're not just saying, do you have an opinion
continue, please.
Okay.
regarding
So I'll address the idea of 3 clocks,
their
which I believe was brought up previously.
Let me interrupt.
Sorry.
Let me ask a
Why don't
question.
we just explain to the jury how clocks work in an iPhone?
Okay. Let me just explain to a jury how clocks work. Good.
That is kind of covered in the next slide anyway.
Good.
Maybe worth just jumping ahead to that slide.
Explain the idea
what?
of 3 clocks.
Yes.
He's asking.
Essentially, there is one clock on an iPhone. It's the clock that you see. It's shown in the top corner, and all activity is related to that particular time. So when you receive a text message, the time that's shown in the database is related to the time that you can see on the phone. When you do health activity, it's related to the time that you see in the top corner of the phone. Everything is related to that time. The difference is within the current power log databases. It's a subset of files stored on iOS devices. They use what's called a monotonic clock, but it's not a clock that can actually be trusted to see when events occurred.
I'm going to start talking about the fact that they want to put a
it's the
separate
way
time
that
zone
the
on the
device
moon in a minute here.
records
'Cause
time. It's essentially a counter that's just counting seconds since the device was reset, basically. And I'm sure most people can recall a time where you would set a clock on a digital device, come back to it 3 or 4 months later, and the clock's now not quite as accurate as it was when you left it. Time starts to drift. It might drift forward and be faster. It might
if we do not get to wibbly wobbly, timey wimey, now that we're at monotonic clocks, can we just get to wibbly wobbly, timey wimey, and that time is a construct? Please. We're begging you. I don't think it's going to happen, but I'm ready for that to be the explanation versus like Tokyo Drift or whatever we're talking about. So let's get back to it.
Recall a time where you would set a clock on a digital device,
by the way.
Come back to it 3 or 4 months later, and the clock's now not quite as accurate as it was when you left it. Time starts to drift.
Look, that's why all my Tamagotchis died. I'm just going to go with that. Time drifts. It wasn't me. I'm not responsible. I set the timer on the digital device, and it's not my fault.
It might drift forward and be faster. It might drift slower and be further behind. That essentially happens with the monotonic clock as well. So you have to take the values that the monotonic clock provides and add or subtract different values, which are essentially offsets, in order to get the accurate time. And that's what I'll be displaying in this slide here. The confusion with the idea of 3 clocks, I believe, comes from the way that Magnet Axiom product displays power log data.
Yes, we're going to get into quantum physics in a minute,
monotonic
chat.
date and
Don't
time,
worry.
a baseband date and time, and a display date and time within the power log records. As an examiner, it's really good to see this data and understand how the tool is determining these values.
The tool being Cellebrite.
As an examiner, it would be really bad to look at these values and think that they are accurate timestamps at face value, because they aren't. And I'll start to talk through how this information works. So the other thing that Axiom shows, as well as the monotonic baseband and display times.
Totally on me. The tool they were talking about is Axiom. They switched streams on talking about tools. My brain didn't jump the track with them. So apparently we switched from talking about Cellebrite to talking about Axiom. I don't know if he made that clear, but that's where we're at.
Is they show the location where this information came from. In this case, we have 2 tables. One is called PL Springboard Agent Event Forward S Block. And that is what this table is here. And you can see we've got an ID number, a timestamp, and a value of locked. But we also show a second table that's involved called PL Storage Operator Event Forward Time Offset. And that's this table at the bottom here. So again, we see there's an ID, a timestamp, baseband, kernel, and system values. These values all need to be read together in order to make sense of the data. So for example, if I take the timestamp that's shown here, the 1643 33687 number, if you treat that as number of seconds since the 1st of January 1970, it's what we call a Unix epoch. That will get you the timestamp of 29th of January 2022 at midnight, 21 minutes and 27 seconds once you account for the UTC minus 5 offset. And you'll see that that is the same timestamp that Axiom shows here as the monotonic time, 12:21:27. What we need to then do is take that monotonic time and add it to the baseband value that we see in the time offset table. So now we have a value of 1643 3687.14954, and we add minus 183.
I'm real glad I got some coffee.
This number is here to get this value. If we treat this value as number of seconds,
I told you I'll
since
send
the
you an
1st
app
of January
notification when we move
1970,
on.
then we get a time of 18 minutes and 23 seconds past midnight on January 29th, which is also the time that we show here as the baseband time. Finally, we can take the monotonic time and add the minus 181 seconds shown in the system to get this value, which equates to 18 minutes and 25 seconds.
The jury has no context for why this matters yet.
On the 29th of January, which is the same as the display time.
They're trying to explain points the defense is going to make in cross before the defense makes them in cross, so the jury has absolutely no context for why we're talking about the time-space continuum. None.
Yeah.
None at all.
So all this is
Just
essentially doing is
none.
saying that the counter that is built into the iPhone is registered the time of that we see in the top, the monotonic time. This is not necessarily the time that the event happened. You have to offset it with this value here in order to get the actual time that this happened. My own personal phone, when I was doing this testing, the time difference between the monotonic time and when something actually happened was over 2 weeks. There was a massive difference because my phone has been drifting so far since I originally bought and set up that phone. And again, when I was testing this, I can turn the flashlight on, turn the flashlight off. Both of those activities are recorded in the power log database. If I just look at the monotonic time, it's off by over 2 weeks. If I do this process to calculate the correct offset, it shows exactly when I turned that flashlight on and when I turned that flashlight off. The calculation is imperative. Without the calculation, these timestamps are irrelevant.
Okay.
And all Axiom is doing here is they're showing you the values that they use in
The
order
jury is
to
ready to drift into
calculate
lunch.
the
Yes, they
final
are.
value. It doesn't mean that you can take the monotonic timestamp and read anything into it. It's completely irrelevant on its own.
Thank you,
Is it
Cindy.
necessary
We
to
have time
understand
warped
this
together.
process in order to ensure the integrity of the time that you're offering
just
to
a
the
jump
jury,
to
so
the
you
left.
understand whether it's accurate or
And
not?
then a step to the
It would be if we were discussing power log data. Power log data only really encompasses things like battery level, the time and date that it's plugged in, button presses, camera usage, things like that. It doesn't count
Buttons.
for location data. It doesn't count for Apple Health data. They both work on the system time. And they both work on the same system time. So they're always going to be aligned.
Do you have an
Location
opinion
and
to a
health
reasonable
work on
degree
the
of
system
scientific
time?
certainty as to the accuracy of the location data times and the accuracy of the health data times that you shared with us?
They'd be consistent with each other.
Okay.
So to summarize that, there's only really one clock that's in use on an iPhone for recording. The only difference is the monotonic time, which is how power logs record information, but you need to offset the times to figure out when that activity actually happened. And that you only have to offset those times for power log data, not for health, not for location, not for messages or photographs or any other activity like that, purely power log data.
Is there
Okay.
another subject that you looked at, that you analyzed in order to reach a conclusion about the time and location of John O'Keefe's cell phone over the night of January 29, 2022?
Yes, the next one is battery temperature.
Yay!
Can you explain a little bit of background on this before you start the
Yes.
slides?
We're
So
ready
again,
for battery
we have a
temperature. We want battery
sensor
temperature.
built in within the phone, monitoring for if the battery temperature increases too high and becomes a danger, or if the temperature gets too low and becomes an issue.
Batteries don't like
So
cold.
it constantly monitors the temperature of the battery and records that information in the Knowledge C database.
Did you look into the battery temperatures from before midnight and after midnight and do an analysis regarding the temperatures of that cell phone battery?
I did, yes. Throughout the evening of the 28th of January and then the morning of the 29th.
Mr. Whiffin, that's going to be hard to read. Is there any way you can enlarge it?
And biggin!
Apparently not like that. There we go.
Thank you.
And biggin!
So on the evening of the 29th,
Oh,
sorry,
I
the
just want
28th,
this whole thing. Can you just, can we
see
just
an
have
average
this?
temperature of around mid 80 degree Fahrenheit. I've got no understanding of where the device was at this time, whether it was in a pocket on a surface, whether it was in use or not. But I just wanted to get an average idea of temperatures of the device. By 13 minutes after midnight, we're still at 82 Fahrenheit. At 22 minutes after midnight, we know from the location data that the device was currently in a car, and we see the temperature has dropped to 77 Fahrenheit. By 37 minutes after midnight, we now know the device is already at Fairview. It's been at Fairview for approximately 12 minutes. And the temperature has continued to drop. It's now 72 Fahrenheit.
Mr. Whiffin, if I can interrupt you. At 12:37, when the temperature drops to 72 degrees, is that before or after the healthcare data stops for that evening?
That's after.
Thank you.
45 minutes past, the temperature's dropped to 66 Fahrenheit. 53 minutes past, it's dropped to 61 Fahrenheit. 7 minutes after 1, it's dropped to 55 Fahrenheit. At 1:36, it's dropped to 50. And then we have a large gap in the data, with the next record being made at 6 minutes after 6 a.m., when the temperature is 43 Fahrenheit.
Mr. Whiffin.
I think the jury has perked back up at this part.
Phone has any protection or
Very
coverage.
much so.
Well, let me ask it this way. Do you know what, if anything, happened around 6:02, 6:03 to trigger that 6-degree drop in temperature?
I don't know. Accurately, no.
Okay.
Right,
And
he
then
doesn't have a
you're now
case
at
file.
6:14 and it's 37 degrees?
Yeah, you're correct. This
You
is the
know-
coldest temperature recorded.
Do you know what, if anything, happened to that phone at 6:15:01?
I don't know.
Okay, please continue.
And then, as of that point in time, from 6:35, we start to see an increase in temperature to 43 Fahrenheit. At 6:40, it's up to 50 Fahrenheit. At 6:48, up to 55 Fahrenheit. And at 6:56, up to 61 Fahrenheit. And then also plotted this out onto a graph just for visualization. Again, we
Okay.
can see
Can we
on
see
the
the
evening
graph?
of the 28th, the temperature is relatively consistent. It starts to drop as we know the phone is traveling in a car. And by the time it arrives at Fairview, we only see it drop until 1:36 a.m. We see a relatively modest drop over the next few hours, but no records recorded. We see the final drop at 6:14, and then we see an increase. But there are no increases occur prior to 6:14 that would suggest that the phone went from a cold environment to a warm environment or
Until
had
6:35.
extensive usage.
Between 1:36 a.m.
I
and
hoped he was going to
6:06
ask
a.m.,
that. What's the phone
is there
doing?
any indication at any time that that battery temperature went up?
No, there's no records related to battery temperature at all for that time.
Do we know why?
Thank you. Is there another area that you looked at for your conclusions in this case?
Yes, I was looking at device usage.
What is device usage?
Information about when the user unlocks the phone, what applications they're using, what they're using the device for, and when they lock the phone again.
Would device usage require an actual person to interact with the phone, or can it happen without user interaction?
Everything that I was looking at was related to physical interaction and manipulation of the device by a user.
Please continue.
So the three sources of data that I used for this were Knowledge C, a database I mentioned earlier that logs lots of different activity, including device unlocks, device locks, applications that are on screen. The current power log, which I mentioned, which can track button presses. So specifically when the lock button is pressed and the times that I display have been offset appropriately. And unified logs, which is essentially a list of almost everything that's happening on that phone for a short amount of time. But it would be used, for example, if you had a problem with your device, took it back to Apple because it was crashing all the time, for, let's say, they could look at the unified logs and figure out, well, what's causing these crashes to occur. So really granular. We see that at 12 minutes and 52 seconds after midnight, the device is unlocked using biometric Face ID. The SMS application is on screen for about 5 seconds before it's closed. And then the user presses the lock button at the side of the device to lock the phone. At 13 minutes and 54 seconds, biometric Face ID is used again, and the SMS application is opened. And at 14 minutes and 29 seconds, the lock button is pressed again, causing the device to lock. 15 minutes and 46 seconds, the device is unlocked using Face ID. The SMS application is already on screen because that's the application that was on screen when the device was locked. And the device is locked again at 16:03. At 17 minutes and 59 seconds, the device is unlocked again using Face ID. The SMS application is still on screen from before. And at 18 minutes and 12 seconds, the lock button is pressed, causing the device to lock. At 18 minutes and 25 seconds, the device is unlocked using Face ID.
Much more information than we had
The
last
SMS
time about the
application is
phone
already on
use.
screen from the previous usage. And at 18:31, the SMS application is closed. At 18:34, the phone application is opened by the user actively pressing on the phone icon on the home screen. At 18:36, they're now in a call, and this causes a different screen on the phone. And at 19:23, that phone call ends. At 19:29, the Waze application is opened by the user pressing on the icon on the home screen. And that's open for approximately 5 minutes, closing at 24 minutes and 26 seconds.
No, it's
2
true.
seconds
Mama Bear
later, at
said we
24
had
minutes
it,
and
but
28
Lolly didn't
seconds,
make
the
it clear.
device
That's
is
true.
locked by
It
the
is
user pressing the
much
lock
more
button
clear
on the side of the phone.
It's going to be interesting if they do this
At
for
24 minutes
her
and
phone as
59
well.
seconds, the device is unlocked using Face ID. The SMS application is
the
opened
defense probably
using
will.
the icon on the home screen. And at 25 minutes and 9 seconds, the lock button is pressed by the user to lock the device. At 27 minutes and 45 seconds, the device is unlocked using Face ID. The SMS application is already on screen. And at 27 minutes and 50 seconds, the device is locked using the lock button. 29 minutes and 52 seconds, device is unlocked using Face ID. SMS application is already on screen from the previous usage. And at 29 minutes and 53 seconds, the lock button is pressed to lock the device. 32 minutes and 4 seconds, the device is unlocked using Face ID. SMS application is already on screen from the previous use. And at 32 minutes and 9 seconds, the lock button is pressed by the user. And that is the final interaction with the device. It's the final unlock of the device using Face ID, and it's the final logged button press on the device as well to lock the device.
So the final interaction with John O'Keefe's cell phone that night
Correct, up until 6:15 a.m.
in 12:32:09 was the last time before.
So the device
phone
was
moved
locked
again the next
then.
morning.
Correct.
Is there one more area that you engaged in analyzing to help reach your conclusions in this case?
There is. During my time looking at the unified logs that were mentioned, I found a record that appeared like it could be interesting that was called Doppler. This was the pocket state that
searching
I think I
for
mentioned
Face ID.
earlier, and it detects when the user takes the phone out of a pocket, or at least removes the item that's blocking the camera. There were hundreds of thousands of records within the unified logs that I was able to filter down to just the Doppler records and to filter and aggregate down into a more digestible number,
More digestible, you
which
say.
is what's shown here. So again, whenever the device receives a phone call, or whenever the device is picked up in a particular way, the camera activates and it actively looks for a face. If it finds that the camera's blocked, it records the fact that it's in a pocket state. And it will continue to record pocket state until either the obstruction's removed, so the device has been removed from a pocket, or until whatever is calling for the Doppler check to be completed. So, for example, if I make a phone call, it will continue to check and look for a face up until the phone call ends, or the ringing ends. So in this case, at 12 minutes and 37 seconds, see a small amount of time where 4 Doppler checks were conducted. And that ended at 12 minutes 37 seconds.
What's hard about this for all of you that are in the chat going, I am so confused. And then you're seeing others in the chat that are like giving you timing information about where people were and what they were doing that you don't have yet. The jury doesn't have it yet either. I am also trying to restrain my memory from the last trial because it is more information is going to come in. The jury does not have a ton of context for this, and the chat is trying to add context to it. I understand. Chat, I am not going to add context to it as much as I can because I am waiting to see how they break down the other information because the jury doesn't have that information. So trying to take this information in a vacuum without other information, like what was Karen Reed's phone doing, without other information like was John O'Keefe receiving phone calls between 12:33:14 and 5:52 a.m. that caused there to be 26,000 records to show that the phone was in or the camera was blocked, showing it was like in a pocket or underneath someone or what have you. The jury doesn't have that context yet. So they are going to have to wait for more information to come in and then try to remember this and go back and check those times against each other, which is difficult to do. They are going to have to take notes and then try to remember what was said here or ask for readback down the road because this information is coming in earlier and they don't have other information to check it against. I think we will see some of that during cross-examination, but we will see. So I know it's hard for those of you that are like, I am so confused. What is happening? It is the prosecution's job to make this not confusing. So if you are confused, I get it. I get it. Just hang on because you want all the context at once. And so does the jury. And they don't have it based on the order of the witnesses. So we will see what questions get answered. Some of you are saying Massachusetts doesn't do readback. Well, that's going to be miserable for this jury because they're going to have, how can you not do readbacks? Don't get me started. But trying to recall all this information can be difficult. And also trying to wait to have context can be difficult because they don't have information to check this against. It's just information in a vacuum at this point.
With a pocket state cleared.
And that's where they're at, which is hard.
At 12 minutes and 39 seconds, there was a 7.5 second period where 108 Doppler checks were conducted. Again, that ended with a pocket state cleared event at 12 minutes and 46 seconds.
This jury has very little information at this point to go on.
25 minutes and 8 seconds, there was a single Doppler check that resulted in a pocket state.
No readbacks, it's wild.
And at 29 minutes and 37 seconds, for 5.5 seconds roughly, there were 97.
And for those of you who are asking, I did not answer this question. I should have. No, these are demonstrative exhibits. These are not evidentiary exhibits. The jury does not get these. The jury can get the base documents that these come from, but the jury does not get these. These are to highlight what is in the bulk of the records.
Doppler checks.
So
the 97th check resulted in a pocket state cleared event at 29 minutes and 42 seconds. At 31 minutes and 52 seconds past midnight, there was an 11-second period where 155 Doppler checks were made. The 155th Doppler check resulted in a pocket cleared event at 32 minutes and 3 seconds. At 33 minutes and 14 seconds was the start of a 5-hour and 20-minute period where 26,500 Doppler checks were conducted.
A lot of records.
Every one of those checks came back to say that it was in a pocket state. There was never a pocket state cleared event during that time. At 2 minutes after 6 a.m. And 41 seconds, there was a 12-minute period and 20 seconds where 417 Doppler checks were conducted. The 417th Doppler check showed a pocket state cleared event at 6:15:01.
Mr. Whiffin, as a result of your analysis of John O'Keefe's cell phone, considering the location data, including Waze data, and considering the healthcare data, the pocket state information, the battery temperature, did you have an opportunity to create a timeline putting all of these different important pieces of data together so you could show them
Oh, thank God.
to the jury in chronological order?
I did, yes.
Would
Oh,
you share with us now your timeline and explain it for us?
Of course. So again, this combines all of the information from the previous slides, just showing it all within a timelined view.
oh, thank God.
So at 18 minutes and 25 seconds, the device is unlocked using Face ID. We see the SMS application is in use.
I was hoping we would get to a timeline of some sort.
Around 11 seconds, a phone call is made from John to Jennifer McCabe. Phone call lasts 36 seconds, starting at 18 minutes and 47 seconds. That call ends at 19 minutes and 23 seconds, and the mobile phone application is closed at 19 minutes and 24 seconds. At 19 minutes and 29 seconds, the Waze application is loaded on screen. And at 20 minutes and 49 seconds, which is what this location on the side relates to, we see an incoming message from Brian Higgins saying, "You coming here?" At 22 minutes and 14 seconds, this is the start of the 3 flight climb events as the device is driving along Oakdale Road, I believe that one is. At 24 minutes and 26 seconds is when the Waze application is closed and the device is locked via the lock button at 24 minutes and 28 seconds. At 24 minutes and 37 seconds, the three flight climb events comes to an end. And at 24 minutes and 38 seconds
or
is
the phone
the first
stops
record that shows a
registering
speed of 0 meters per second. At 24 minutes and 59 seconds, the device is unlocked using Face ID, and the message, "You coming here," is read at 25 minutes and 8 seconds after midnight. At 25 minutes and 9 seconds after midnight, the device is locked using the lock button. At 27 minutes and 33 seconds after midnight, a text message is received from Jen McCabe saying, "Here." At 27 minutes and 45 seconds after midnight, the device is unlocked using Face ID, and the "Here" message that was just received is read at 27 minutes and 48 seconds. At 27 minutes and 50 seconds, the lock button is pressed by the user, causing the device to lock. At 29 minutes and 37 seconds, we start to get some Doppler checks, and at 29 minutes and 42 seconds, the
What
pocket
happened
state
on that
cleared
answered
event
phone
is,
call?
Written. At 29 minutes and 44 seconds, there's an incoming call from Jen McCabe. This is answered and lasts for 7 seconds, ending at 29 minutes and 51 seconds. At 29 minutes and 52 seconds, the device is unlocked, and a second later, the lock button is pressed, causing the device to lock again.
This is a much more clear
31
presentation of
minutes and
this
47
info.
seconds after midnight, a message is received, again from Jennifer McCabe, saying, "Pull behind me." And at 31 minutes and 52 seconds, the Doppler check records a pocket state. At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. And at 32 minutes and 3 seconds, there's a pocket state cleared event. At 32 minutes and 4 seconds, the device unlocks with Face ID. And again, I'll point out that makes perfect sense if the Doppler state clears, because it's no longer within a pocket, and then it unlocks a second later.
Right.
That
Because it was looking for a face.
makes sense with the logic
Okay.
that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message "Pull behind me" is read. 32 minutes and 9 seconds, the messages application is closed, and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that
The
all
jury doesn't
record
know about all
pocket
these
state.
calls yet. This is the first they're
This
seeing
is
this.
followed by several phone calls at 33
Several.
minutes and 35 seconds, 34 minutes and 9 seconds,
Few more than
34
several.
minutes and 38 seconds, 35 minutes and 9 seconds, 35
This is the first time
minutes
they're
and 35
hearing
seconds,
about all these calls.
and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered, and all resulted in pocket state being detected by Doppler.
Right.
At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in pocket state being recorded by Doppler function. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler. 37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler pocket state being detected by Doppler. And I've also shown some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying, hello. This is the first iMessage or SMS message received by the device, which is unread. This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, where are you? And at 42 minutes and 35 seconds, there's a 40-second voicemail received from Karen. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere kind of around the flagpole area. 55 minutes and 31 seconds, a message received from Karen stating, I'm going home. 55
And this, again,
minutes and 50
is the
seconds,
first time that the
follow-up
jury's hearing
message
about
saying, see you later.
these messages. We didn't get through
Another
these
location
in other
data, this is the
testimony
location
yet.
that's shown bottom left. And at 2 minutes past 1 a.m., another message from Karen saying, your kids are cooking alone.
I hate it when iPhone doesn't spell fucking correctly. It's really annoying. Nobody ever means ducking. I mean, except on a very rare occasion.
John O'Keefe's cell phone. Keeping in mind some of the data points you shared with us, that
Why do you get quiet all of a sudden? Brennan, where did you go in the courtroom, Brennan? Because all of a sudden I can't hear you at all.
Keeping in mind some of the data points you shared with us,
I had to gain him back up for the
that
first time
the
today.
wave was initiated around 12:19. That the car reached the flagpole around 12:24:37. That the only health data during that later time near 12:30 was from 12:31:56 to 12:32:16. That the last interaction was at 12:32:09, followed by an
go.
overnight pocket state, and an increased reduction in
Objection, Your Honor.
I need to hear the question first.
Well, he's objecting because,
including a increased reduction in the battery temperature.
sorry, I can't hear him at all.
Do you have an opinion to a reasonable degree of scientific certainty that after that phone stopped in the car at the flagpole area of 34 Fairview, whether or not that cell phone remained near the flagpole the entire night until after 6 a.m. the next morning?
Objection, Your Honor.
I'm going to allow it.
The location data,
Question was awkward.
the location data that shows accurate tends to show around the flagpole area. There's no further health data other than 36 steps that were taken that suggest that it moved after 32 minutes and 16 seconds after midnight. The battery temperature data never indicates that the device went from a cold environment to a warm environment, which I would expect to see if the device went inside a building. And the Doppler state information suggests that the camera was blocked for at least the majority of the 5-hour period, with no records showing that the camera was unblocked during that time, which would typically happen if you were to pick a camera up and move it around.
Does that lead you to a conclusion to a reasonable degree of scientific certainty?
Yes.
Whether that phone remained in the flagpole area from around 12, 24, 33,
So
until the next morning at 6 a.m. or after?
That's
the
my opinion.
objections sustained. Ask the question in a different form.
Do you have an opinion where John O'Keefe's cell phone was from around 12:24:33 on the evening of January 29, 2022, through at least 6 a.m. and after that morning?
Yes. Based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
I have no further questions. Thank you.
Wow.
Mr. Alessi?
We are getting to cross today.
Okay. Jurors, feel free to stand up.
Will you let our lovely Law Nerd app community know that we have gotten to cross, even if it's just for a little bit? I'm going to zoom past this. I think the timeline was a good representation of the data, much better representation of the data, and much more information than we saw in the first trial. Also, I know a lot of you know a lot about this case, but this is all the jury knows at this point. If you are sitting on this jury, you are seeing the battery temperature decrease from when the car stops at Fairview based on the Waze data. You are seeing a timeline, and we haven't gotten across yet. You are seeing a timeline for the stare data that he said was when John O'Keefe was in the car. We know from the previous trial that defense will be challenging this. But what the jury is sitting there with at this moment is that they have seen the not the O'Keefes, they have seen where John O'Keefe was at the Albert House, and now they are seeing all the cell phone data together. If you're sitting on the jury, you're like, well, the battery temperature doesn't warm back up. And if they understood the pocket state information, you're seeing that there's this massive swath of time where the camera of the phone is covered. And from Carrie's testimony, the jury knows that she picked up his phone from underneath him on the ground. We're going to get to other witnesses who talk about how unusual it would be that someone's phone is lying underneath them in a vehicular collision situation. We're going to get there. We're not there yet. I think this jury is sitting there probably taking away what is the most clear. I think that timeline at the end was clear. How compelling will they find it? It's going to depend on cross. But right now, that is a pretty clear timeline. I know a lot of you are like, but, we're going to get there. We'll get to all the buts. But remember, the jury is seeing this information through the perspective of the Commonwealth at this time, and then they only have cross-examination. The case will change as we get into other witnesses. But for now, that timeline is a very interesting timeline, adding in all of the battery data. I think it's really interesting to see. All right, let us zoom into cross-examination. I know that's what y'all are waiting to see. So let's get into cross. This will be the only witness today. Cross is not going to finish today because there's a whole voir dire of the ARCCA witnesses this afternoon. we're getting into cross. We're not going to get through it all today. For those of you that didn't watch the first trial, do you think the timeline was helpful to understand what John O'Keefe's phone was doing? This afternoon will be streamed, so we're going to watch this afternoon as well. Alessi's like, hold on. Let me, like, he's just like, let's go, buddy. He's like, he's stretching. He's like, let's just like, oh. I wonder if the witness is getting more nervous watching Alessi pull out these binders. He's like, hold on. Hold up.
Your Honor.
Wait a minute.
May I proceed with the
Yes.
administrative matters? May I approach?
Yes.
Thank you.
He's like, just wait a minute, y'all. Just wait
Your
a
Honor,
minute.
pursuant to a stipulation with the prosecution, I would like to mark and enter into evidence 3 documents. These are each portions of a March 2025 report prepared by Mr. Whiffin. The first one.
So, yes, they can come into evidence. They can come into evidence. There's a stipulation. So
And
we
so-
can mark it as the next exhibit.
If we could, that's page 29 for the next exhibit. Separately, please.
I know for those of you that watched the trial before and know a lot about this case, it's hard to look at it through the eyes of the jury because you have so much more information. And when the Commonwealth says something, you're like, yes, but this, yes, but that. I know. But
The next exhibit will be pages.
I think what we can underestimate when you know what's coming in this case is how persuasive this information can be as it comes in. That might change as you get to other witnesses, but don't discount how persuasive hearing Karen Read talking about her own drinking and driving can be. Hearing how the cell phone battery is getting cooler from the time they get to 34 Fairview and continues on. That can be persuasive information. The defense has an uphill battle with some of that information, especially because the jury is going to clue very much into the things Karen Read says in those clips. So, again, long way to go in this trial. But the Commonwealth is ordering their case so that these good pieces of information for them stack up at the beginning. Notice we have not seen very many law enforcement investigators in this case yet. That's not by accident. That is completely by choice. They are putting in their most persuasive information before we get into all of the shit show that are the investigators. So for the jury, they are having to go with this day by day, waiting for the wheels to come off, which y'all know is coming if you've watched it before. So it's going to be very interesting to see how this cross-examination goes. So let's get into it as they're marking exhibits.
77 and
Let's just do it.
78 of the same report.
Okay.
Exhibit 41.
Lily asked, do they have a motive? I don't know what they're going to argue this case. I'm going to wait and see.
The
gonna wait and
third
see.
and last is page 43 and page 44.
So we'll see.
Okay, all set.
Thank you, Your Honor.
I appreciate that he just marked them at the beginning. Thanks for zooming, Alessi. I know all of you are sitting here like,
May
the
I, Your Honor?
anticipation, the anticipation.
Good afternoon, Mr. Whiffin. I don't believe we've had the pleasure of meeting.
Good afternoon.
Cell phone data, when correct and when correctly analyzed, can help tell a story of what may have happened under various circumstances, correct?
Correct.
And in cases like this, literally seconds on cell phone data can be significant, correct?
Correct.
What I'd like to do is to go back to your PowerPoint presentation and specifically go to the timeline that you had gone through with Mr. Brennan, and rather than repeating everything, there'll be select aspects of the timeline.
I like starting
I'm
with the
going
timeline
to
that
reference,
they just saw. I
And
think
with the
that's
court's
a good
permission,
place
we
to
will
start.
put the timeline back on that's already in evidence.
Okay.
Oh, so they
Thank
are
you.
putting the timeline in evidence. Great. Good to know. So these chalks are going into evidence.
So what I'd like to do is to
That's a good point
start
of clarification.
with page 70,
So
which
they're
we
gonna
have
put them in
as
as summary
78 of
exhibits.
the deck. If you could, Mr. Wolfe, go to that. And what I'd like to do, if I could please, Mr. Whiffin, is draw your attention to the very last entry, which says at the bottom, location 122438, and it indicates description, first location record
I'm
showing
going to have to
speed
gain
of
Alessi
0.
down, which is
You
rare.
use that, sir?
I do.
That's better.
And this is the arrival of John O'Keefe's phone at 34 Fairview, correct?
Correct.
We could go to the next page, please.
I wish these
We have
pages were
up
numbered.
at the top,
They are not.
12:24:59, about 21 seconds later after arrival, we have device unlocked with Face ID, correct?
Correct.
Is it possible for anyone other than John to unlock that device with Face ID?
If a secondary
Only if
user
another
was set up.
profile is stored.
Do
Well,
you
what's
have
one?
any indication that a second user was set up on John's mobile phone?
I never looked at that.
I'm sorry,
I never looked to see if a secondary user was set up.
in terms of the next entry, 12:25:08.
Don't you have the whole download though?
It says, read message, you coming here?
Never looked.
With 3 question marks. What I'd like to do, because you did not note who that was from, but I want to go back a few slides so we can identify who that message was from. We could go back to 76, please, Mr. Wolfe.
Yes.
So in the last line there, message reading left to right 12:20:49, it says message received from someone listed in context as Brian Higgins. Do you see that?
Correct.
So if we could go back to slide 80, excuse me, if we could go back to slide 79, that phone reading the message, you coming here, is reading the message from Brian Higgins, correct?
Correct.
But you didn't note that in the timeline that was from Brian Higgins, correct?
No, I was just highlighting the fact that a message was read and that the contents of the message were you coming here.
But you didn't note in this entry when it was read by John that message was from Brian Higgins, correct?
Correct.
Now, the next entry, lock, again, I'm always going to be reading left to right unless otherwise indicated, sir, is a time of 12:25:09.
So Reddit
And-
locked the phone.
It says device locked with lock button.
Yes,
You see that, sir?
I do.
That requires human volitional conduct. In other words, someone has to actually manipulate their phone and hit it, right?
Correct.
Now, at this particular point, isn't it correct that in your report that you mentioned in your March 2025 report, that you had more of a description of what was happening at this time with the phone, namely, device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Isn't that what you had in your report?
Yes, and that's covered in the location section of this report, the PowerPoint.
So there is no statement in this timeline under any type where you had concluded that at this time the record showed that the device was moving west from the roadside towards the house, correct?
The location, latitude, longitude was moving westerly, but at the same time, the accuracy was increasing. So it didn't intrinsically prove that the device was moving.
My question, Mr. Whiffin, is straightforward
Okay.
in this sense that I'm just looking for an answer of whether
It was in the
on this timeline
previous
you
slides.
included
No, it was
the
in the previous
analysis
slides.
that you had in your report.
It went fast, but it was in the previous slides. It was not in the timeline. So it was addressed on cross. So all of you were like, wait, no, it was addressed on direct. I think that Alessi is doing a good job of highlighting it because a number of you were like, wait, what? Right.
That the device at this time was moving west from the roadside towards the house. Did you include it in that timeline?
No, I left that out of the timeline.
Not in the timeline.
Next entry, 2733.
Right. They
That's
they
12/27/33.
He explained it and moved on.
You note that there's a message received from Jen McCabe. Here, exclamation point, question mark. You see that, sir?
Correct.
Now, at this point, you have two people
He explained why he
in
left it out of the
just
timeline in the first
2.5
answer,
minutes.
if that helps.
Brian Higgins and Jen McCabe tried to find out if the John is coming to 34 Fairview. Is that a fair conclusion?
It appears so.
I'll allow it.
Is that a fair conclusion?
It would appear so, yes.
So just because of the colloquy that occurred, I want to repeat the question. Now you have, at this point, at 12/27/33, you have two people, Brian Higgins and Jennifer McCabe, in just 2.5 minutes, trying to find out if John or the phone is coming to or if John is coming to 34 Fairview.
Sustained. Ask it differently, Mr. Alessi.
Thank you, Your Honor. Now, at this point, you have two
Calls for
people
speculation.
trying to find out if John is coming to 34 Fairview, correct?
It also
Sustained.
calls for speculation.
Mr. Whiffin,
You have texts.
in terms
say-
of the information at this stage, there are two communications with Mr. O'Keefe on this phone, and that is
They are sent to
they're
him.
trying to find out, excuse me, I'll rephrase it. There are two
Speculation.
communications, one from Jennifer McCabe and one from Brian Higgins, correct?
Correct.
Now let's go to the next deck 80, please, Mr. Wolfe. This is 12/27/45, device unlock with Face ID, correct?
Correct.
And then right under that is 12/27/48. It says read message, which it says here. And is it correct that that is the message that was sent by Jennifer McCabe?
Correct. I'd just like to point out it says read message, not read message.
Read message, thank you. And
Fair enough.
that, the fact that Jen McCabe sent that message and that it was read was not indicated in your timeline at this point, correct?
I think it was.
So repeat that question.
Yes, you did not, it does not appear in that timeline that you've drafted that that message that was read was from Jennifer McCabe, is
Correct.
it?
Correct.
Next entry, 2750, device locked with lock button. Next entry down that, 2937, Doppler pocket state. And I want to be clear. Does Doppler pocket state mean that someone takes an iPhone? Because up above there's red messages we went through on 2748. So if somebody reads the message and then it goes at 2937 into Doppler pocket state, does that mean someone has, for example, put it in their pocket?
No.
What does it mean that's a pocket state?
So the only times that I was able to cause a pocket state to be recorded is when the camera was blocked and when the device received a phone call or was picked up in a particular way, so that the device thinks that you're about to try to use it. If the camera is not blocked from the outset, then nothing's recorded at all. And in order to get the pocket state cleared, the camera must be blocked to begin with. So,
and then unblocked.
Again, you have to receive a phone call with it in your pocket and remove it in order to get a pocket state cleared.
Thank you, because that helped me, because that's exactly where I was going with the next question, which is pocket state cleared. What did you conclude from 2937 to 2942 that it was in pocket state and then pocket state cleared?
There was some activity on the device that caused the pocket state to be checked. The device was in a pocket state up until 2942, when whatever was obstructing the camera was removed.
Next entry is a call at 12:29:44, and that you state is an incoming call from Jen McCabe. So there you do indicate the name, and you say answered 7 seconds. Correct?
Correct.
Is the phone at this time that there's an incoming call from Jen McCabe that is answered out in front of 34 Fairview?
Yes, it would be according to the location data.
Right. So now we have at 12:29:44, the phone's out in front of 34 Fairview. There's an incoming call from Jen McCabe. It's answered. 7 seconds is how long the duration of the call was. Is that correct?
Correct.
And then 12:29:51, incoming call ends, and that's end of that 7 second duration.
Correct.
So you've concluded that this was a call that was indeed answered by the user of the phone, correct?
Correct.
Now let's go to...
I think the defense is going to highlight the times that they want to use.
81, which is starting up at the top of
Because it seems like that's what we are doing with highlighting the times that the defense will want to use down the road.
There is, as you
And
indicate,
locking in
an
those times.
iMessage received from someone with a contact named Jen McCabe. You see that, sir?
I do.
Can you just state for the jury what an iMessage is?
An iMessage is essentially a text message sent primarily from iPhone to iPhone.
What do you mean
via the Apple
primarily from
service,
iPhone to iPhone?
Not like an SMS message which goes through carriers.
Solely from iPhone to iPhone.
And
Can you primarily from? Can you tell me how you can have an iMessage that is not sent from iPhone to iPhone?
Is it correct that the message that was received from Jen McCabe said from a contact?
Oh, that's
Jen
fair. You
McCabe
guys are like
says, "Pull behind me"?
iPad chat.
Correct.
That's fair. Chat said iPad, MacBook, computer. That's fair. That's fair. Thank you, chat. Because I wasn't even thinking about iMessage on the computer and the iPad. So that's completely fair. And from the watch, fair enough. From any Apple device, fair. Chat is bae. I was like, are you texting other ways? Yes. The chat is like resoundingly, yes, you are texting other ways. Fair enough.
And then at 12:31,
Told you it's a Monday.
we're back to Doppler pocket.
Fair.
Correct?
Correct.
They're like, Emily, not on this one.
Now let's go to
Any Apple device.
the next entry, which is deck 82. It's under health type. And what I want to do is see if we can clarify.
I'm glad we've gone back to what's on the
The
screen. 'cause
Commonwealth on direct
so much easier.
examination, and multiple times referred to this as healthcare data. Do you remember hearing that healthcare data term?
I do.
Is that a correct term? Is it healthcare data or?
Alessi is just going for Brennan because Brennan kept saying Apple Healthcare, and the expert kept saying health. I like that Alessi's going in on like, so can we just clarify that he's wrong?
Or is it health data?
It's health data.
So it's incorrect to refer to this as healthcare data.
Correct.
Healthcare data is encompassed within Apple Health, but primarily if we're talking about steps being taken, it would just be health data.
Right. So the correct parlance is health data.
Yes.
Correct. Particularly
Parlance
when we're
might
getting
win
to
today.
steps. Is that correct?
Correct.
It's important to be precise about the parlance.
Yes.
We'll hold parlance.
So
in
in this
abeyance.
entry 123156,
It might be where we
you
get
state
today.
that there's the start of health event,
Parlance
quote,
is in the running.
36 steps / 25 meters. Correct?
Correct.
Is it accurate to say that
Parlance is in the
because
running,
we're
we
in
still have
the
a long
United
day to
States
go.
and we don't work on the metric system, that 25 meters is about 84 feet? Are you able to make that calculation?
He's like, no.
It's approximately that, yeah.
Don't
Right.
make
Would
me
you
math.
accept approximately
Makes
84
sense.
feet? So as we discuss meters, we can go to feet and
Yes.
about 84
I would accept
feet.
it approximately 3 times 25.
Right.
So,
So,
Parlance is in the running.
in
So we'll
your
see.
report of March 2025,
Apple Vision.
isn't
I
it
forgot Apple
correct
Vision existed.
That for this
Thanks, Chad.
time, you stated that the device began moving for a period of 20 seconds, correct?
yes.
So
Alessi, do you want to move it? Move it?
again, your conclusion from your analysis is with these 36 steps, the device at this point began moving. Correct?
Yes, correct.
Next entry. 123203. Pocket state cleared. Correct?
Correct.
So does that mean that there's some human activity going on, interaction with the phone, or not?
It could have been a received phone call. It could have been movement of the phone to be lifted.
But something has happened.
But something's
correct?
happened, yeah.
Next, 123204, device unlocked with Face ID. Correct?
Correct.
And then at 123205, it states application focused messages.
Yes.
Can you clarify what that means in terms of what is happening with the phone for the jury?
Yep. So at 32 minutes and 5 seconds, the messages application was in focus on screen. So it was the application that was being used by the user at that time.
Now, the next entry is message 123206, and it states red message, quote, pull behind me, close quote, correct?
Correct.
Now, you don't indicate who that message is from in your timeline, but that's the message that was sent by Jennifer McCabe at 123147, correct?
Correct.
Next entry is application lock at 123209, and you've got here end application focus, and then you state device lock with lock button for the last time, correct?
Well,
Correct.
So that's again pressing
I don't think it says
the
last
side
time on
button
there.
on the iPhone that locks it.
Correct.
And that requires
Brennan said last
human
time.
conduct, human interaction with the phone, correct?
Correct.
And then the next entry under health data at 123216, that
Did it
is
say last time on the timeline?
7
I need to go look at
seconds
it again.
After 7 seconds
Chat said
after
it does say last
the
time.
lock, it's the end of the health event of 36
I'm gonna have to go
steps,
through the pictures.
25 meters, and as we agreed, approximately 84 feet. Correct?
Correct.
So
Thank you, chat. Your guys' functioning
in
memory
terms
is way better than
of
mine.
the steps,
It does.
I want
had
to
go back and
turn
look.
to some
Indeed.
further information with regard to your
I know the jury can see the timeline now.
Previous.
We just can't.
the report that you mentioned on direct, which is the March 2025 report. Your Honor indicated a time for the break, and I'm going to go into a little bit of different area. Would you like me to keep
All
continuing?
right, Mr. Alessi. Folks will stop.
Okay, well, we're done.
Turn on lights, please. Thank you. Mr.
And the jury is done for the day.
Jurors, we're going to recess for the day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And please be very careful with your social media use. All right? We'll see you tomorrow morning.
Mr. President, jury.
I think it was fair. Alessi asked the court, is now a good time to take the break, being mindful
I'll
of
see
time, and
counsel
she said
at that.
yes. So that's fair. We are going to get into the lunch break, and then after the lunch break, the jury will be out and ARCCA will be in. A lot of you guys are like, the judge sounds annoyed. I didn't think she sounded annoyed, but that's just me. I didn't think she was just like, yep, we're getting to the break. So I didn't read much into that, but they are going to get to the lunch break. Where are we where is the camera go? Where are we going? Well, now I'm curious. I just want to find out where we're going while everybody's standing while the jury leaves. So it looks like everybody's sitting back down, which means the jury is out and the attorneys are at sidebar. I want to hear what the court puts on the record before they go to lunch. For those of you asking about ARCCA, he's like, put those cameras. Did you see the bailiff telling them to put the cameras back up? He's like, excuse me, pool camera, put it back up. Put that camera back up. The ARCCA is the experts that were hired originally by the feds, testified at the federal grand jury. The defense used them in the first trial, and now we are going to see them testify again. ARCCA is the company they work for. They are biomechanical and biomedical engineers. We are doing a voir dire, which is to extreme OnlyFans close-up, which is a remedy of a discovery issue that the court found. So I'm going to see if the court puts anything back on the record. She might just go directly into lunch, which I think is exactly what happens. All right. So if the court is going into lunch, I am going to take a bathroom break real quick, and then bring on some snacks. They're going to take a quick lunch break. So let's see. They should be back from lunch in about 15 minutes. Am I right? Or are they back now? Hold on. Let me just double check. No, they're not back yet. So they should be back from lunch. Michelina, what time did they say they would be back from lunch? They should be back from lunch in like 15 minutes, right? So I might take 15 minutes to grab some food. I'm so tired. To grab some food, to grab some water. And then when they come back, we'll come back. The jury is going to be out for the rest of the day. So everything that happens from here will be just with the lawyers and the witnesses, but it will be an examination of the witnesses. That is what the court determined the remedy was for the discovery violation. The court said that information should have been turned over and it wasn't. The prosecution will be allowed to go into it. I don't think that they can get that done this afternoon. I think it's going to be a long afternoon because the ARCCA voir dire last trial took an entire day. I don't know how we're going to get through this in less than a day. But first thing, if you have not done it yet, now is the time to get the Lawnerd app. We built it for you. It is free. It is on iOS and Android. We can let you know when we get to the parts that you want to see. Like, hey, are we in cross-examination yet? Yes. Hey, is voir dire started yet? Yes. Hey, is a jury back? Yes. We can keep you in the loop through the Lawnerd app. Again, built it for you, completely free, iOS and Android. Yes, we have a paid community within that app, but that is by choice. You can use the app completely free to get notifications because YouTube will not notify you when things are happening in court. So for those of you asking in the chat, is more happening in court today? Yes, without the jury. So let's talk about let's lip gloss. Let's talk about where we've gotten to. let's talk about where we've gotten to at the end of the morning, shall we? Shall we? Let's do that. Let's do that. All right. We are at the lunch break on day 5, and we just tiptoed into the cross-examination of the expert from Cellebrite, Ian Whiffin. So we are right at the beginning. At the end of that testimony, though, we did get a timeline that overlaid the information that we were looking for, the health data with steps and stair calculations, the temperature, the phone having incoming calls or texts, when calls were answered and texts were read, in addition to the data from Waze and the location data when it was shared on the timeline. So we saw Alessi starting to go through the timeline, and at the beginning of cross, we did not see him challenging the timeline. We saw him, confirming certain points in time. I think those points are going to be incredibly relevant to the defense, and we see him pointing out those times, not challenging that they're not accurate, pointing out and highlighting them. We also saw him highlighting what is and is not on the timeline. Why is it here? Why did it get left out of the timeline? Alessi's not going to ask the why questions. This is cross. You left that out of the timeline? Yes. And that is where we're at. Alessi was just going to start getting into a report written in March of this year by this witness when it was time for the lunch break, because we have a whole afternoon of voir dire with the ARCCA witnesses regarding discovery. So once we get into that, we will see what happens and if that concludes at the end of today or not. Who knows what's going to happen? Because, court is dynamic. So, all of you, we still have the outstanding question of, don't iPhones have fall data? The prosecution in opening statements, and if I was sitting on the jury, I don't know if I'd be able to get past that point, but we saw the prosecution say in opening statements that John O'Keefe fell backwards and hit his head, or went backwards and hit his head on the ground. They said that Karen Reed hitting him with the car is what caused him to go backwards, but no one has asked if the phone would pick up that change in 2022. We'll see if they ask, but I know that the more modern phones have collision detection on the phone. Does the phone have fall detection in 2022? I don't know. We'll see. They didn't ask if John O'Keefe was wearing an Apple Watch. I don't know if he was. But also when they asked about the Face ID and could another profile be set up on the phone, this expert said, I didn't look. I didn't look to see if another Face ID profile was set up on the phone. Okay. Okay. So I think there are some more questions that I would have if I was sitting there, and it's hard when they don't ask. So it's tough. Sean, the 21st century viewer of this channel. Even when I was in computers 20 years ago, it was known the best color for PowerPoint is black background, yellow letters. I hate that people don't use it. I hate it when PowerPoints are not in dark mode too. Staring at the white screen is so hard on my eyes. I absolutely hate it. Tanya M. asked earlier in stream, can the jurors work on the weekends or half days since they are not sequestered? It depends on the juror. It depends on their job. And it depends on what they do. It can be difficult depending on the juror, if they can go into work, not go into work, but that's going to be up to them. They can't talk to their coworkers about the case. They can't talk to anyone about the case, but if they are able to work, if that works for them, they're not going to be forestalled from it. So let's see. We also have Emily, long time since Depp missed your commentary. Well, it's been a minute since we've had a live trial, but we did cover a few, in 2024. But it's good to see you on the channel, and thank you. I appreciate it. For everyone who gifted memberships today, welcome to all our new members. I'm sure you are loving that you are not on slow mode, especially as the chat gets busy. So with all of that, Chanty in the chat asked, how much do you get paid for jury duty? It varies by jurisdiction. I have not checked in Massachusetts, but they also get lunch. Not all jurisdictions give you lunch. So when the jurors come in and out quickly for lunch and those lunch breaks are shorter, it's because lunch is delivered for them and they can go in the jury room and eat. They don't have to go find lunch and then come back, which takes more time. So that is helpful. So for all of you that are watching this trial for the first time, we are doing our best to not spoil information that's coming. I am doing my best to give you how I see the evidence as it is coming in with what this jury knows and what this jury doesn't know, and trying to say the jury knows this and the jury doesn't know that yet, because there's a long way to go in this trial. And while a lot of us can go, okay, but we know that we should see this, we should see this, we should see that. I'm trying to keep it out of my mind as best I can. It's not easy. This is why you have jurors come in who don't have knowledge of the case, because it's not easy to check out what you know that they don't know. It's easier just a few days in the case because there's not as much information known to them. The way that this jury is seeing this evidence is so different from the first trial. And it's really interesting to watch the strategy behind that of what information is being put in front of the jury and in what order. And I think we will see. We will see. I can't tell you if I think saving some of the law enforcement stuff for later is going to help or hurt. I don't know. I don't know. If the prosecution's case in chief ends with like Proctor, is the jury just going to sit there at the end of that witness and be like, the fuck did you just say? I don't know. Do you leave them with that before going into the defense case? Does it wash all the rest of this out of their mind? Or are they still sitting there with an untainted view of this information going, well, the cell phone battery, well, Karen Reed's clips? Or by the time you get into some of that law enforcement testimony, do they all just go, I'm sorry, what? So I don't know. It'll be interesting to see. Black cat, blue chair. Can the defense call Proctor if the prosecution doesn't? Yes, they can. I think the prosecution has to. I really do. I really think the prosecution has to call Proctor. I don't see a scenario where they can not call him and have it work well. I think they have to. I really think that they have to. Ariel said, why is the jury dismissed for the ARCCA stuff? Will they get to that testimony? The ARCCA witnesses are for the defense's case. The discovery information that's being asked is information that may or may not be proper evidence in front of the jury, but that the prosecution is entitled to. And you can't put the shit back in the horse. You can't unring the bell. So if the jury hears stuff that can't come in evidence, it's really hard to put that out of your mind. We know that. How hard is it to sit here and put out of your mind things that you know from the other trial? It's not easy to do. So they don't want the jury to hear or be exposed to information that might not be proper. Proper for the prosecution to get that information, not necessarily proper to come in and trial. So the jury is out, and that's what they are going. That's what they are going to do. So we will talk about Proctor a different day, former Trooper Proctor, because I definitely need to grab some food, grab some more water, and we've got like 15 minutes. So I'm still going to give it 15 minutes. I will be back at 1:05. If court is not back yet, I will push that back a little bit or answer questions. We will let you know in the app when I am back. We are going to put on some hold music. As for those of you that are asking about witnesses tomorrow, I have not seen anything official with that. So thank you I don't share unconfirmed information until we see it. We're going to see the evidence come in as it does. But if witnesses that you are looking forward to take the stand, we will let you know in the app 100%. 100%. When we get to cross, when a new witness takes a stand, they've got a lot of cross to go with this witness. So tomorrow there's going to be, I think, more than an hour. I think more than an hour of cross tomorrow, for sure. Yeah, for sure. Okay. Are you guys ready? I'm ready for a lunch break. I'm sure you're ready for a lunch break. We're all ready for a lunch break. Give me 1 second. Let me get our lunch break music going for y'all. And then I will take a little bit of a lunch break. Y'all, I suggest taking a little bit of a lunch break. I will also play the chimes when I'm getting ready to come back in, so you will know that we're getting ready to come back in. So there will be some cues. So let's get us to our lunch break. How are you guys doing on a Monday? This is a lot of court for a Monday. It's a very Monday in court. Your girl's tired from the weekend. Why? Well, because we drove multiple states. It was a very busy weekend. Hopefully y'all had a good weekend. Okay. You ready? You ready? Let's do it. It is time for a bit of a break. Let's go, law nerds. I'll see you in a minute. Emily, just push play. I know, we're doing it. Because we're doing it. We're doing it. We're doing it well. Emily, stop it. Law nerds, I'll see you in a few. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during Verdict Watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. All right, y'all. Are we ready to go back to court? Are you ready to go back to court? I'm ready to go back to court. Trial days are long days, so I hope you guys got some snacks. I got some snacks. We'll be interspersing questions for those of you that are just popping into the chat. Hi, do the YouTubey things, the likey, subscribing, all the things, do the YouTubey things. But what we are going to do, we are going to see this question. There will be 30,000 of us asking this question. Well, there will be some. Is the jury there? No. We are doing a voir dire of the defense accident reconstruction experts. Why? The court ordered the voir dire as a remedy for the court's determined discovery violation. There was information the court told the defense they had to turn over. It didn't get turned over. The defense says that information no longer exists. And the court said, bring in ARCCA. Let's do a voir dire. So the defense will get to present information from ARCCA. The prosecution will get to cross-examine ARCCA. It will probably be both of the ARCCA experts that we saw testify last time. And then we will get into it. I liked these witnesses quite a lot when they testified last time. Again, they were brought into the federal investigation. But when there were things that the defense said, we never paid ARCCA, and then it comes out that you did pay ARCCA, I have questions. There are things that needed to be turned over. They weren't. So now the prosecution gets to ask, do I think it changes things with how ARCCA did their work before they ever talked to the defense attorneys in this case? No. But we're going to find out more about it. Again, I thought that their testimony was really helpful. I also thought it was a really bad look for the defense when they said, no, we didn't pay for ARCCA, but you did. And it's okay that you did, but you have to disclose it. There's no problem with paying experts for their time, for the work that they've done, but they didn't retain the experts. They were originally retained by the federal government for that investigation. So, you can't be, too cute by half with what you turn over. So now the Commonwealth is going to get to ask those questions outside the presence of the jury. What information from this voir dire will come in at trial? We'll see. It depends on what's discovered. I'm curious, but we will see. I imagine Brennan's going to ask a lot about when the experts were hired by the defense, when they communicated with the defense. I think we're going to get a lot of that information. So with all of it, y'all ready? Y'all ready to get back to court? I'm ready to get back to court. Yeah, let's do that. Let's go to court because it's time to bring the experts and have a voir dire, which is, again, the questioning process outside the presence of the jury. So Maddie said, who goes first in the voir dire? The defense. The defense will get to bring it in. You ready? Let's go. I'm ready. I'm ready for it. And for those of you that are telling me who or who may not testify, until it happens in court, sometimes those things are accurate. Sometimes they're very inaccurate. So I wait until I have things confirmed. I appreciate you giving me the heads up, but I don't bring in outside information. When it happens in court, we will know. So I'm waiting for the court to be unmuted. No,
All right, thank you.
I was muted. Oh, Emily, you're the worst. You were muted while you were talking. Of course I was. Well, now we're unmuted.
Unmuted.
So we'll see. So the court had told them that the defense would go first, the last court date,
You may be seated.
and said,
For the
You
record,
can
before the court is
go
Commonwealth
ahead.
versus Karen Reed, 22 CR 117. The parties are present. The jury is not present.
All right, thank you.
jury is not
All right.
present.
So we know that the Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with reciprocal discovery regarding the ARCCA witnesses.
Yes.
Previously, about a month or so ago, maybe longer, I found that there was a violation of the defendant's obligations for reciprocal discovery, and
Under
I found
Rule
that it was
14?
deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCCA witnesses or to exclude their testimonies. Upon that, I believe, I issued an order last week
To turn over.
for certain discovery to be provided and to be provided by ARCCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So, Mr. Brennan, who are we going with first? Dr. Wolfe?
Please.
Okay.
I mean, isn't it Alessi's witness to put up? I guess not. Okay. Because last week, she said, Mr. Alessi, you can present whatever you want. I wonder if Alessi said to her at sidebar, no, we don't need to present anything. Just let him go. Because last week, she had told Alessi, you can put on whatever you would like. So, I guess Alessi has said, nah, ask what you want.
solemnly swear that the testimony you shall
So
give
we're starting
in
with
court in the matter
Mr.
now
Wolfe.
shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
All right, go right ahead, Mr.
Thank you. Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to...
Oh, you called him doctor. Well, at least we're off to a good start. Chat, I know, chat. For all of you that are new to chat, I will chat. I promise I will make sure that closed captioning is not covering the good doctor's dimples. Chat, I know. I've got you. To everybody take take a breath. The crash daddies are just like, oh boy, the law nerds again. Yes.
Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So
order?
we need Dr. Wolfe to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolfe. Last name
We know
spelled
who you are, Dr. Wolfe.
W-O-L-F-E.
Who did you receive that order from?
Chat's aware.
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
I'm spilling.
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I provided them to Miss
I
Little.
didn't directly email that to the court, no.
Did you indirectly email it to the court?
Did I already spill?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay. Did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have,
boy.
and as I informed Miss Little,
If he at one point says, I'm sorry, I had to rehome my phone, I'm going to fall over in my chair. I'm going to fall off of my chair. I looked at the phone I currently have. You know, like all the witnesses in those cases.
last year I was under T-Mobile, was my carrier. Subsequent to that,
New
I
carrier,
then
new
switched to
phone, who dis?
Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
He's like, I hit reply all. So all, just all. Hank is pissed because there's information that he wants that he can't get to. I understand why Hank is pissed. It's probably the same way the defense feels when they're like, oh, where are these phones? I don't know. The SIM card got destroyed. So, yeah, you mad, bro? I mean, okay, sure. Can I get all that flustered about it? No, I'm more mad about not turning over the proof of payment, truly. All right.
On the defense.
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
This is part of the discovery.
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on the one of the emails. I don't know as I sit here today.
You communicated by phone with
So
the
this is
defense,
about
didn't you?
discovery.
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson
Yes, sir.
a number of times.
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
Okay.
I understood him to be the defense attorney on the case, yes.
Did you speak to Miss Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please.
Oh, Kimmy K, I appreciate this. No, there were definitely times when I was annoying. No, there were definitely times when people would have found me annoying. I mean,
Did you speak?
no, there
Tell
were.
me.
I'm sure there were times.
Did you speak to anybody other than Mr. Jackson about this case?
All lawyers can be annoying, and sometimes when you're in work mode, the other side is going to find you annoying. There's still people that find me annoying because they're like, stop pausing the testimony. Yeah, okay. Sure. But vibes. If Brennan cross-examines this witness like this during trial, the jury's going to be like, sir, stop it. Just, sir, stop it.
Before the first trial?
Just, sir, stop it.
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Miss Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You ever Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
Did they open the windows in court? Because the birds are not coming from my yard for once. The birds are not from me. It feels like they opened a window in court. For those of you, and there's a number of you asking in the chat, why are they asking if he spoke to Karen? The Commonwealth, the last time they brought this up in court, said that there was unaired footage that indicated to them that there was more information from ARCCA. So it is and this is my assumption based on the limited things that Brennan said in court, is that when Brennan was listening to the uncut interviews, there was something in there that either Karen said or that Jackson said or that somebody said that indicated that there was communications or other communications that he thinks he doesn't have. So that's why I'm suspecting they're asking directly about that. But yes, also birds.
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
I'm sorry. He's just like, yeah, no. And with the birds singing, I can't today. I just can't. Watercolor Love and Dog said, would EDB be as fascinated by the glass cannon? Yes. I would have asked an unnecessary amount of questions about the cannon. I'd have been like, tell me everything about the cannon. I have so many questions. I want to know everything about the fucking cannon. It sounds awesome. Yeah, I would have been completely entertained.
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
I am amused. He's just like,
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact
I'm so
with Mr.
amused.
Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk
Right.
about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
I don't think I can emphasize what a unusual situation this is in court. I don't think I've ever seen anything like this. I'm sure there is another case that has like the weirdest situations in the world. But there's a federal investigation looking into, it seems to me, this is my speculation, it seems to me that there is a federal investigation looking into this investigation. They hire their own accident reconstruction experts, this expert and his business partners. And then in the discovery from the feds dump a bunch of discovery on the defense and the prosecution in this case. Within that discovery is a report from this company. And the defense reads the report and goes, oh shit. These accident reconstruction experts that we did not hire don't conceive of how the victim in this case was struck by a car. This information is out there. The prosecution has it. We have it. We need to bring this in at trial. But there's also a federal protective order. What do? That is the situation he is trying to elucidate for Brennan. I've never been in a situation where there is a federal protective order and a report that's been turned over, but there's things I can't say to the defense or prosecution in this case. I need guidance from the AUSAs who are like, we don't give a fuck what the state's doing. And we have information that is helpful to a jury in this case. Agreed. The information is helpful to a jury in this case. So him trying to explain to Brennan, look, shit's weird, is just, there's no jury here for Brennan. I'm going to back up because it sounds like the bailiff interrupts and the audacity of it all. Just let's continue on. So the prosecution's pissed. The jury's out. Is he going to try to rattle this expert? Probably. Should experts be used to it? Yes, they should be. Let us continue.
March 20th, 2024?
So I believe that would have been the very first
So I
phone
backed
call
it up, like,
that I had
doodle-doo.
with Mr. Jackson.
Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolfe, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was
Somebody at the
abnormal.
defense team.
I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or?
Brennan with the "you done." Wow. What?
Structures.
Woo!
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you
That's
talked about
logistics.
fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is
Because
why
it's fucking
ultimately,
weird.
immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Oh, Alessi, allow it. He said we talked about logistics. And I said to the defense, our typical procedure and logistics is this. We do this, we do this, we do this, we do this, we do that. Brennan's out here acting like he is new. Even though he's a defense witness or defense attorney, I'm sure he has hired experts before. And this expert being like, I was telling him what our normal process is. And we were like, what are we supposed to do? And then I reached out to the feds for clarification. Seems real logical.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I
We need
explained to us the
know
normal process.
how to do that.
When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again,
Logistics.
him utilizing us in the trial as expert witnesses.
Well,
'Cause
what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking
He
to Attorney
told you.
Jackson. That's what I'm talking about, okay?
Okay.
Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated
That's
by
not what he
Attorney
said.
Jackson or the defense for this case, didn't you?
That's not what he said.
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client. I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you. On March 20th, 2022,
He answered it
not the
3
22nd,
times.
Not the 24th. March 20th, 2024. Did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yeah.
For all of you asking, why is Brennan so salty? Look, these witnesses, for me, and I'm sorry for everyone that this is a spoiler for me, these were some of the easiest witnesses to follow in the last case, and they were much better than the state's. So I think that's part of why they're so salty. The state has new accident reconstruction experts this time, but I think that's part of why. However, the job as a prosecutor, the job as a prosecutor is to find the truth. You would think that these experts would be imperative to trying to get to that. So for the number of you that asked if I am drinking a Prime Energy, I am not. I am drinking Element. We need to hydrate.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship
The unpause.
resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed. And I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024,
'Cause it's a weird situation.
You reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should, please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
Big fan
sure
of
about that?
justice.
Sir, I'm on the science and the analysis that I've done. That's
I'm going to back this up. Look, Brennan's not in front of the jury, and he's just fucking doing whatever. Some wild questioning. It's just some wild questioning.
You reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that
I
clarification
backed it up.
allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should, please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness.
That's so
You
argumentative.
called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses, what did you talk
Oh,
about?
the disrespect.
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson?
He answered
Do you
it.
remember that?
I'm going to allow that.
I remember that there were conversations, yes, specifically what they were too. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know
Per my last
that I had
email.
received that clarification.
Well, sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line.
You
What
asked,
did
he
you discuss with
answered.
him during those calls?
Well,
Like, I don't know.
to be honest with you, the call to the ARCCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April
Yeah,
still?
I'm still talking at April. April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag.
He's like, I don't know,
sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood,
It didn't go through to me.
he contacted the ARCCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
He's saying that's what it
Sir,
sounds like.
That is my best guess. I don't recall from a year ago.
We're not asking you to guess, I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
Y'all, the jury is not here. Hank is well, Brennan is Brennening because he's clearly upset with this witness, which isn't going to shake this witness. But again, the point of this voir dire is to get to the heart of discovery issues. The defense didn't turn over the things they were ordered to turn over, so the prosecution has the opportunity to ask all of these questions to get to the heart of the discovery issues. So that's what he's doing. I know a lot of you are like, I do not like the way Hank is questioning. It's rude, but that's what he thinks he needs to do. He's allowed to. It's not like we haven't seen the defense attorneys in this case question in much the same way. The way it is received as you're watching the case depends on how much you like the witness, which is completely normal. When Brennan goes after witnesses that everyone likes, it's like, dude, why are you coming in so hot? When Yannetti was coming in so hot the other day, I was like, dude, why are you coming in so hot? It is coming in way hot. We'll see what happens. But again, this witness is a professional. He should be able to answer it. So that is what this voir dire is for. Is it for him to be rude? No. Is he being rude? I think so. But he's allowed to ask all of the questions regarding discovery that wasn't turned over. And I think it tips his hat that Brennan is nervous about these witnesses. That's what it seems. But Brennan is going to try to rattle this witness. That is clearly his style. So let us continue.
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you
That's not what he
actually
said.
did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24th, 2024?
That's not what he said.
Remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Okay.
question.
Do you remember the phone call on April 30th, 2024?
The judge said move along.
Do you remember that one?
I don't remember that call, sir.
Nope.
Okay. Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
Background.
And did you discuss issues regarding this
So
case?
background.
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all
It was
laid
in the
out in the
report.
report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCCA, but never, ever talked about this case.
He said his background, his training.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So, yes, that time was kept track.
Somebody's
That's not
going to
what I'm
pay for
asking
it.
you. Ultimately, that time that you kept track of,
Somebody's going to pay for the time to talk to the expert. Whether it's the feds, whether it's defense, somebody's going to pay for the time. Just like lawyers. I wonder if ARCCA bills down to 6-minute increments. or 10? Brennan, do you bill down to 6-minute increments or 10 or 4? I've got questions, sir. I've got questions. We're not new. Hank is pretending like this is the most devastating thing in the world. You were keeping track of your time? Yes. That's how it works.
Did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation
Well,
when
there
an
you
invoice
go.
goes out. That old invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolfe.
Okay. So in order to get paid for that, you would have had to submit that time through ARCCA to then
Well, he
forward
didn't.
it,
Billing
wouldn't
did.
you?
Objection, Your Honor.
Going to allow it. Is that true?
It is a discovery
Yes,
hearing.
yes, I keep track
Alessi.
of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can we approach, please?
Who asked me
No.
that?
Me, Your Honor.
Yes. Come on over.
No. He's like, I'm salaried, but my company has to bill for time. You know, like, I don't know, a lot of practices that bill for their time. Throw me examples in the chat. This is what a discovery voir dire is for. I'm just bummed they're talking about it at sidebar. The jury's not there. Can't we just bring enough for the class? Hank's just like, so you keep track of your time? I do. And then I send it to like the departments that deal with it. And then they send out bills. And then I get paid. Okay.
Doctor, again, to focus you, we're on May 1st, 2024.
Can we, to focus you, sir, can somebody just, no, don't. I'm going to make a joke about somebody throwing a Snickers at Hank and then he's going to get hit with something in court and it's going to be a mess. No, I'm joking. He's just real pissed. It's a voir dire. There is no need to be coming in this hot.
May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that that could be billed?
No, he
Yes,
sent it to
and I will
billing.
note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
Right.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Now, when you billed, did you bill for
Is
the
he
entire
doing the
conversation?
billing?
I don't know.
You said most of the conversation was background, talking about ARCCA, talking about your families,
Yes.
right? Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my
Oh,
family.
now it's brief. Okay.
He said it was brief before. In fact, you said it was
Do you
brief.
typically charge
This
when
was
you're
brief.
talking about-
That was brief. He's just trying to have a gotcha moment. The court said something because it was like, oh, so it was brief. And then he explained and he goes, oh, so now it was brief. You tried to flame him for him saying it was a brief conversation earlier. Hank?
ARCCA, talking about your families,
Yes.
right? Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my
Oh,
family.
now it's brief. Okay. All right.
Objection, Your Honor.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
He's like, sir, I have so much background training and experience that, yeah, 45 minutes is actually brief for the amount of shit I've done in my work.
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring to?
No, I'm saying, did you become
Yes,
friendly?
it's 100% what he's referring
No,
to.
I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
We were
I talked to him
collegial.
like I talked to all of the attorneys that I work with, sir.
What would you call me? If you were gonna address me?
Probably.
Do not, God damn it, Brennan. We have been so respectful as a chat. The mods have been doing their best. We are working so fucking hard, Brennan. We are trying. No one has tested this chat since, I think, James Spears, the way this chat is being tested right now. And you, sir, are going to get in here and be like, what would you call me? Just Brennan, do not tempt the internet. Thank you, chat. Thank you, chat, for being respectful of the chat rules. There are days it is harder. There are days it is harder because
Survey says.
See, the thing is, in my brain, I'm just like, do it, do it, do it. What would you call me? Do it, do it. Come on, Dr. Wolfe. What would you call him? The responsible streamer side of me is like, no, we are not name calling. We have been so good. We try so hard. And the like petty bitch side of me is like, just let it go. Just let it fucking fly. What would you call me? Damn it, Brennan.
I guess first name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
I talked to him like I talked to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
So,
That's not what's happening
remember the
in
next
his
time
brain.
you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
I wanted him to
Going
say
into June.
he's a professional expert witness. So he's not going to say to your face, probably Mr. Brennan, because it's not going to go well for him. He has to testify in front of this jury. He believes in the work that he has done in this case, and he is not going to torpedo that for the lulz. But in my brain, the list of answers that I have come up with, it's distinguished, but he can't. It is appropriate restraint. This is why I could never be an expert witness.
June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with
Do you have,
an
like, a
attorney
file?
to discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not
saves
when
text
it's things
messages for
about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order,
Also, I bet Brennan has the billing logs, and I bet they say phone call logistics.
did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, aren't those the
Well,
records?
I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the
What
full
was asked
extraction
for?
as it relates to all of the contact between myself.
The court asked for any contact between him, the defense attorneys, and the defendant. That's what was asked for.
Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah,
They
after the trial
auto-delete.
concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here. I just don't have a habit of keeping that type of text.
So
he's not my friend, sir.
So you didn't delete text?
I'm not a real housewife, sir. I don't need the receipt, screenshots, timeline, fucking everything. I'm a witness. I wrote a report. We scheduled. We deleted it. Done. He's like, I'm not trying to keep the deets. Okay. Can we get back to talking about where all that video went, though? No, not today. Damn it.
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
Objection, Your Honor.
So next question, no
Okay.
comments, Mr. Brennan.
Good
How
luck,
many
Your Honor.
texts did you delete in communications with the defense?
I don't know the number, sir.
He wasn't under a
know the
preservation
number?
order.
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was it 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
He said maybe.
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you
Oh,
and
you
the
just
defense?
swipe the whole conversation. You just go,
It
whoop.
would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial, sir.
Where were you when you were deleting these texts? Were you at your office, at home?
On
Do
the
you remember
toilet. On the toilet.
sitting down
Just sitting on the toilet, cleaning out the
and
phone.
deciding intentionally you were going to delete
Instead
over
of playing
100
Midas Merge,
texts?
just-
Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts? Where you
Sir,
were?
I just said I delete text routinely. You're asking me to specifically give you a location and a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
Apparently everybody's using Signal, Brennan. I avoid the news like the plague, and even I know that. Sir, what?
You know the benefit of Signal, don't you?
I mean, it's a messaging platform. yes.
Actually encrypted.
app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
Brennan, you've reminded me we
I
all
don't
should
know,
be
sir.
using Signal.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal.
That doesn't surprise me at all.
But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted act when you're talking to attorneys?
He said the
If the
attorney
client
asked
has
me
that
to.
preference, I don't have a problem with it, sir.
Sure.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations did you think you had with the defense team by signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know.
I don't want you to think. I want your memory, but I don't want you to think. Okay.
How many times did you use signal with the defense to talk about this case?
No, he said Jackson.
Going to allow it.
From what I recall, was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right. I'm telling
And
you
I told
that
you
I
I-
didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means. I don't
Probably
know what that
around,
means.
probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
Could be
How
6.
long were the conversations on signal? The 4 to 5 times.
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Were you
yes.
putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the signal calls were 4 to 5 minutes?
Not.
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
Not very.
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Objection, Your Honor.
He
What's
answered.
that? How confident are you, Dr. Wolfe?
I can't answer that anymore.
Okay.
It's my
Next
best
question.
estimate.
Required by court order to provide all of the records to Your Honor. You knew that one of the important things you need to respond to were communications
If they existed.
between you and the defense for Her Honor to consider, right?
Yes,
And signal is a communication, isn't it?
certainly.
You looked at all your records and knew it listed the text messages and the phone calls. You knew that, right?
Yes,
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Wouldn't Signal count as text messages and phone calls? Because he said we messaged and called on there and the call quality was terrible, so we didn't use it. Aren't those text messages and phone calls?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes.
Phone calls.
And you never informed in your response that there were phone calls through Signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon entries as well as the emails. I could not, there's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
Right.
During those 4 to 5 Signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these Signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope.
Or-
Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there
trial.
wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
Just let him answer.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you?
I'm waiting for him to be like, I'm surprised that the prosecution didn't call me and didn't want the information, since the prosecution didn't seem to have an expert accident reconstructionist. And I thought it was important that a jury in this case hear the information that I had. So no, I didn't have an agreement. And this is me speculating. I'm dying to see what he's going to say. But no, I didn't have an agreement with the defense. And no, I didn't know if the U.S. attorneys were going to pay for it. But I think the jury needs the information because big fan of justice. So I came, and we'll sort it out later because that's the right thing to do. I'm very curious to see where this goes. So, sir, tell me, you just like showed up then? Tell me everything.
For the cost of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill. I'm not.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
I expected my company would pay me.
I'm a salary employee, so it doesn't matter to me. I'm sure my boss would like us.
I'm on salary, Your Honor. I'm on salary. I'm sure the company is going to sort it out. I'm on salary. So I'm getting paid by ARCCA. It's fine. I'm going to get paid. So I just work here. Somebody will pay him. The money people will sort it out.
Did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
Has to.
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I mean, I don't think Jackson was like on
I believe that,
Expedia
yeah, she may have
American Express.
escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. You know. So did you meet a person by the name of Kat?
I'll allow it.
Jeez.
I think when I arrived here, yes.
Well, without the qualification, the simple question is you've met Kat, haven't you?
I think I met her. It was either at the voir dire day or the trial day, yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street, and I think she walked me over, and then ultimately when I was done, I think she walked me back to the lot.
Do you have conversations with anybody for the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
Okay. And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out.
There's a fucking zone around the courthouse. What's he's supposed to do? Pull up to the front of the courthouse and park his car? Like what is happening? Also, Chad, if you know who Kat is, please don't answer. I want to wait and see if it comes up. I need to wait and see if it comes up in testimony, because at a retrial, there's a lot of shit that we know about this case. And when something comes up that we don't know, I just want to ride it out and see what happens. So yeah, they told me where to park. Okay.
There, and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
Going to allow it.
Pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique.
Are you here for your 15 minutes of fame? Oh my God, if we get a 15 minutes of fame question, I'm going to fall over. Look, good Lord. This is a thing. Yes, it's a thing. This case is a lot.
And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face, right?
Yes.
Yes?
Yes.
Okay. Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
I imagine it was like, so this shit's kind of crazy. There's a lot of people around. All right, into court we go.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact, where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would be needed. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we were supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. I could certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there. We're going to get there, but there's a lot more communications before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
I do remember that there was
Now I want to know about the travel
Now,
day.
June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
There were so
No,
many
sir.
of you in the chat. I wanted to pull up this chat.
You
Now I can't because it's
ultimately,
just like jumping.
Have more conversations on June 16th.
Excuse me, chat would like to know if anyone bought you muffins. Chat, don't send this man muffins. We can joke about it in the chat, but the chat wants to know if you were sent muffins.
Do you remember those conversations on
I tried
June
to grab
16th?
the comment and it just.
Not specifically, no.
You don't remember them specifically? Do you remember?
Damn, today is spicy.
Whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
So everything from your mind was just logistics at that point?
Yes, sir.
Yeah, logistics.
And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th?
I'm trying to grab
Jackson?
another
The day of the voir dire?
question so I can get to it
Yes.
in a minute.
I could have to let him know that I arrived.
Here,
So you check in with the client, tell them you're on their way? even though you're not going to meet.
Were there any butt dials? Were there any butt dials though? Because you haven't asked him about butt dials. I got
the 18th
questions.
with Attorney Jackson.
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
Well, so you check in with a client, tell them you're on their way, even though you're not going to meet them?
You are going into
To let them know
court.
that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney?
When you are waiting for witnesses to come to court, the least shocking thing is that the witness would text you when you are in the courtroom and they are outside of the courtroom. They would text you and say, I'm here, so that you know that while you are in the courtroom, behind the double doors, they're there. Because the court at some point will inevitably look at you and say, is your witness here? And because of the wonders of technology, you can say, yes, Your Honor, my witness is here, without having to stand up, go outside, and look for them. Brennan, what? Witness communication is key. And as the chat has pointed out, Brennan, and I am on their side, didn't you not have witnesses like for the entire afternoon last week because you had like communication issues? Maybe a few more texts. Just saying. Just for all of you, I'm going to answer this question before we get back into this because it was a great question and it took me fuck ever to save it in the almost 40,000 of you in the chat. Susan said, EDB, please tell me what this line of questioning has to do with anything and how is he getting away with it? This is a discovery remedy. The court found a discovery violation. And so instead of discovery being turned over in document form or what have you, the remedy is to ask the questions. So we are asking the questions. The jury is not there. This is a discovery hearing. So we are now asking about all the things in the discovery. And Dr. Wolfe is like, am I being gaslit? You text that you're here. You text that you're here. And I saw someone in the chat ask me, how many of my clients do I text with in encrypted apps? I don't have clients anymore, but would it bother me? Nope. Sure wouldn't. Not at all. And if Signal had existed when I was a DA, would I have used it? 100%. Not to get away from discovery, but to get away from people trying to hack your phone. But yeah, no, it's not weird to me at all. But also use work phone, not personal phone. So, but no, it's not. This is not weird to me at all. If he says, I prefer to communicate this way, to say, okay, I'll text you in Signal. Like, that's not weird to me.
Attorney Jackson.
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on
Isn't
the
odd to me.
24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd.
He's like, I don't know.
Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
I want to see what he's approaching with. What are we approaching with? Did you bring enough for the class? Because I want to know. He's showing the defense whatever he's approaching with.
Showing you an email. Do you recognize that?
Yes,
From you to who?
to Mr. Jackson.
Okay. And what's it labeled as?
Wolfe Direct.
And that's before you testified on trial 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified.
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him.
I
This
just
is
sent
something
it to
that I
him.
sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified.
So this is something I routinely do when I work.
Sir, when I deal with stupid ass attorneys, they don't always ask good questions. So to make sure that the attorney that I am going to testify for asks questions that allow me to testify to my report when we haven't had time to prepare, I send them a list because sometimes attorneys don't ask good questions. So I send them a list to say, hey, here's some suggested questions. Does this shock me that an expert would do it? No, I'm almost more shocked when experts don't, especially given the situation where he doesn't know this attorney. The attorney has his report and nothing else. So he says, here you go. Oh, again, I don't know if any of this seems like a serve outside of the legal profession, but all of this is like, you're making a very large deal of things that are not a deal to be made of.
Recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified.
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Can I get that, please? There's an email with a document I'd like to attach this as an exhibit.
Okay.
The court knows that
Exhibit 1.
because we've seen this multiple times.
1.
Okay.
So you assisted the
Hold
defense before your testimony.
Hold on.
So maybe you said, Emily,
Thank
is
you.
this all or
So
nothing
you
burger?
assisted the defense
It may well
in
be.
anticipation of your testimony by sharing
We'll
with
see.
them the questions
We're
and
not done
answers you
yet.
thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point.
Ding,
so
ding,
I
ding.
sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question is
Hold the comments, please.
my question.
Your Honor, if ever there was a time to just full-throatedly yell at someone, Your Honor, now's the time. Just bring it, Your Honor. Just bring it. The judge said, hold the comments. I'm waiting. He's not going to, but I'm waiting.
The one for my question is
Hold the comments, please.
my question was you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
He
Can you
thinks
repeat
it
the
is.
question?
Of course I can.
The comments.
So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help
Chat.
your testimony.
Chat. Is sending an email without receiving a response having communications, or is it you communicating something to someone? How would you, in your mind, if you sent out an email, you're like, I sent him an email. We didn't have a conversation. I communicated info. There was no communication back. We did not have a conversation. So I sent him info. We are it's not a conversation. And he is going back and forth between conversation and communication. It is sending a communication. It is not a conversation. Okay.
Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Sustained.
Do you want to answer my question, or do you want me to move on?
Woo!
I think I answered your question.
I don't think you did, so I'll ask it one more time.
Objection, Your Honor.
All right, no comments, please.
Do you think that providing...
Your Honor, he is ignoring you.
Not today, Judge.
He's just full ass ignoring what you're saying. Just ignoring all of it. So
a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline,
Well,
whether I
that's not a
testified on
direct
behalf of the defense or behalf of the Commonwealth.
that's not a direct answer at all.
You don't want to answer my question?
Objection, Your Honor.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
He said
Vote
it
to allow that.
would assist
You
the
were making
jury
suggestions to help the defense,
understanding.
weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here, under oath, before this court, that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Yep.
So there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination,
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
Yes.
I don't believe so, no, sir.
And then
I
when you
see
wrote,
it differently. Yes, I was trying to help the jury understand the testimony. So it would be clearer if you asked me about these things. Yes, I was trying to assist in the testimony coming in a clear fashion. And that is what he keeps saying. And then Brennan's like, you're trying to assist the defense. And he's like, I'm not trying to assist the defense. I'm trying to make my testimony clear. Brennan's putting a value judgment on it because he wants these witnesses to come across as biased. He's saying, no, I just want the testimony to come in smoothly. And Brennan's putting a value judgment on it, and he is not going to accede to that value judgment. And that's why we're still here. I don't think it's going to matter. At the end of the day, the jury's not going to hear 98% of this, and I don't know if it changes everything
have
or
a
anything.
feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspected the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
Oh my God. Alessi is trying to yell, and as Alessi, I'm just backing it up. We're just playing it again, but as Alessi is trying to object, Brennan starts fucking yelling. Boy. What the chat? Motion granted. Chat, motion granted. Just motion granted. Because I don't know what reaches DEFCON, what the fuck is this, except what the fuck is this? What the fuck is this? Just what the WTF, Brennan? All right, y'all, code red is granted. Code red is granted. For those of you that are new, code red is our DEFCON level of what the fuck. We are just at full code what the fuck is happening. Just full fuckery. So when we go to code red, the lights will change red for those of you that are new, and our code red bumper is flashy. The flashing ends when the music ends. So for any of you that are flash sensitive, I'm just giving you the heads up. But when the music ends, the bumper will end and it will be done. It is a, 8-second bumper. And I granted it. Motion to go code red. In 3, 2, 1. All right, and we backed up a little bit, but we are at DEFCON red because what the fuck is happening today in court? Brennan has lost his mind. The court has admonished him, 3 times now, 4 times now, for no comments. And chat, I know it is hard. It is WTF is where we're all at. We're all at WTF. The court has admonished him multiple times to stop it with the comments. The comments have not been stopped.
I didn't personally inspect the vehicles.
Damn.
Well, it would have been the prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspected the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue.
I backed up.
Weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's 2 questions. Ask 1 question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Your Honor.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury.
Yeah.
That's what I was trying to make sure that that point was understood, to the jury.
In your collaboration with the defense, that's not all you wrote, is it?
It wasn't a collaboration.
You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19.
I mean,
Would it be
maybe.
fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
Oh. And then, do you defer to the defense, not the jury, trying to give the full story to the jury, do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a
he's
question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer to
Isn't it a voir dire? Isn't the purpose of a voir dire is to get answers to questions, not a cross-examination? It's a voir dire, not a game of gotcha. Okay.
the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Next question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolfe.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes.
Yep.
Allow me to explain.
Nope. He's probably not
for
gonna.
one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as
Okay.
an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions. 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
He told the defense.
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Brennan, really? Because we watched the pretrial. Okay.
Again, that's why I put the comment in there to...
Did you inform the court about your misrepresentation?
He informed the defense.
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not. Correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
Your Honor, could you just say that more forcefully? Because I don't think Brennan's listening to anyone at the moment. He's just flipping fucking paper at this point.
As you
listen to
sit
him, he's
here
just like,
today,
"Ah!"
you don't really know how many communications you had with the defense before your last testimony, do you?
For trial one,
That's
Yes,
a fair
trial
question.
one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls, incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf.
I
There
don't
was no
think that's
discussion that took
discussing
place
it.
between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been
So not
paid by
after.
the defense. You said no. You were later paid by the defense, weren't you?
ARCCA did send an invoice afterwards, yes.
Did you talk to ARCCA about that? About the billing in this case?
No.
You submitted your bill? Yes?
I don't think that's how that works.
ARCCA submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement, and ultimately, he's also an accident reconstructionist, so it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as
Chat,
logistics,
would
sir.
you characterize that as logistics
had
or
this-
not? You guys let me know. Would you characterize that as logistics or not? What did the three people do? This, that. Okay. Is that logistics? Well, we kind of did the same thing in this report. You tell me what you think.
Describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr.
He just
Klein.
told you.
It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me the report is a general report that has yours, Dr. Rentschler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are
yours.
on it,
It
yes.
doesn't distinguish who did.
Yours. That word is yours. Yar? What? Oh my God.
What in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does,
So they're
then
different.
you would be able to understand that.
Well, it would be easier to understand if you could just tell us what the conversation was. That's what I'm asking you about.
Okay.
I'll allow it.
When you had a conversation with the defense, did you tell them
He said it like
the
3
role
times.
that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever
Sir,
watch
are you a
any
law
of the
nerd?
reconstruction's testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
Straight. And, sir, is there any other communications that you've had with the defense that you didn't tell us about outside the text and the...
I'm stuck at the feds were closely watching this trial and they were having conversations with us about the trial. He didn't ask anything else about it. Did you hear the wind rushing through the courtroom with how quickly Brennan moved on from that question? Brennan has gone around and around and around on, wait, so you sent him information. That was a conversation. He's like, it wasn't a conversation. We weren't talking. I sent him an email. So you had a conversation. No. The feds were paying close attention to this trial. And Brennan was like, whoosh. They were communicating with us about what was happening in court. Whoosh. Just zoom. Immediate zoom. Not even a follow-up. Interesting, isn't it?
Phone calls.
It's interesting
and the
to me.
signal calls, or any other communications that you can think of that you had with the defense?
Real interesting.
No, sir. I've provided everything I have in my possession.
Yes, it's okay if you all say hi to the feds in the chat. It's fine.
I have no further questions.
FBI!
Mr. Alessi, do you have anything?
Thank you, Your Honor. Thank you.
Are we going to get to Dr. Rentschler today or not?
Well, you know how much time Mr. Brennan's...
I'm just asking you.
The court's like, are we going to get to Dr. Rentschler today? And he's like, Your Honor, Brennan, Your Honor. And she's like, are we out of here by 4? Oh my God. What? I had to back it up. I had to back it up.
Mr. Alessi, do you have anything?
I sure do, Your Honor. Thank you.
Are we going to get to Dr. Rentschler today or not?
Well, you know how much time Mr. Brennan's...
I'm just asking you.
I hope so, Your Honor.
Okay.
He said, I hope so.
May I approach the witness?
Yes.
He's like, Your Honor, I hope so. But Brennan.
Your Honor, may I approach the witness for the document?
Yes.
Thank you.
All right. The defense is going to...
Dr. Wolfe, I am
We'll see.
providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
I gained it up a little.
Could you please read the, excuse me, at this time, Your Honor.
I have it.
Where did it go?
Well, it's
Chet, I have no idea what happened. I went to gain it up and it just disappeared. Apologies. I don't know what happened. It just yeeted itself. It was just like, I'm out. I was just trying to gain it up. We're back. We're back. Fred, no. You just walked in. I can't blame you. I know.
I understand.
Hi, buddy.
So if Your Honor has it, I would like to be part of the hearing right there.
We can mark it.
Yeah, that's exactly. Thank you.
So what the court asked for and when is being marked as an exhibit, which is fair. It's already part of the record, but it's fair to mark what the court ordered and how it was communicated to
I
this
offered it
witness.
into evidence, Your Honor.
Okay.
May I allow the witness to have that,
Yes.
please? Thank you. Take that, Judge.
What's up, buddy? What? Fred is just staring at me. He's like, I don't know. I don't know what I want to do. Alessi, what are we doing?
You're with me, Your Honor?
Taking a breath? Just being like, well, that was a lot.
Dr. Wolfe, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCCA had in our possession, we produced.
The records.
What I'd like to do is to go back
in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCCA for which all time was billed
we heard about
for
this.
your work on that matter in February
It's
of
all billed under the same number.
2024?
Yes.
Did that contract number that began in February of 2024
Alessi, you don't have to yell
ever
too.
change in ARCCA?
Well, let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work,
He said he didn't know who was going to get paid.
did
who
you
was going to pay for it.
understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have, from any time in 2024, any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
let's now go
Who does
to
the billing,
your
though?
first
Because it's not him.
interactions with
He's like,
the
I get paid no matter
defense.
what.
As
I don't
I
know how they work
understand
it
it, well, why don't you tell me what was the first date of your understanding of interactions with the defense?
I believe it was sometime in mid to end of March of 2024. Again, that would have been over a month from when we issued our report to the Department of Justice.
Your Honor, may I approach the witness?
Yes.
Thank you.
It's not weird to me.
Your Honor, may what I have is the entire production that ARCCA made. I think it would ease in terms of the.
Sure, he can have it.
Thank you.
The court's like, yeah, fine.
Pursuant to the subject of the Honor's permission to answer any of my questions if you need to.
Okay. All right.
Now, in March of 2024, had your final report been issued, the final report that you prepared for the U.S. government?
Yes, that was issued on February 12th of 2024.
From February 12th of 2024 until you sit
When was it
here
provided to the
today,
defense?
has there been any change
It was at the end of
whatsoever to
February.
that report?
No.
Have the conclusions in that report stayed the same since it was finalized for the U.S. Department of Justice
Okay.
in February of 2024?
Yes, and that was testified to at the voir dire and certainly at the time of trial.
Did the defense at any time have any discussions with you about the substance of that report to the United States Department of Justice?
No, we had no idea who the defense was or the Commonwealth for that matter.
And when you took the stand in the voir dire testimony,
I wonder if
in
they knew
the
there was a
first
state case.
trial,
They must have.
before you
Well,
took
maybe
the
they
stand,
didn't.
did you have any discussions with any member of the defense
Fred.
about the substance of that report?
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCCA was working for the United States Department of Justice, do you know whether
The who? The who?
ARCCA could have been retained by any other party for any aspect related to the February
I know.
2024 report?
He already answered.
I'm not sure I understand your question.
I know where you're going with this because he
In
already answered that they couldn't be retained
24.
for the
Did
feds.
the federal government prevent ARCCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to the emails that were discussed with you, starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
Fred, I swear, if you chew on those audio cables, cat, like the cables seem like a good idea today. No, they're not.
Okay.
Are you there, sir?
Yes, I think so.
Nope.
Well, let's test to make sure. March 20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolfe. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as required. As of March 20th, 2024, was there any understanding that ARCCA would be compensated by the defense for any aspect of current or future work?
No.
Was there any understanding or discussion that ARCCA would receive any reward or payment or compensation for any contemplated?
I would like a sticker for sitting through everything we've done this afternoon without screaming. I goat screamed. I did yell fuck a couple times, but without excessive screaming. I would also like a reward. Alessi, I would like a reward. We need some treats, a cookie, a gold star, something. Because I am exhausted by all of the yelling. Just we all need some rewards. 100%.
Work.
Because good Lord.
No.
I know. I need restitution at this point for my time.
The discussions that you had with Mr. Jackson that are the subject of this March 2024 email, were there any inducements to ARCCA from the defense?
No, sir.
After that email was received by you, did you have any understanding or expectation of any kind that ARCCA would be compensated for any work associated with this case?
No, sir.
What was, briefly, the essence of that conversation that's discussed in the March 20, 2024 email?
Well, if it correlates to when I'm looking back at this phone record log, there was an incoming call to the ARCCA main line on March 20th, 2024 at 7 a.m., and that's Pacific Standard Time, so that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes. And as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him with our typical, protocol for when a case comes in and a client wants to utilize us to testify, which is certainly outlined in that email. But obviously, given the very unique nature of this case, I had no idea if that was something that was okay, if it was allowed, what to do. So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice.
Because it's
from
such a
ARCCA
weird situation.
To Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Yes.
Okay.
I have it located, yes.
Did you ever have any discussion of any kind with any member of the defense team about that invoice before July 12th of 2024?
No, sir. And I will note, I am not a part of the invoicing or accounting at ARCCA. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice, did you have any understanding that the defense team, as you're making each of those entries, any understanding that the defense team was going to be paying for any of that work?
No, again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe how it is you enter time and what it is, what your thought process is as you're entering each of those time entries? Not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got, an 8-9 hour day, right? I'm working on multiple cases that day, right? So I figure out, all right, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet so that ultimately, again, my boss and the accounting department knows what was Dr. Wolfe doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall it off the top of my head. I know it was the project number for the Department of Justice case, though.
Right. I'm sorry. I wasn't asking about the specific number,
right,
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
For any entry on this invoice,
we covered that, though.
Did you ever have any belief that you were retained or engaged by the defense?
I think we covered it.
No, and as I mentioned earlier, again, the Department of Justice forbid that. So we could not be retained or in a contract with the defense.
I would like to now go back to...
Right. I think it's clear.
The emails.
And then the feds were like, wait, we're not paying you for that time.
Specifically, we left
Go
off
build
with
them.
March 20, 2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email. What had happened between March 20th, 2024 and March 22nd, 2024?
Do you have the tab for that, the email that you're looking at? Sorry.
I have no idea.
Tab one, please.
Tab, okay. Right, so the first email that we were talking about on March 20th, 2024 from Mr. Jackson to myself, it looks like the next email was from me to Mr. Jackson 2 days later, March 22nd, 2024 at 6 a.m. I sent an email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation."
U.S. Attorney's Office. But okay.
"Until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it."
Okay.
So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on,
about how
again,
this would
moving
work
forward with potentially testifying in the case.
Because
and what
it's
did the
weird.
United States Department of Justice tell you?
They said to wait basically until they internally figured it out.
They said, we don't know, it's
what
weird.
was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
Because it's weird.
Were you entering time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one.
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
He's like, dude, it just went into the project.
In March
I don't know.
22nd of 2024,
not my department.
Was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, I remember a part of that call, there was a great deal of confusion about what do we even do from here.
Because it's weird.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all
they can finish this
by
today.
ARCCA with regard to the defense?
I just don't see how they're going to finish this today.
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April.
Okay.
When you
Because I don't think they're going to get to Rentschler today.
Under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling, logistics. And when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out. I mean, obviously, I know that this was a large trial, a lengthy trial, a lot of witnesses. Things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea. Hey, can you come this day, right? And then I would relay that to Dr. Rentschler. He'd say, yeah, that works for me. So that I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
And again.
It might appear to some that there were a number of conversations before and communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
Okay.
At the voir dire hearing, do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
They didn't, I don't think.
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
Now let's go to
Pots 1 in the chat, that is not what they cost at Target. So you must be looking at the resale. No, we enjoy Joyride at this house, but we get them at Target.
outlines that you were asked on direct examination by attorney.
For those of you asking, is he sponsored by Fiji Water? No. But also, if somebody was like, hey, we have some Dasani, I'd be like, also no. I also think there were times he was definitely taking that water bottle.
You've described
as a way to
this
not
situation.
make faces.
Well, you described
would've.
how it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal
real weird
government?
situation.
There's rules of the road, so to speak, as what you can do, what you can't do, and then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure, yes.
In
But
terms
those, again, were
of
logistics.
your
I get it.
outlines that you
That's still
sent to
logistics.
Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to...
Sir, have you ever had attorneys ask you questions badly so that it's really hard to explain your report? Has that happened? Because I bet it has.
You, before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that this is my job.
Was there
match
any
energy,
other
buddy.
motivation that you had in sending that outline in that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline?
I'm waiting. I'm just waiting for this expert to be like, no, for the first trial, I was just trying to explain my report. But now, in the year of our Lord 2025, why are we here again? Like, I got some feelings. I'm just waiting. I'm just waiting for him to be like, you know what? From the time of my report to the first trial was one thing. But from the first trial to now, my opinion has changed. Like, I'm just waiting for it to be like, well, we've seen more now, and I have thoughts. But it doesn't change his report. His report is still his report. His report has not changed. I'm really surprised that the Commonwealth didn't say, what have you reviewed since the first trial? Didn't ask him at all. Didn't ask him at all. Fred was sneezing. The Commonwealth only asked about communications with the defense. Did not ask, have you reviewed any of our expert reports? Nothing.
line in the testimony at trial. What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis, what I did, what I reviewed.
Did the defense ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury
Why is there screaming like outside of court for everyone wearing headphones? That's not happening on your end. That's happening on this end. Yeah, yes. Yes, it's like the kids have gone wild. What? Are we across the street from a playground? What is happening? I'm just going to roll it again. I'm so confused.
any
what the fuck
aspect
is
of
happening
your
on this
report
Monday?
in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident, there was bad weather conditions, it was nighttime, therefore, we should give that more weight.
And is that desire of yours, in your mind, to help the defense more than to help the Commonwealth?
No, it's impartial. And I will note, I give numerous presentations. And I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you went and sat during that trial.
Okay.
And gave testimony
Yes.
to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
They had the report. Because they had the report.
Do you recall
Everybody has
any
the
member
report.
of the Commonwealth asking any questions at all during your trial testimony about whether you had been compensated by the defense?
Alessi.
No.
Do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense
my
with
God.
regard to your testimony while during your trial testimony?
I don't think that was asked. No.
Did you,
Did the
do you recall
Commonwealth even ask?
any questions from the
No.
Commonwealth
No, they
about
didn't.
whether
No.
back in March or any
Oh
other
my God.
time you had been promised or induced by the defense? You remember any of those questions?
No.
After
Do you remember any
Brennan's
questions by the
questioning,
Commonwealth
I
at either
can't
the
give him a
voir
hard
dire or the
time.
direct testimony
I
about
can't give him a hard time.
whether you had had conversations with the defense?
No.
The Commonwealth
Do you
caused
remember
this.
any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
And that's the point. Unless he's going
At
to
the
say,
end
Your
of
Honor,
the trial.
Your Honor, They had a whole ass voir dire. They could have asked. And you know what? They were disinclined to acquiesce. So Lally never asked. He could have sat on the stand and pulled out his phone and said, yes, I said, I have arrived. Like, he could have asked me in 2024 and didn't. And then there was no order to retain any of the information. So you could have asked. It's a good point of questioning on this because, Your Honor, they had the ability to do a full day of voir dire. And they asked about the report. They didn't ask about any communications with the defense team. They could have, they didn't. So we didn't hide anything. They should have turned over the invoice. But they also could have asked. The invoice is the biggest problem, and it's been turned over now, so it's been resolved. So, okay.
Did you have any understanding whatsoever that ARCCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No, and the records certainly reflect that I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between us.
Well, let's go beyond Mr. Jackson. Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel, expenses, disbursements that you had or incurred up to and through your trial testimony?
He's like, dude, I get paid the same.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Okay.
Now let's proceed to December of 2024. Were there any conversations?
I think Alessi's amusing himself at this point.
Until December of 2024, other than logistics.
Okay.
Well, was there any conversations of any kind? And please summarize briefly what they were, or text.
The only communication I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Okay.
Now let's go to recent communications. In 2025, did you have any communications with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Well, you knew when you testified earlier today, so you learned at some point that that was true because you testified that that was true.
Now let's go to...
So you had to have learned before today.
Did the defense approach ARCCA to see if they might be able to testify in this trial that's currently pending?
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that time frame, I became aware that I think that there was a motion or two regarding ARCCA and potentially excluding our testimony for the upcoming trial. I also know that around that time,
Wait.
unfortunately, I ended up getting.
If you didn't talk to Jackson at all, would you have known? Like, when did they say we might need you to testify at the next trial? Because at some point after the mistrial, there had to have been a conversation of, if this gets retried, we might need you for the retrial. The retrial was originally set in January. So maybe that conversation would have happened before, but at some point there would have been that conversation. So I'm interested to see when that conversation happened. So calls in February because there were motions.
I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life, where my wife was affected. They were posting pictures of my 4 kids all over the internet. So it was somewhat of a difficult time on my end. And I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet? You know, why are they talking about me? Why am I getting all these hate emails? So it was, I think, a conversation to figure out, hey, you know, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
That makes sense.
Do you have an understanding of why you were getting hate mails?
Well, I reached out to the defense to be like, hey, WTF, because people are putting my family on the internet. It's so fucking ugly. Don't go real world with people. I talk about it enough. Y'all know where I stand on it. Don't go real world with people. Don't go real world with people.
So it was, I think, a conversation to figure out, hey, you know, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCCA or myself.
He's like, I don't know.
I'm clear on that. It was, you believe, regarding comments about ARCCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that, you know, insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
I mean,
Now
you guys,
to
we have seen
the last part.
some shit show experts in trials. Don't go real world with people. Like what the fuck are people doing?
Which is, did the defense contact you with regard to potential?
Oh, they
further work?
100% want the court to know
Move
that.
on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report. We went all the way through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the defense about doing further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at. Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
What the fuck is happening?
I didn't know that was
Alessi just popped the fuck up. What? We were all just like, what just happened? What just happened? Alessi is now testifying. Oh my God. Okay, I'm going to back up because Alessi's not asking a question anymore. Alessi is just testifying at this point. So I'm going to back all the way up because all of a sudden shit just went off the rails in the moment Alessi wanted to get to this. Okay. Sure, not a objection, which is interesting. Let's just, I'm going to back it all the way up for all of you. Like midway through, we all went, wait, what the what? Yeah, I backed up. Yep.
No, sir.
We just went doodly dood all the way back.
Have you done your best to try to provide accurate and truthful information in this matter?
I mean, it got so repetitive. We all just were lulled to sleep.
Now to the last part.
It's true.
Which is, did the defense contact you with regard to potential further work? I want to separate out now and move on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report.
Okay, potential further
We went all the way
work.
through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the defense about doing further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications.
Okay,
so
Alessi.
I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about?
Objection. Nefarious? It would be nefarious. So what Alessi said is, he wants the court to know this. It's not really a question to this witness, but did you know that they were trying to get to the phones of Karen Reed's parents? We knew because we covered those motions, that they were trying to look at the phones of the defense. That I don't remember. That going to Signal was a way to protect the defense attorneys. That doesn't surprise me given the amount of phones that they were trying to get to in this and related cases. So that's where Alessi's like, did you know why they moved to Signal? He's like, he just said I'd rather communicate on Signal. And I went, okay. Didn't know any of that. We knew he didn't know any of that. He wanted to remind the court of that.
Using Signal?
No.
And my understanding is it's the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right,
That's
so I want
2025.
to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
He said that.
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, etc.,
Oh my God.
do you recall when
Did that help you in your work? No. No, their work did not help me in my work.
you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, etc., did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that
This is regarding the
Dr.
Commonwealth
Rentschler and myself
experts.
are particularly interested in are extremely vague in that report in PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCCA's business to evaluate that information and prepare your own report, analysis, and finding? In the ordinary course, how much time
The
would it
Commonwealth
take
didn't ask
ARCCA
about
to
this
do
at
that?
all, and I'm surprised by that.
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson, I indicated to him on the 26th that we did have authorization to move forward, he immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, at the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative terms, 800 gigabytes? Is that a little data, medium amount of data, or a lot of data?
Voluminous, a lot of data. So we immediately started to review that. And again, I feel like maybe I speak for most experts. One thing we always want is more time, right? So in a case like this, I mean, ideally, we would be talking months to be able to sift through all of that information, be able to do analysis, be able to do testing, be able to write a report, right? So I think certainly we are on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could, along with Dr. Rentschler, to review that material, and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case.
Did you put other work aside at ARCCA to work on this matter?
Absolutely. Work and personal things.
And personal things. What did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary. So
it affected his personal life, I understand.
Okay, I'll move on, Your Honor.
He's
With regard to the work,
Yeah, plans got canceled.
you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that correct?
correct.
You said you would like to have had more time, correct?
Correct.
I mean,
but
of course.
I understood Your Honor's order, and I wanted to meet that deadline. So I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline, and we completed our testing.
And with regard to the testing now that you've worked on, that you just described, does that testing relate to any previous work, or is it all in response to the new expert for the Commonwealth, Aperture, and the new information from
The
Aperture
Commonwealth didn't ask about
that
this
came,
at all.
In iterations through the month of February?
It would be in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the Aperture report and slides and scans?
Nope.
No, I don't even know what we would be responding to then.
So you needed the Aperture information before you could even start working, correct?
Correct.
Also, the court was the one that advanced that deadline a little bit.
Does ARCCA have in mind
So
any further testing
the court is
that you
hearing
need
that
to do,
too.
or have you completed what ARCCA needs to do with regard to fairly and properly responding to the new work of Aperture?
I think we're satisfied that we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering type terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we've produced all of that raw test data, photographs, video. So it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully, to my next question, which is there's nothing that you have that you've done that hasn't already been produced to pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
How long on an expedited basis? Well, let me ask you. In the ordinary course, how long would it take you to do this last part of your work? In the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However,
I mean, that's fair.
it would take a month in the ordinary course. How quickly can you get that work done?
He's like, y'all are really rushing it.
I'm hoping if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
It's my birthday. So, all right. We're going to be in trial one way or the other.
At this point, Your Honor.
All right, Mr. Brennan?
She said the testing needed to be done. The testing, it sounds like, is done and turned over. It is the final reports that are not done. Okay. Back to Mr. Brennan.
Doctor, you're suggesting that it's going to take until May 7th for you to complete the reports in this case?
That's like days from
And the
now.
analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided Rod.
When did they get your expert's report again? Because I literally can't with you. When did they get your expert's report? They didn't get your expert's report and scans till like trial started. So, okay.
Data last Friday,
Yes.
but you would agree you still have not.
Last Friday. They got it last Friday. I'm sorry. They got all of that last Friday.
Started.
I think like a week or so ago.
You provided raw data last Friday,
Yes.
but
They were.
you would agree you still have not provided any reports.
Correct.
Raw data last Friday.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
When were the scans?
Just the
turned over?
report?
Yes.
I didn't know that,
And
no.
the file in its entirety was turned over by February 5th? Did you know that?
Objection, Your Honor.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th,
Well, they weren't retained
the
February
testing
5th.
report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as ARCCA, yes.
Putting aside the authorization, I'm going to ask you about that. But just the time you need to test, if you knew or received the information by February 5th, you could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now, so wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True?
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to deal with this information you said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, ARCCA's did, in June of 2024, didn't it?
I believe it was sometime last year, yes.
Do you know the Commonwealth notified
Really?
the defense that they were going to have a new expert back in October of 2024?
That's interesting.
No.
Are you aware of any effort by ARCCA or the defense to try to facilitate an agreement that the defense could use ARCCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCCA in December or January?
No.
And so as far as you knew, this came out of
Interesting.
nowhere in March, that the defense wanted to use ARCCA, or specifically you and Dr. Rentschler, in late March of 2025.
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCCA issue was being litigated. And I think that like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2000?
I think Hank would have gotten a lot further with this line of questioning had he started with it. But he didn't. He started with screaming about the emails. But I think the direction we're going to see the Commonwealth going with this is that the defense is sandbagging. And the reason they waited so long, and I think this is their argument, we'll see. I think he's going to intimate, or maybe he'll just say it because he hasn't held back all day, is that, and this is a rude pause face. Hold on. Sorry, sir. That the defense could have reached out to this expert June, July, August, September, October, before March, pending trial in April, starting April 1st, could have reached out to ARCCA sooner and had them start to review the Commonwealth's information sooner, and that waiting till now is the defense saying, well, we don't have it, we can't turn it over, it's not our fault, and holding back their discovery by choosing to not even reach out to the feds earlier when the contract ended, if the contract really did end in June of 2024. Part of where the Commonwealth is going to go with this, I think, is to ask that any new opinions be kept out because the defense didn't give the prosecution enough heads up. So not turning over the ARCCA response to the Commonwealth's experts in time is where I think this argument is going to go. Hey, your contract was done in June. The defense didn't even reach out to you till February. They didn't retain you till March. They didn't give you our reports until April. But had they given it to you in a timely way, then we wouldn't be here on the back foot. And I think that's where the Commonwealth is going to go with this argument.
I have to even seek permission from the federal government.
Let's see.
To retain you and Dr. Rentschler so you can review the materials.
Objection, Your Honor.
Do you happen to know that?
I don't know, no.
Right, because that
You
question
shared with
called for
us
speculation.
communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Okay. Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving...
Just to be nosy, I want to know everything about that conversation. I want to know everything. I want to know everything about the conversation that the AUSAs had with this expert about the pirouettes. I want to be a fly on the wall because giving
you information during the trial about witnesses. What witnesses do you remember they were giving you information about?
One that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case,
hey, George,
was that part of the catalyst for you to either call or text the defense and ask questions?
No.
did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No. It was
Yep.
just verbal
And
communication.
they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was, as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that. no.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case?
Were all the
before your
experts
testimony
sequestered?
in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of
This
Justice
would have been-
about this case before you?
This is much more important ground to tread than fighting with him over an email. Like, why didn't he get into this before?
Testified.
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA,
Yes.
and certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline with your comments. You recognize this?
Yes.
I'd like to introduce that as an exhibit, please. Thank you.
Exhibit 3.
I'm very curious to hear what he has to say.
So, as an expert, when you receive information, you need time to look at the raw data, don't you?
Potentially, yes.
You need time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing,
knows where he's going with that.
should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new, and an expert wants to look at it, you would agree to sift through that much information and consider and
He's sitting there.
vet it, and then
Dr. Wolfe is sitting there going, this is the defense, the Commonwealth, starting to angle that they have not had enough time with the defense's rebuttal information. That's where this train is headed.
and do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert
That's
that
where that's
determines
going.
whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
He didn't
May
say
7th.
do. He said that's when he would have it.
It could take an expert, if they wanted to do testing based on new testing that you provided, over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided the report, how many pages was it? 10, 12 pages?
The original DOJ report?
The report that you
The
produced
thing
in the
is,
case, your-
it's rebuttal to your expert.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected as classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided.
It's a good line of questioning.
For the first trial?
Yes.
No.
And videos of the demonstration, you built like a potato cannon, right?
I'm sorry, what?
No, it's a fucking yeet cannon. Look, this is a much better line of questioning than what we got to earlier. The earlier line of questioning was just ridiculous. This line of questioning actually has the potential to cause some problems. But we've gotten so late in the day. But I want to hear all about the yeet cannon. But so you never turned over the raw data, but that's critical because the Commonwealth is going to say, look, we couldn't bring in rebuttal experts to their expert because we don't have the raw data. We had to bring in a new expert and they could have gotten their experts sooner. And they are going to try to cut off the new information from ARCCA, where ARCCA is looking directly at the Commonwealth's new expert. That's where he's going with this because he's like, right, you need the raw data, but we couldn't get that. We couldn't test your work because it was protected. Yeet cannon. Yeet cannon. These are good questions from Brennan. Yeet cannon.
All right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected as classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
Has it been
And
provided? Was it
videos
provided
of
now?
the demonstration, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of?
Do not offend ARCCA about the cannons. He's like, if you want to call it a potato cannon, fine. He's like, this is a serious bit of engineering. He's like, do not offend the cannon. If you just want to call it a potato cannon, fine. He's like, it's way more awesome than a potato gun. It's way more awesome. Way more awesome. The cannon has been offended.
Of it when you were doing your demonstrations and tests?
Yes.
Never turned over those videos, did you?
They're classified.
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one, so
Okay.
no, I want you to focus on.
Okay, no, that
trial
was
one.
not produced, no.
Never turned over any of those videos, did you?
Again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welch's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided
Right,
in
so-
response to Dr. Welcher.
Without video and without the raw data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
I think you might be confused. Again, our role for this round.
I don't think I am. I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report.
I'm going to back this up just a minute.
No video, no raw.
Look, I am dying. A lot of judges might not have allowed ARCCA in had Brennan done the voir dire of ARCCA the first time. Had Brennan done the voir dire of ARCCA the first time, this not being turned over might have been the thing where the court kept ARCCA out. ARCCA allowed them in the first time based just on that report and a voir dire, no other underlying information. I think that's in part because of Lally's questioning. I think if we had gotten to this questioning, the court might have said, you know what? We're not allowing this in. You don't have the raw data. But now we're getting to, yes, that didn't happen in the first trial. I don't know why we're going over the first trial, because this is a voir dire about discovery issues leading up to the second trial. So I don't know why we are circling back to, well, you didn't turn this over to us in the first trial, because that's where we're at. But you didn't turn this over to us in the first trial. Okay. Has it been turned over now? Because it sounds like it has. Very, very interesting. So I am backing up because Brennan is now just like, but no, the first trial, I'm dying with him being like, sir, you're confused. I'm confused.
Led to your testimony in trial 1, is there?
I think you might be confused. Again, our role for this round.
I don't think I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial 1.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's not what I'm asking
We
you.
have provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel with that.
Wow. New trial, new opportunities. The court's like, with that, I need to see counsel at sidebar. Where the fuck are we with the day? Not much longer in the day by the looks of it. And yes, we are behind real time because I keep pausing to yell because damn, today is a lot. It's a lot. So ARCCA is coming in as a rebuttal witness this trial. Okay. I'm going to zoom until we get done with this side. The sidebar.
You're all set.
She just
And
said the
let's
witness
bring
can step
Dr.
down.
Rentschler in here, please.
Thank you, Your Honor.
Okay.
Just said the witness can step down. Are we done? I guess we're done. All right, we've got to back off. We got a new witness on the stand, so we have to undo our code red, but we're done? I guess we're done. The court's just like, you're done. So, look, the court completely cut off the prosecution in the middle of their line of questioning. I know everyone would be screaming if she did it to the defense. The prosecution actually had an interesting line of questioning here. If they had used that before, then maybe they wouldn't have gotten cut off when they were actually starting to make a point. But instead, they wanted to spend, 30 plus minutes dicking around talking about an email communication. And the court's just like, get out. So that's on them. Ask the good questions before. All right. So Dr. Wolfe is no longer on the stand. She's bringing in Dr. Rentschler. I'm going to reset the lights. And the second ARCCA witness is going to take the stand, it seems. My, oh my. Today has been spicy. But then Brennan wanted to talk about those emails forever and didn't get into some of these other questions. A number of you have asked about the defendant going up to sidebar. The defendant's allowed to go to sidebar. The defendant asked if she could have a listening device at the table so she didn't have to go up to sidebar. And the court said, no, she can come up to sidebar. So the defendant is going up to sidebar.
All right, Dr. Rentschler, this is going to be very quick.
Really?
Go ahead, Mr. Brennan. We
Thank
just
you.
need his name.
Good afternoon, Doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Rentschler, ANDREWJOHNRENTSCHLER.
You've testified before in this case?
I have, yes, sir.
At a last voir dire in a past trial?
That's correct.
Okay. Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one, and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Okay. Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium
Right.
to have conversations with the defense other than text or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
When I
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
I don't believe that ARCCA has any specific policy for that, no, sir.
Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean?
Yeah.
They just tell us shit,
Certainly,
sir.
that would have been up to the DOJ. I mean, I would have had conversations.
Sir, it's the DOJ. They're just like, we're telling you this. And they're like, oh, okay.
The FBI!
Okay.
With them, I don't believe that I asked or requested anything, but they
Sure.
were called to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
It would certainly help prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order? That there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire, it's the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th,
Did you talk with awesome people? Did you do awesome shooters? Was it an awesome party? Where are we going with this? Did you have an awesome lunch with the defense? Brennan, he said no. He said no. I met them when I came to court.
yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the
There
airport.
was a
Come over,
lunch.
have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk?
There was a lunch. I didn't think there was a lunch. I'm backing up. There actually was. Brennan, I apologize. I was prematurely snarky. There was a big old lunch. Was it in the outtakes from the docuseries? Was the lunch in the outtakes from the docuseries? Interesting. All right, I'm backing up. Is this after the voir dire or after testimony? Now I need to back up because I was busy being snarky. Apologies.
No, I was not.
Okay.
After you testified, did you Well, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire, it's the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And
There
sir,
was a lunch. Interesting.
I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you wanted to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
You
opinion.
make a decision on what you think is appropriate to contest or maybe agree with. And
Dude!
then you contest if necessary, correct?
To be able to respond.
What? Brennan walked away from the mic as he was getting snarky.
The estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you wanted to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
You
opinion.
make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do
And
that.
it's still not done.
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report
Wow.
and everything completed before the 7th? If I order you to do something?
They kept Brennan on a timer.
I mean, I could certainly try and expedite that.
All right. I appreciate that. Thank you very much. You're all set, sir.
The court kept Brennan on a timer.
Counsel at sidebar for 1 minute.
The court kept Brennan on a very short timer. I'm going to get past their sidebar. I think we've got to be close to the end of the day because the feed is just about done. So I think we are just about done for the day.
All rise to the court, please.
Yep.
Goodbye.
Oh boy. Brennan did not use his time well today, I don't think. The end of his questioning, I think, was more helpful to him. We'll ultimately see how helpful it will be. But the end of the questioning, I think, was more helpful to him than yelling about the emails. I thought that was just a bit of a waste of time. So at the end of the voir dire what day of trial are we at? Day 5. The court ran over a little bit to get this done. They barely had any time with the second witness because Special Prosecutor Brennan brought all of the special snark at Dr. Wolfe, just all of it, about whether or not there was an email sent or whether it was a conversation, what the communications were. If, ARCCA is like rooting for the defense, aren't you trying to help the defense? Aren't you doing this to help the defense? What do you mean you didn't communicate with the defense? And round and round and round with Brennan yelling at the witness before we then had Alessi's questioning, which again went around and around, covering a lot of the same ground. I think it's clear that Alessi doesn't necessarily trust the court to hear what he's saying. And that's the sense I get from his, and that's purely my speculation. That is the sense I get from his style of questioning, where he breaks things down and then asks them in multiple different ways to make sure that it's clear that there's nothing nefarious. Where I think Brennan started making better points to support the argument that he is going to make is when he got into how long it takes. Oh, so you need the raw data because you want to be able to check against the conclusions. Oh, so you need the raw data, the report, the photos, the videos, and then it would take you more than a month to do that information. This is where Brennan, I think, is trying to get to, keeping out ARCCA's new information. But it sounds like from ARCCA that they have been brought into the case this time not to cover the report that they originally did and not to give those opinions, but to respond to and rebut the Commonwealth's expert instead of proactively give their own research. So what they were saying is that they took in the new expert from the Commonwealth and are going to say, this is why we don't come to the same conclusion. This is us rebutting that conclusion. So I think where Brennan is going to go with that is saying, but Your Honor, if they're giving us this information so late, we need time to then have it double checked with our expert. And I imagine where the defense is going to go with that is, but this is rebuttal. We're not bringing them to do anything other than to rebut your expert. So there is going to be more argument, I imagine, between the defense and the Commonwealth over the scope of ARCCA's testimony. Remember, the court already said she was allowing ARCCA in, but that she wanted to have the voir dire and would determine the scope of their testimony, and limited the defense from being allowed to discuss ARCCA during their opening statement. We've also seen the prosecution say that they would need more time. They would need more time to address the ARCCA stuff. We only got to the voir dire today. We did not get to the argument about it. I wonder when we will get to the argument about it, because it's going to come up. I would imagine we'll see probably another motion filed by the Commonwealth regarding this, saying ARCCA can't testify, we don't have enough time. I think that's the direction they're going to go in. And the defense saying, we didn't even get the raw data from the Commonwealth until this time. But we did see the Commonwealth bring up that ARCCA wasn't under contract with the feds past June of 2024. And we saw the Commonwealth bring up, they say that they turned over all the raw data to the defense well before ARCCA got it. Though during the hearing, with the amount of yelling from Brennan, it was unclear to me exactly when that information got turned over. But we know that Brennan's argument on that is going to be they could have picked a different expert. ARCCA was done with the feds in June. The defense could have picked a different expert. They knew that we had retained our new expert, and they waited and waited and waited. And ARCCA didn't even reach out to the feds to see if they could work with the defense in this trial until March. The trial was originally set for January. What would they have done then? So when we see argument from the Commonwealth, it's going to be the argument that, well, the defense waited so long to give them this information so they wouldn't have to disclose it with us. One of the really solid points I think Alessi made during his questioning was that ARCCA was never questioned about any of their communications with the defense the first time they were voir dired. That voir dire didn't really have limitations to it. The court didn't say you can't ask discovery questions, it's only about the report. The court said at one point during the voir dire with Attorney Lally in the first trial, this is your time. You can ask them what you want. Lally did not ask those questions. And it was pointed out, I think, very effectively by Alessi during this questioning. You weren't asked about communication with the defense. You weren't asked about if you expected to get paid. You weren't asked about what case number you were billing under. You weren't asked any of that. So is that on the defense, or is that not on the defense? Is that on Lally for not asking those questions during the first voir dire? Oral argument on this is going to be fiery. I think it's going to be fiery. We haven't gotten there yet. I'm interested to see what the new expert for the Commonwealth has to say. I'm interested to see how the defense brings up, well, the pirouettes, and the rest of it. So we are not done with the ARCCA question at the end of the day today, nor are we done with the first witness that was on the stand today. We are just left unsatisfied. Are there any answers at the end of today? No. I don't think there's any answers at the end of today. But we do know that the feds kept a close eye on the first trial, which was news to me, and were having conversations with the ARCCA experts about the first trial. Brennan represented that there was a sequestration order that seems to have covered experts, which again is an unusual situation. Generally, experts can watch the testimony of other experts. But again, they were never asked about that by Adam Lally, but it seems that the feds were watching the first trial very closely and communicating with ARCCA about it. And at the end of all of it, we got to Dr. Rentschler having lunch with, it seems, Karen Reed, her family, possibly the defense team, where he said, I stood in a corner and was waiting for my ride to the airport, and they said, have lunch. And I stood in a corner and had lunch after my testimony. Is that going to matter when these experts testify all that much? I don't know, because they've been retained by the defense. So is the jury going to be like, oh my God, I'm so shocked that y'all had a lunch together once and the defense hired you? I don't know if that's going to be shocking to anyone. We will see when we get to that testimony, if it even comes up. But the court cutting off Brennan's questioning was like, we're getting this done today. I think Brennan wasted a lot of time on stuff that didn't really help him very much, and then lost a lot of time in the testimony that might have been more helpful for him. But again, we have to wait to see argument, and we have to see what the court rules. I'm curious. And here we are, just waiting to see what happens with ARCCA at the end of the day. I hear noises. Hello, my teenager. I know the cats are, both cats are in here. The second my teen gets home, the cats are like, bye. Preferred human has walked in. We were just summarizing court for the day. How are you? Your mouth is full. It's all good. I know. You came in looking for your cat. Your cat is heading out with you. You can say hi to the chat. Do you hear that? Chat, can you hear that cat saying, pay attention to me? Saying, pay attention to me? Yes. The cat is just immediately like, pay attention to me now. Pay attention to me now. All right. I know. The happiest cat in the world. Will George let anyone else pick him up like that? No. No. Do you see how happy that cat is? We needed a cat break. That cat's like, let me climb into your skin. I've missed you. I've missed you. Yes, he is. All right. You can take. All right. Good to see you, T. I'll see you when we're done. We're just wrapping up at the end of a long day. The end of a long day. I know. A long day. Yes, everybody's like, his human is home. Exactly. The chat has said you have matching hair. They do. They have exactly matching hair. No, they match. They match exactly. It's hilarious. There was one point where T had like put his head down on the couch with both cats and just kind of blended in. I know. All the boys. So I think we finished summarizing it. We're going to answer questions. They're twinning. They are 100% twinning. Today was so much. I know the cats are like, ugh, substitute humans. T is home. Did you hear him? Immediately. The second he hears Travis's voice, he's like, all is well with the world. For all of you being like, what is going to happen when Travis goes on tour with DCI this summer? I don't know. George is going to be mad. He's going to be big mad. We'll figure it out. It's going to be fine. 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 You guys, today was just, I don't know. Today was so much. And again, I don't know why Brennan needed to be so aggressive at the beginning of his questioning of Dr. Wolfe, because I thought that the questioning later was much better. I actually thought the really aggressive questioning just was not helping at all. But the later questioning, it was like, oh, that's actually really interesting. Ugh. 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 Tomorrow's a full day in court. I'm going to answer some questions. So we will do all the things. So let's see. Travis is not marching college yet. He is still in high school. So he's marching DCI this summer. And yes, he's marching DCI this summer. So yes, we will be in Indy in August. There will probably be trial. It'll be fine. It's all gonna be fine. This summer, when you guys are like, Emily, why are you streaming in a hotel room? Cause I'm a band mom. So that is why. Let's get to questions, shall we? And I think for the chat that was asking about Brennan, I don't know. It really is kind of like throwing out a pitch to hit the batter, or in water polo, throwing it so it hits the goalie in the face. It really was just unnecessary. It was really just unnecessary. And the court has said so often that that's exactly the type of questioning that she doesn't like. And she admonished him a couple times. I wish there had been a stronger admonishment at some point. She did cut him off in his questioning, but she was like, no comments. At some point when he was continuing to yell, I was just waiting for the court to be like, Mr. Brennan. No comments. It was just so much. It was so extra today. I mean, are you all exhausted? I'm exhausted. The amount of yelling, I'm just like, oh. And Dr. Wolfe was just like, Lord, what is happening in this court today? I know, I'm with y'all. It was a lot. It was a lot. Maria said, grief over who told him where to park. I know. There were so many options to not. And I think the question about lunch, fair question. I think the questions about the number of communications, fair question. I think asking them about how much time it took them to do the new work when they were given it. When did the defense give you this work? Did the defense tell you you could not have information from other witnesses if there was a sequestration order? All of that information, I think, is helpful. He wasted so much time just being really mad about stuff that I don't think was as impactful as what was later. I mean, wow, today. Let's see. Donnie said when Crash Daddy said the Commonwealth could have used ARCCA too, in my head, all I heard was ex-TMZ employee Morgan telling Elaine, I could say the same thing for you. It was, you guys could have called me. Everyone had the report. I think the thing that sticks with me about the ARCCA witnesses, I liked the ARCCA witnesses in the first trial. I didn't have an issue with the ARCCA witnesses. I really thought that they were neutral witnesses. I thought they testified well. It didn't shock me that the defense said, we had their report, we talked to them about logistics. That didn't shock me. Once you saw the ARCCA report and you saw what they concluded, I'm not surprised that the defense was like, sure, we'll ask you the questions on the stand. Fine. That, again, does not surprise me at all. So asking about it again, I guess the Commonwealth really wanted to get to. So you're really telling me that you talk to the defense about your background, the other person's background, the training, what your normal procedure is, and then the Fed report, and they said, we're going to ask you about your report, and you said, yeah, and that was it? And they're like, yeah. I'm not shocked that happened. So, am I shocked that they had logistical conversations? No. I'm still most surprised that when the payment issue came up, that the defense was still saying to the court, we didn't pay for ARCCA when they clearly had. That's the biggest problem I have at the moment. And that's been since turned over. So the discovery has been turned over. Okay. We'll see. We'll see what happens. Brennan is pissed that this information didn't come up to them sooner, not the payment, but any retesting and new report. And he thinks that the defense waited too long to do that to put them on the back foot. That's what Brennan is mad about. So we'll see where that goes, but that's what Brennan's really mad about, is that they're like, well, we're just getting this ARCCA information now. Okay. And when are you going to call your accident reconstructionist? And then when's the defense going to call ARCCA? You probably have time to review it. We'll see. We'll see. But I think the Commonwealth has made the point. Kate said they were authorized at the end of March. They were. The Commonwealth's point is, but the defense could have done that sooner and didn't. And the Commonwealth is going to argue, and I think they've been alluding to the fact that that was intentional. You could have hired them after June 2024 and didn't. That's where they're going to get to. That's what I think they're really mad about. So we'll see. Because it sounds like ARCCA's not going to be testifying to their report that they testified to last time, but testifying in rebuttal of the Commonwealth's expert. That's where it sounds like we're going. So, but yes, the experts, I think, kept their cool for the most part. There were a few looks. They weren't terrible though. It was patient. It was patient, more than many could. So we will see. Happy at Heart asked, why does the Commonwealth get a second voir dire for the first trial? So after the first trial, they're getting a second voir dire because the court found additional discovery violations. We covered those. She found a discovery violation about the text messages, and she found a gravely concerning discovery violation with regard to the payment of ARCCA. So those are the two things. Those are the two things. So let's see. Can the Commonwealth open the door to disclose that the feds hired ARCCA? I don't think so. And I'm interested how they are going to address the original hiring of ARCCA, or if they're not going to at all. If they're just going to stick to ARCCA was hired by the defense to respond to this expert, then they might not need to address it at all. So we'll see. Let's see. Nicole said Hank didn't give the defense the Welcher report until February 1st. And it sounded like the original report was what they referred to as the vague conclusions, because the defense made motions about this too, the conclusions and the PowerPoint, but that they weren't given the underlying data until after that. So for all of you saying that you are watching Ryan Hall, y'all, I completely understand. Court's done for the day. We're going to do this in a case brief. So if you have the Lawnerd app at lawnerd.com, there's going to be a case brief with me trying to summarize today. So if you need to go watch your weather, totally get it. Go do it. Go. Just don't worry. It's fine. I'll put it on later because I want to see too. Wait, where did it go? I just went to YouTube to try to pull up Ryan's weather, and it says, video unavailable. What is going on? Maybe it's on my end. Now I'm confused. Their chat doesn't say anything. But anyway, if you need to go watch the weather, don't worry. We'll have case briefs. Court's done for the day. I'm going to keep answering questions. And then I'm going to try to come back and see what's going on with weather. Is it my weather? it your weather? I don't know. I can't pull it up. That's so strange. Okay, YouTube being weird. Whatever. I'll get back to it. Emily, don't get distracted. Don't get distracted. Because we're gonna keep trying to answer questions. But the yelling today, just look, if everything's a big deal, nothing's a big deal. And normally I would have given Alessi shit for being like, and did you turn it over? But after how much screaming we had from Brennan, I'm like, I mean, you kind of get what you get at that point. It was just so wild today. Sam said that was 100% were these magic grits energy. Yeah. When we got to, I think you're confused, and I started choking. I'm really interested to see when ARCCA testifies in front of the jury, how this goes. I imagine it's going to go differently, but it's going to be incredibly interesting. I have no other words today because I'm still flabbergasted by all of the screaming in court this afternoon and how Brennan just kind of bulldozes his sentences even when there's an objection. It's a lot. It's a lot. It is a lot. And it's frustrating that all of that kind of lost some of the better points that could have been made. Like, why are you doing that? Just what does that, how does that help? And I really don't think that it does help at all. So we'll see what the court does. There's still a long way to go with the ARCCA. So let's see. For all of you that were stressed, I see a lot of super chats about how all of you, like all of the yelling in court today was just stressing you out. I get it. Expert witnesses are generally not yelling like that. It was a lot, but are used to a strong cross-examination. But even with it, that was take a breath, take a sip of water, and let's keep going. It was much. Fred of Orange's court cam said, Brennan, thou shalt not scream at or in the vicinity of Alessi or thy crash daddies. He did not acquiesce. He did not acquiesce to that. So he did not. All of you we are getting notes that it is a YouTube problem. So YouTube is having issues. That's weird. But it's probably a good time for us to start wrapping up in case it becomes an issue on our end as well. Because today was so extra. Tomorrow, though, will be, well, it should be a regular court day. I won't be surprised if we have attorneys wanting to see the court or see the judge on the record before the jury comes in tomorrow. And then it should be a full day of jury testimony tomorrow. I have seen some comments, not just from you, but from our production team too, that there are some YouTube issues. This is why we have the app. It's a good time for me to remind you about the app, because if anything happens to a stream, we can send out new links and the rest of it. It happens when there are outages. You never know. We want to keep you in the loop. Being kept in the loop is a good thing. So if you are fascinated by this trial and want to stay in the loop, Lawnerd app at lawnerd.com is the way I can keep you in the loop. Because as I was going over to look and see if weather was being talked about in my vicinity, I couldn't pull up anything on YouTube either. So let's see. Rebecca wants to know, said EDB, I was not going to jump into the chat today. It was like, I'm going to listen in the background. I got things to do. I got to get stuff done. Hands got to be free. I get it. I haven't even unpacked and I am so tired, partly because I took my favorite pillow with me to travel, because I was like, it's a road trip. I've got the car. We're just going to bring the pillow. Like we're driving. That pillow stayed in Indianapolis. So last night I was on backup pillow, which was not sufficient. So, I am tired. But Rebecca wants to know, said, but I have to know, how is the prosecution asserting the truth of this case by badgering this expert? Well, they were on a discovery expedition. So I don't think the badgering was necessary to just ask the question. I don't know why Brennan is so mad. He's trying to give it strains credulity, but it's really hard watching everything that's happened in this case and seeing Brennan get that mad and be about, so you sent messages. You sent messages on Signal. Okay. But it was discovered like a year after trial that somebody actually downloaded all of your CC video from Canton, and then like it all just, or a substantial amount of it just disappeared. So the disproportional level of frustration from Brennan is surprising to me. It's just surprising with me. I just so mad. So mad. Ashley McCork said he's saying that his comments were to help the jury. That's what he was saying. That prosecution did not believe that at all. Just not at all. Tina, oh wait, where did it go? Tina said the repetitive questions when he doesn't like the answer he is getting had me banging my head into the wall. He was like, let me ask it again. You're not answering. Let me ask it again. And it's different in front of the jury, but you're out of voir dire and the answer is the answer. So, I don't know why my brain just blanked on trying to read all of your name clause. I apologize. He should have called ARCCA for his own case. He could have called ARCCA for his own case. However, when you get a report that says the exact opposite of what your experts say, I think more investigation or questioning is necessary. Why not call ARCCA and be like, hey, how have you come up with something so different than what our accident reconstructionist came up with? And maybe like endeavor down that path. I'm still surprised that, well, I think Dr. Wolfe being snarkier would not have been helpful down the road in this case. I don't think it would have helped. So, Mom interrupted, said, Emily, I am also originally from SoCal, now live in Lebanon, down the road from you. So I relate to all your weather and school updates. Love following your trial coverage. Hope to run into you at Target one day. I'm sure that we will. Target or Starbucks when I leave the house, or concerts, because it is concert season and I do go to concerts. It is one of my favorite things to do. Jojo said, Emily, or in my head it was EDB. What do you think of the prosecution's tactic today? Because to me it was all over the place. I think the questions at the end were more helpful for what I think the Commonwealth is arguing. I think at the beginning, it was just so over the top that the point, if any, got lost. So I just, again, when the defense comes in way hot out of nowhere, I'm like, what are we doing? Same here. Why are we coming in so hot out of nowhere? It's just wild. KK said, isn't some of the problem that the judge wouldn't rule on the ARCCA motions? I think part of the problem was that the judge ruled and then stuff kept happening, because the judge did rule on the discovery issues and then stuff kept coming up. But I also understand Alessi's point. Alessi's like, oh, isn't it weird when all the text messages are gone? That's so frustrating. That's so frustrating. Our experts don't keep their texts. They're like, no, it's our habit. And he's like, you deleted 100 texts. It's like conversation, swipe, delete. Okay. However many texts are in there are gone. But again, you've got multiple Commonwealth witnesses who the day before there was a protective order got rid of their shit too. So there is so much shit in this case that is unbelievable that it's like, okay. And your expert is like, we were arranging travel. We never got to hear about the wild travel day. No, we didn't hear anything about the crazy travel day. Nothing at all. We needed all the crazy travel day. They never got back to it. But we didn't hear about it. But we also, didn't hear much about I changed cell phone carriers. Okay. You change cell phone carriers. Fine. Sure. Okay. People delete their text after 30 days. People set text to automatically delete it. Alessi really wanted to get into, isn't it because the Commonwealth was going after protected communications? He really wanted to get into that. And you know what? There was no objection. So he was just like, Sylvia said, my son teaches Carolina Crown. Carolina Crown is so good. Wasn't there horn line? Emily, is band your happy place? Wasn't there horn line just at Coachella with Carolina Crown? Who did Carolina Crown? Somebody remind me who Carolina Crown played with at Coachella before I have to scream for my teen. Because they were at Coachella. Their horn line, man. It gives you chills. I don't know. I didn't realize it was a thing that not everybody got chills listening to music. But much like a mind's eye, not everybody works the same way. In that way, chills. But Carolina Crown's horn line will give you chills, especially if you've already protected your hearing. Otherwise, you might have to protect your hearing first. And then a lot of you said Travis Scott. Oh, that my brain just went like, Travis. I completely forgot it was Travis Scott. Yes, perfect. Their horn line, just. Emily, are you still a band nerd? Once a band nerd, always a band nerd. We'll always love marching band. We'll always be excited by a drum cadence. 100% going to love it all the time. Brianna said you need to call them brief bits. We went with case briefs because it was legally adjacent to what I spent law school doing, writing up case briefs. And I can't always say that they're going to be a bit or that they're going to be brief. So I was just, we're teasing. Let's see. I heard Trixie Mattel brought down the house. I heard that too. From the stuff I've seen online, I've been like, Jazz Fest looked like fun. Stagecoach looked like fun. Coachella looked like fun. But honestly, with all of it, I really don't want to be in crowds that large. So I do appreciate seeing it from this side of a screen, but I am ready for concert season. I am. Coachella seems dusty and hot and miserable, but I do like seeing it from this side of the screen. So I'm here for it. All right, we're going to do a few more questions, and then I am rambling because I am exhausted, and it makes the ADHD way harder to rein in. Just way harder to rein in. Let's see. I'm trying to get to lots of comments. I'm just trying to find if there are any questions that we need to get to. Lo-fi Law Nerd Lounge, loving it. I definitely asked for a lo-fi vibe. Because, well, I enjoy the lo-fi vibe. I know not everybody does, but I really do. So, Sunny Days asked this way earlier in stream today, and I wanted to get back to it. EDB, does a motive need to be proven? I have two thoughts on that. Legally, no, a motive does not need to be proven. They charged the second-degree murder, not just a manslaughter, not just a vehicular DUI-related manslaughter. They charged a second degree. I think it's difficult if the Commonwealth doesn't explain that, but no, they do not need to prove a motive. I also think the Commonwealth did not do well at trying to do that the last trial. So do we think that they will get there? I'm not sure. I'm not sure if they will, or if they'll just let the jury try to draw a conclusion. We're going to have to wait and see. They talked about them fighting and their relationship not going well. I think the Commonwealth would go better or argue better to say, everyone was drinking. We will hear the voicemails. So we will get to tempers were flared at some point, and we'll see clips from interviews of Karen Read saying she was upset. But I think the main argument for the Commonwealth is everyone was drinking heavily. Yeah, people were angry. I don't think many have clear memories of what happened that night. And that's part of the problem in this case, is that they were not asked soon enough in time and separately to distinguish what they are remembering and what they've been told. And if the Commonwealth's case was Karen Read's initial statements where she left him at the waterfall, because she does not remember what happened. And if they had charged her with not knowing and intentional crimes, they could have made those arguments. It's going to be difficult when they charged her with knowing and intentional crimes to argue that she was completely blacked out and didn't know. So we will see. But no, they don't have to prove a motive. But I wonder in this case where everything is so odd if the jury will be looking for one. Nathan Eddy asked question, why are they not giving grounds with their objections in this trial, Emily? Wouldn't it make the appellate record messy without objections? Well, it would sure be easier, but the judge has ruled that the attorneys are prohibited from stating grounds for their objections. So here we are with the attorneys being prohibited from giving their grounds. It is frustrating. So let's see. I see a lot of good chat happening around the timeline from much earlier in the day. So now we've gotten backed up. The Cheerbo lady said, EDB, in your opinion, what is the relationship between Lally and Brennan? What does Brennan think of Lally? Why did Lally stay on the case? I imagine that his office told him to. Was Lally staying necessary from a prosecutorial viewpoint? I don't know the inner workings of their office, and it's been very hard for me to try to figure out what they have decided and how and why at different points. But I don't know if it is a good working relationship, a tense working relationship, a working relationship at all, or if we're like just you do this, and not much crossover. So I don't know if there is a lot of collegiality there or not. I think given everything that's happened in this case and given what has been alleged by the defense, it might have been more helpful for Brennan to have come in and taken a fresh look at this case without any input from anyone at the Norfolk DA's office. I don't know if that was done or not, but if you're bringing in a special prosecutor, you would think that it would be helpful for them to get a fresh look without anyone's input. We'll see what that was done, but I do think there's times that you can see Brennan being like, well, this wasn't done before and that wasn't done before. And for Lally, that's got to be like, this was my case. And I tried my case the way I tried my case. So I don't know. I don't know. It's not easy to have multiple lead attorneys on a case where there's a new lead attorney. And then we just see Lally kind of sitting in the corner. Though we did question witnesses on Friday. We'll cover Friday a different day. Today, we just need to just be done. Because damn. Shakia said, fresh off work, I'll rewatch when I get home. You're welcome and I'm sorry. Brennan goes ham. Hammond just goes ham at one point. Just ham. So, I imagine there's just collegialness and that's about it. I don't imagine there's a lot of closeness between Brennan and Lally, and I imagine the work got divided up the way it got divided up and everybody just kind of did their own thing. Today was spicy. I knew I was really interested in the Arc of Voir Dire. I did not think it would be that. I don't know what I thought it would be. But I was not anticipating that level of yelly. I just wasn't. I was interested to actually learn about what the expectations were between ARCCA and the defense, what the communications were. I was really interested to see that. And then we got a lot of yelling and I was like, okay. Some of these things are just not the serve that they seem. And I don't think a lot of those points hit. Some of them, I think, are going to be helpful for the prosecution to argue to the court. How long it would take, when stuff got turned over. I think those timing questions are going to be helpful in the prosecution's argument. What the court ultimately does with it, we'll see. I can't see the court keeping out ARCCA, especially as a rebuttal to the Commonwealth's new expert. So we'll see. Tomorrow, we'll be back in court, 8:15-ish? 8:15-ish, depending on what starts with court. Do you think the attorneys tomorrow, I'm going to put up a poll as we get out of here. I'm going to put up a poll and see if we start the day tomorrow with the attorneys talking about this more. Let's see. I'm just putting up yes, no. Does the day tomorrow start? Or does tomorrow start with the attorneys wanting to be heard about ARCCA? Do you think they just want to put it on the record? We'll see. We'll see. Let's see. There were a couple questions I wanted to get to real quick. Somebody asked, who do I think is doing a better job so far? This trial is just so completely different. I think the prosecution, I definitely didn't like the way Brennan was questioning today. I think I made that clear. I think the prosecution has put in their evidence in a better way for their case. By the time we get to the end of this case, I don't know how that order will have worked, but at this point, I think they have put in their evidence in a better way than in the last case. They've definitely streamlined it. So overall, from where we're at this trial versus last trial, like 5 days in, I think the prosecution is worlds better than they were at this point last trial. I think the defense has done a better job this trial with their impeachment. I think that's partly because the testimony's been more clear. So when the testimony's more clear, it's so much easier to say, you said this, now you're saying this. When the testimony is not clear, it's really muddy to try to be like, you said this, well, you kind of sort of maybe what, if anything, said this. So the questioning being clearer has made the impeachment clearer. The way that the tech testimony came in today, I think, was much more clear. The battery information from John O'Keefe's phone is incredibly interesting. The timeline is interesting. We'll see. They're not at cross-examination yet. We just got started. But again, there's a long way to go. So do I think this trial has evidence coming in more effectively than last trial? 100%. Do I think the prosecution is presenting their case better than they did last time? 100%. 100%. Just 100% better. So yeah, that's where I'm at. It's gone much more succinctly, and I'm very interested to see where they follow up with the order, because I thought after looking at who they called on Friday that we would be getting more into what happened at the waterfall and after the waterfall. So I was surprised that we went back to what was going on with O'Keefe's cell phone, but it's very clear that Brennan has a pretty meticulous order that he is going through in the way that he is presenting this case. And that it's not happenstance. It's not just who arrived first and what happened next. This is a very structured and organized prosecution. And it is coming in a very different way than last time. So it's going to, I think, be easier for the jury to follow. It also makes it easier when the defense makes points that those are highlighted, because you're not just slogging through a word salad. So I think it really makes it more clear to the jury. I'm very interested to see the new experts. I'm curious which civilians are going to get called and when. So we'll see what happens tomorrow. We're going to finish up the cell phone information from Mr. Whiffin over at Cellebrite. I'm interested to see when the defense brings back around the timeline that they were nailing down today, because there are specific points in time that the defense was like, put a pin in this, put a pin in this. So this time this was happening, and they were locking down specific points in time. They are going to use the points in time from that PowerPoint with information from Karen Reed's phone. When they will do that is at the mercy of the prosecution and when the prosecution brings in those witnesses. But I think that having those points be so clear will make it easier for both sides to argue the timeline. But the phone timelines are the phone timelines. And so when we start bringing up John's phone's more clear timeline vis-a-vis Karen's phone's more clear timeline, I'm interested to see what matches up and what doesn't. And I'm interested to see the new information from Karen Reed's car, because there's new car information. So it's a whole new trial. And new opportunities for people to do some good lawyering, and then to do some shit that, oh my God, that scared me. And then to do some shit that's just unhinged. It's a turkey. Look, they look like dinosaurs, man. The wild turkeys out yonder are fucking huge. And I just see like an eyeball walking by the bottom of my window, and it's just like on a it looks like a little brontosaurus. It's just turkey. So that's the end of the day. It's just time to go. The birds are birding. I need to go for a walk. I don't even know what happened today. Chat. My head hurts from like furrowing my brows so hard. For those of you that are in the Lawnard Lounge, I'm going to take a picture of the turkey. I will post it. We will be back tomorrow with Ian Whiffin. When we have a shorter day, we will bring in day 4. It's not that much time of the time we missed, and we will bring it back in. I did a summary, my summary of day 4, which was these are the witnesses that were called and they went on jury view, will be in the case brief. We will scoot it in when we have time, but this week's going to be busy. So we will find time for it. Do not worry. It was foundational testimony. Today was the spice we didn't want to miss. And then this week is, well, Friday's going to be Emily, are you just telling us in advance that you're going to be like this all week? Yeah, Metallica's this week. So Friday is just, we'll see how it goes. For everyone that's like, girl, will you stop interrupting the testimony? Friday's your day. Friday's your day. Emily's going to sit here like this. That's what Friday's going to look like. So buckle up. It's going to be a week. Lawnards, you're the best. I will see you tomorrow in court. May tomorrow bring some clarity, some answers, and if nothing else, at least a spicy day in court, because the spice isn't going to back down. It's not going away from here, is it? I don't think so either. Lawnards, I will see you tomorrow. It's time to roll. I'll see you soon. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Lawnard app at lawnardapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Lawnard app. Thank you for being here, and thank you for being a Lawnard.